Good morning. I'm eating Peeps for breakfast. Happy almost Easter. Good morning, everybody. A friend of mine says you have to eat them butt first so they can see themselves being eaten. Good morning, Judy, Tricia, Marty, Jennifer. How are all my friends this morning? Hi, my name's Debbie. Welcome to my channel. Y'all, I watched the rest of the documentary. Remember I told you that I had thought I'd watched it all, but forgot that I hadn't finished it, and there was I had like 3 more episodes to go. It wasn't just Deaver. A bunch of people lied. A bunch of people. Hey, Paul. I bet you do. I bet you do. I bet Stephanie has one just like it too. I've always thought that he did it. And I still think he did it, but I have more questions than I did before. Wow, Tricia. Yeah, exactly. Hey, Wiggles. Yeah, Jim did it. Because the blowpoke that they kept saying was a murder weapon that they couldn't find, that had magically disappeared, and they found it in the garage with cobwebs on it like a year later. The police found it that night. The night she died. They found it. And they took it outside and photographed it that night. And then they were the ones that put it back in the garage where it was found a year later. The people that found it was Eric Campen, and I think his name was it Dan George? 2 cops we've already seen testify. They didn't say anything about a blowpoke. And the state is still insisting the weapon was a blowpoke when they know they found the blowpoke and there was no evidence on it, and they didn't submit it into evidence. They put it back in the garage, which wasn't where they found it. So now I'm like, what the heck? Did they manufacture the evidence or think they manufactured the evidence to try to frame him? Like, I still kind of think he did it. I mean, just by the way he was acting, it was like hinky. I mean, like, I don't know what to think now. And the medical, not Dr. Snell that we already saw, that's the forensic pathologist, but I forgot her name. I guess the one that actually performed the autopsy, she wanted to make the cause of death blood loss, not blunt force trauma. But the cops convinced her to make cause of death blunt force trauma. So she changed it. So his whole case was screwed up. That man 100% deserved another trial. And I'm not saying that he's innocent. I'm just saying if anybody deserved another trial, that man 100% deserved another trial. That trial was so screwed up. And the reason he took the Alford plea was because he just didn't want to go through another trial. And the Alford plea was a guilty plea to voluntary manslaughter. And because he served 8 years in prison because of that screwed up trial and he was found guilty, he'd already served the time for voluntary manslaughter. So he was allowed to go free. And Judge Hudson said if there had been a second trial, because he proceeded over the plea agreement and everything, he would have been over a second trial too. And he said if he had to do it again, he wouldn't have allowed in. I agree with this. He wouldn't have allowed in the evidence of Liz, what's her name? The girl's biological mother that fell down the stairs. She had a brain aneurysm and died, but she was at the top of the stairs when she did, so she fell down the stairs and she was found dead at the bottom of the stairs. And everybody keeps saying he must have killed her too because Kathleen died at the bottom of the stairs. So he must have killed both of them. So the judge said he wouldn't allow that evidence in a second trial, and he wouldn't allow the bisexual stuff in a second trial. I disagree with that because I think that was the motive. But he said he wouldn't allow those two things in a second trial. And the Judge Hudson, said that that's reasonable doubt. So even the judge thinks that he might be innocent. I'm not saying yes or no. I don't know. Because that trial was so screwed up and so many people lied. My mind is blown right now. Because I've watched so many documentaries and Datelines in 2020 and 48 Hours, and because this whole case, the actual case itself lasted like 15 years. And then all the stuff I've watched over all this time. And now it's like, how many years later now? Another 10 years on top of that. Because the Alford plea was in 2017. And now it's 2026. So all these years, and now I don't know. Like, my mind is blown. I didn't know all these people lied at his trial. So now I don't know what to think. I'm just like, I was watching it just like the the whole time Rudolph was talking to the judge in the Alford plea, I was just like, so I didn't even realize all the lies. I knew about Deaver. I thought that was the only person that lied. And then at the Alford plea, Rudolph's talking about all these people that lied. And I was just like, oh my. But some of the lies he only found out like a week before the Alford plea, too. I was just flabbergasted, you guys. It was crazy. And I need Nancy to be here because there was something else in there was a hearing to dismiss the case before the Alford plea, and he lost that hearing to dismiss the case. And one of the things that they used as a reason to dismiss the case, Nancy hit the nail on the head, and I need her to be here for me to tell you guys about that. So I gotta wait till Nancy gets here. If she doesn't show up, I'll tell you guys anyways, but I'm gonna wait a while. Wiggles, I'm allergic to nature. I am allergic to grass, every tree I've ever been tested for. 98% of the population is allergic to dust mites. I am not. But I'm allergic to every tree, grass, bush. I can't go outside when my husband mows the lawn or my face will blow up. So yeah, nature doesn't like me either. Okay, so now oh wait, I forgot. How do I always forget Judy's trivia? When you go down a rabbit hole and stay up all night searching. Did you ever figure out why the guy was released from prison? Tyrone LaCour has been a suspect of multiple crimes most of his adult life. Okay, so this is the guy that killed the guy that died in the trash can? In addition to Dennis Rowe, he was suspected in the red rum of Eric Pennebaker, his roommate at the time. He was, oh my God. He was set on fire, and LaCour told authorities that it was suicide. Who sets themselves on fire to commit suicide? Person County Sheriff's Office detectives later found one of Pennebaker's checks that had been forged in cash after his death. Unfortunately, Tyrone LaCour continued his life of crime. In June 2025, LaCour was charged with attacking a homeless man with a machete. Both men lived in a homeless encampment in Hillsborough, North Carolina. Good Lord. Nancy! Yay! Perfect timing. I was just talking about you. Okay. So, the hearing. Hey, Marty. The hearing that they had to dismiss the case was because. Do you remember when we were talking about how they were touching the evidence without gloves? Nancy was like, why doesn't he have gloves on? And I was like, oh, he does have gloves on. And it was a cop that had gloves. The attorney did not. The attorney didn't have gloves on. And Nancy was like, why isn't he wearing gloves? And so we were speculating. We were like, well, maybe because they're not going to need to use the evidence again. Or, well, he's just putting it back in the bag and writing down what it is or whatever, and we were trying to figure out why the attorneys wouldn't be wearing gloves. So when he got the new trial and they were looking at the evidence, the private detective that was working for the defense, because Rudolph was not going to defend him in the second trial. He said it was just the first trial was 4 months long and he was just drained emotionally and he just couldn't do it again. He couldn't go through another long trial like that again. And he recommended a very good lawyer for the retrial. And Michael Peterson was not happy about it, but he said, okay. The day before the hearing to dismiss, because they were gonna motion to dismiss the charges, the day before, that attorney that Rudolph referred him to had a stroke. So his second chair had to take over. And I guess they got a continuance. And the private detective for those attorneys went to the evidence room and took pictures of all the evidence. It had just been thrown in boxes. The package hadn't been sealed. There were evidence touching other evidence. It was a mess. So they showed in the hearing, they showed those pictures, and they showed video from the trial. And believe it or not, Nancy, they showed that exact part where you asked, why is he not wearing gloves? And I was like, oh, I can't wait to tell Nancy this tomorrow. She hit the nail on the head. So they showed that exact part, and they said the evidence has been contaminated. It was touched with ungloved hands. It was just thrown back in boxes. They weren't sealed back up. Yeah, you did. Yeah, you did. Because we were all like, well, I guess they're not going to use it again, or I guess they don't need to keep it, uncontaminated or whatever. We were trying to figure out, like, a rationale for why they didn't need to use gloves, and you called it. They should have used gloves. I was like, boom, Nancy called it. And then the the district attorney showed a clip of Rudolph holding up. He held up Michael Peterson's shorts, and then he folded them and he put them on the witness stand, and then put his hands on top of them and flattened them out. And so his DNA was all over Michael Peterson's shorts. And so the state was showing that it wasn't just the state that handled them, it was the defense that handled them too. And they were also upset because DNA testing had not been done on Kathleen Peterson's clothes. And I said, well, they didn't need to do DNA testing because there's not a third party culprit. They think that he did it to her in their own home. Why would they need a DNA test? Well, apparently they said his attorney, Michael Peterson's attorney, said, the second one, said that it would have strengthened the state's case if they had tested her clothing, because it would have just shown that it had Michael's DNA and her DNA on it. It would have strengthened the state's case. If it had shown an unknown DNA on it, then it would have weakened their case and helped Michael Peterson's case. But they didn't test it at all. And because the evidence was mishandled, now they couldn't test it. So the case needed to be dismissed, plus with all the other stuff that they knew at the time. Because apparently Frida Black had gotten a note from the medical examiner about the cops making her, or not making her, but encouraging her to change the cause of death. So it was a mess. It was an absolute mess of a trial. And now, like, just my mind is blown now, because, like, now I don't know if he was innocent or not. For years I have been, man killed his wife and killed the woman. And, the owl theory, as ridiculous as it is, the only thing that makes that not plausible, because when she was going into the house, because the lacerations on the back of her head was like V-shaped with another one coming down. Like a talon. And there were several of them, and they kind of overlapped. So if a barred owl, I don't know if it's barred or barred, I don't know. Those owls are huge. Like, they can pick up a small dog. So and they say that they'll just attack humans for no reason. So if she was going into the house and got dive bombed by an owl enough, I mean, they said the flaps of skin, like, was coming off of her scalp. and your scalp bleeds, I'm just saying. I'm just speculating on the theories here, Marty. If her scalp bled enough that she lost enough blood to make her woozy and she passed out. But the only thing, like the Al got her as she was going in the house, and then she was able to walk in and then pass out. But the only thing, there would have been a trail from the door to the stairs, and she wouldn't have landed the way she did, sitting on her butt. She would have landed face down. So that doesn't make sense either. Right now, I'm just like, I have no idea what the hell happened. It's bizarre. I have no Nancy. Okay, so where we are today is there's going to be Spike, don't even start with me. What is wrong with my dog? Why does he bark at nothing all the time? He used to have this cute little squeak that everybody loved, and now he just wants to bark constantly. So now we are at the hearing. It's going to last like an hour, where they're going to argue about whether or not this male escort should testify. And it is yeah, Spike is telling us his 2 cents. So this is going to be a hearing. Spike, I'm talking. So this is going to be a hearing about whether or not this guy is allowed to testify, because his lawyer doesn't want him to testify. And then we're going to hear from the male escort.
The application in writing that Mr. Harden has made for immunity, I would like to be sure if the court, in light of this, grants my client immunity, that the court's order is very, very clear that the immunity granted will be on a statewide basis. I have some concern because the application itself identifies 3 counties, they being Durham, Wake, and Cumberland. And the application also has attached to it purported letter immunity from the district attorneys of those 3 counties, although it's a conditional grant, which I think is, in essence, means it's no grant at all. But it's not the letters that I'm concerned about or want to rely on. What I'm relying on is GS 15A-1051 and GS 15A-1052. And 1051A says, a witness who asserts his privilege against self-incrimination in a hearing or proceeding in court may be ordered to testify or produce other information as provided in this article. It goes on to say that no testimony or other information so compelled, or any information directly or indirectly derived from the testimony or other information, may be used against the witness in a criminal case, except a prosecution for perjury or contempt arising from a failure to comply with an order of the court, which I paraphrased, in fact, this morning in my arguments to you. So that statute contemplates that if the court grants immunity to the witness and orders him to testify, that this is going to be a grant of immunity that covers any state prosecution anywhere within the state of North Carolina, not just the 3 counties that where the district attorneys wrote letters. And if the order does not give my client statewide immunity, Your Honor, then I would say he hasn't been given immunity. And unless he's given statewide immunity, he will invoke his rights not to testify with all due respect. However, if he is granted statewide immunity, he will testify and he will answer questions put to him so long as he receives an order of the court granting him statewide immunity that directs him to do so. So that is the decision, if Your Honor pleases, that he has made in the event the court enters such an order.
Well, Mr. Harden will have to speak for himself as to why he has listed particular counties of prosecution. I mean, I can speak as to why I think he did that. I think he did that because it's not probable that the witness could be prosecuted in other counties where he was not present or the computers were not present, or he probably doesn't believe there's a nexus so that the state could prosecute. I mean, I don't think he thinks he would be prosecuted in any county. But I would guess that he took the steps to try to assure the witness as to the most probable places and districts that he could be prosecuted in. But can you clear that up for us just right now? You might have to be heard later on, but he's worried about the parameters of the counties and why it's not 100 counties that he can't be prosecuted in it, as opposed to your county, Cumberland County, and Wake.
This is the attorney for the male escort. He's trying to he'll only let his witness testify if he gets immunity.
Your Honor, I selected those counties based upon what the witness told me constituted his activity in those locations. He did not give me any information whatsoever that there was any activity outside of those counties. And because of that discussion and inquiry, I didn't dig any deeper or try to get immunity from every single district attorney in the state of North Carolina. Although I think the court could probably grant it, I think you have to have a predicate to base the grant on, and the predicate is activity as indicated by this witness in the 3 counties that are specified in the application. I have a copy of it. I haven't previously filed it, and I'd like to do that at this time with the court.
Well, I think there's also some case law in North Carolina that suggests that some counties that may not be in the actual application would be prevented from state prosecution.
Judge, my interpretation of the law is this. He doesn't need to get permission from 100 district attorneys or 99 other than himself. He doesn't even need to get it from the DAs in Wake and Cumberland County. If he's going to apply under 15A, 1051, and 1052, which he's doing in his written application, then if the court grants that application, as I read the law, the court has to give him statewide immunity, and which is what I'm asking the court to do if you grant him immunity.
I agree that would be the logical intent. The logical and the legal intent. He could list 2 counties, but I think it's 100 counties.
Just so long as Your Honor indicates in the order it's statewide. I don't care what counties, if any, he lists in his application. In other words, I don't think his application legally can narrow the grant. I think if the court grants immunity, it has to grant immunity.
When a district attorney gives someone immunity, it's not statewide. It's just for that county. I thought it was. Well, if they commit a crime that they need immunity from, it's just in that county where the trial is, though, isn't it? Like, because he wasn't on active duty, so it has nothing to do with federal. And how many, like, did he commit this crime in other counties too? Because if he's a male escort, well, I guess it would depend if he was in call or out call. If he's out call and he goes to them, well, if he's out call, which means he goes to them, then he's technically committing crimes in other counties. But if he's getting immunity only for this crime, but then he gets up there on the stand and talks about other crimes, because he does get up there and talk about his other clients. Because I saw a little clip in the documentary where he actually talks about he doesn't name them, but he talks about how some of his clients are professionals, like lawyers and judges. I don't know. Yeah, I would think it should just be for the crime that they're talking about in the trial and not like statewide immunity. Yeah, David, I think you're right. Yeah. Judy has a list of rabbit holes.
Immunity for all 100 counties.
Right. I actually, and after Mr. Harden has spoken, I don't think he was trying to limit it to 2 counties. I think he was being specific as to 2 counties, so your client would understand.
3 counties now.
3 counties. Those would be counties where, if they wanted to prosecute, they would have a legal nexus. I think Mr. Harden understands that, Buncombe County, there's no probability that the district attorney in Buncombe County is going to prosecute your client. There's no possibility. I would say possibility instead of probability. There's no possibility that the DA in Perquimans County is going to prosecute your client for something that happens out of some proposed testimony.
Except, the problem is the internet is ubiquitous. It's really literally all over the world. And if there's any contact at all made or offer made over the internet that someone in Perquimans County sees, potentially the DA there could prosecute. Now, I concede it would be highly unlikely that he would do so, but I would not accept the court's statement that there's no possibility.
Well,
there's little possibility, but I wouldn't say no. And I'm trying to get my client.
If this has to do with the court's order and your interpretation of it, I will put that in order.
Thank you, Judge. That's what I'm asking. I want to be sure that Your Honor gives him as much protection from possible future prosecution as Your Honor can. And so if you put that in there, I think that will take care, Judge, of that problem. The only other thing I would really have to say about this is that just to be sure the court did not misunderstand my argument this morning about the public interest. I wasn't arguing that the emails and that type of thing are irrelevant the way the defendant argued it yesterday. That's not my argument at all. My argument simply is that and both sides know this, because both sides have briefed him. They know if he testifies, he's going to say he never had any telephone or personal contact whatsoever with Michael Peterson. He's never met the man at any time. That their only contact were these emails, which are already in evidence. And he cannot, beyond saying those are emails I sent or received, which the emails on the face of it show, he cannot add anything to the prosecution case or to the defense case in this matter. It's not that it's irrelevant, it's just he can't add anything beyond what the jury already has. That was, and perhaps the court did understand it, but I didn't want you to make a ruling against me misapprehending an argument I made.
Oh, I didn't misunderstand that.
All right, Judge. Now, the next, there are two issues that flow from that, since it appears the court is going to enter an order which my client will obey and testify. This is Friday. The jury has been sent home. Here's the problem my client has. He really needs to testify first thing Monday morning, because he has a final exam that he had scheduled for this afternoon that he got the professor to change to Monday afternoon. He's already changed that exam once. It is my information that the court has announced, I didn't hear it, but Ms. Black filled me in, that the court cannot sit on Tuesday. When my client would be available. My client leaves on a trip he has had planned for nearly a year with advanced cheap rate tickets and all of that on August the 13th, which is Wednesday, and is not due back until the night of the 18th. I asked the prosecuting counsel about the possibility of deferring his testimony till August the 19th, and they indicated they weren't willing to do that because they had planned other witnesses and evidence for that day. So I'm wondering if we can't be sure we can get his testimony in on Monday morning when court convenes. The second issue, Judge, is the issue of the protective order that we have moved for. I note again, neither the counsel for the state nor counsel for the defense opposed the granting of this order. And indeed, following in my footsteps, the application for the grant of immunity that Mr. Hardin has made pursuant to GS 15A-1051 and 1052 has been filed under seal, again, to protect my client's name and identity. And so we would ask the court to enter a protective order. I don't really have a big argument to go about it chapter and verse. What I keep the language the court brought to our attention as being incorrect, and we believe that the language, or we hope it is acceptable. But if it's not, we can go back to the drawing board a third time over the weekend and get this in a shape.
The parties here may not have a problem, but media representatives do. And Mr. Bussian is one of them. There may be more. But let's talk about that in a minute. When, Mr. Harden, do you intend to call the witness?
No, we intended to call him on Monday.
When? Do you
Well, we can arrange, we've got another witness ahead of him that we can reschedule and call the witness on Monday morning first thing. We can do that.
Does that, I don't know what time he's talking about, does that?
Well, it doesn't court convene at 9:30 Monday, am I right or wrong?
10 o'clock.
10
o'clock.
10 o'clock on Monday. Well, it'll be pushing it, I guess, to get through so he can be at the exam at 1, but it looks like, Judge, unless we can defer him to some time, after the week of the 19th, that's really the time he has to do it.
You mean the exam? To do what?
To testify.
No. You tell your instructor, I have been subpoenaed to be a witness at a trial. I don't know when they're going to be done with me. I can sit for the exam when they're done with me. They're going to take me first thing in the morning. I will come straight to class when they're done. You don't have to sit for an exam when everybody else does. If you've got extenuating circumstances, the professor can work around that. This is ridiculous.
I mean, without messing up his final exam and the.
Okay, I'm saying, do we agree or we disagree? Which one? We agree he's going to be here?
Apparently, we agree he'll be here at 10 o'clock.
All right. Okay, let's talk about any proposed protective order. What is it you want, Mr. Laughlin?
Judge, may I hand up
Yes, sir.
copy of it?
Can you give him a copy or let him read it?
They already have a copy, Your Honor.
I'm not sure he has one.
I'm sorry.
I don't have a copy.
No, I'm
No, I wasn't talking
sorry.
about Mr. Hard. I was talking about
The
Mr.
Herald Sun does not have a copy. Your Honor, I'll be glad to hand this to them through Ms. Black. She can pass it over because I can't,
Not yet.
my arm isn't that long.
Well, I take it Mr. Bussey wants to look at it, but can you summarize for us, Mr. Laughlin, what you want?
Judge, essentially what we want in summary is that number one, the witness not be required to give his name in open court other than the name Brad. That when he does so, the court instruct the jury that the court is following that procedure in order to protect the witness from harassment or undue embarrassment. The second thing essentially that we want, protection of his actual name, is that any documents in the case, including the subpoena that was issued to the witness, be filed under seal. There aren't many of those documents. The only ones that I'm aware of, and counsel for the parties can correct me if they have any others, would be the affidavit I filed this morning about the witness intending to invoke the Fifth Amendment, the application for grant of immunity under seal that Mr. Harden filed just a few minutes ago, the subpoena, and I think that those are the only documents that identify him, with the exception of one photographic exhibit, which it's my understanding when he testifies during the direct examination, Ms. Black is going to ask him about this photograph in which he appears. But I would ask that, not that it not be shown to the juror. but that it be, after it's shown to the jury, that particular photograph filed under seal. I believe that's all the papers that would have to be filed under seal. And insofar as the press and the public.
Fast forward to 2026 and they want to be called sex workers and want to know that everyone to know that there's nothing wrong with it. If you're ashamed of your job, don't do it.
Right to know, quote unquote, insofar as the application for grant of immunity under seal, I would propose, Judge, reading, minus my client's name, reading that into the record in open court. So the media and everybody will know what Mr. Hardin said when he applied to the court for immunity, and what he sets forth as his reasons for applying for immunity and asking the court to grant the witness immunity. So the public is not going to be, and the media either, will not be deprived of the reasoning and the rationale as to why Mr. Hardin is applying for a grant of immunity. Next, Judge, we would ask that counsel for either side in questioning the witness, not ask him any questions that would reveal his identity to the public, such as his name, address, that type of thing. Mm-hmm. Third, we would, I guess it's beyond three, whatever we're up to, we would ask that he be sworn in without giving his legal name, but with the court instructing the jury that the court has ordered the movement be referred to by the state and by defense counsel as Brad. We would ask that all media in the courtroom and in the courthouse be ordered not to take his picture or depict his likeness. And in connection with that, it's my understanding with respect to the TV, mechanically they can digitalize his facial features so that when he's testifying, or in the courtroom for that matter, people can see there's a man on the stand, but they will not be able to recognize his facial features, although they'll be able to hear his answers to the questions put to him by counsel. So,
why would I be doing that?
I'm sorry, Judge.
Why would I be doing that?
So, because otherwise, this is nationwide coverage.
Yes.
People may recognize him, and this will subject him to embarrassment and potential harassment.
It will? I mean, where do you get that information from? That it will?
That it will? Well,
yeah, that it will.
I'm sorry.
That it will, as opposed to it might, it could.
No, my client will be embarrassed.
Well, that may be. I don't know that I necessarily have to give somebody a protective order because they're embarrassed. But
well,
I mean, there are a lot of embarrassing cases that happen in court that the court doesn't shield the witness.
I appreciate that, Judge, but my client is not a defendant in this case. And he's not accused of engaging in any criminal activities beyond the items that Mr. Hardin has discussed.
And he's not a minor, which I can understand shielding the face of a minor in a child abuse case or something of that nature. He's not an alleged sexual victim, which I have seen that done in those kinds of cases. As a matter of fact, isn't every act that he's going to testify to a consensual act?
He's not going to testify to any acts, Judge.
I'm not talking about sexual. I'm not talking about sexual act. I'm talking about any act of communication. I understand what you say his testimony is going to be. I'm not talking about sexual act.
Okay.
Here.
I'm sorry. I thought you were.
Any act of communication is purely consensual.
That's correct. That's correct. But
What is it that he would be so embarrassed about at this point? Is what I'm trying to figure out.
well, Judge, this aspect of the case has injected, I believe, quite a bit of salaciousness into the trial, and the media is really in a feeding
Mr. Lawson, you've been doing this for a long time. A criminal defense lawyer for a long time. A civil lawyer for a long time. Salaciousness? I mean, you've handled all kind of cases, as has the court. Domestic cases, adultery cases. You know, in North Carolina, you know, we don't have that. I mean, we have the heart bomb laws, unlike just about every state other than one or two out of the 50. We try these cases all the time. We don't in the civil case shield the partners who are having a bad marriage, that cheated on each other or whatever. Down in district court, we don't shield that. There's some very embarrassing things that happen in those kind of cases. I'm trying to see what the...
And it's court TV in the courtroom when that takes place? No, Judge.
Okay, so that's what this is about. This is about court TV.
Well, it's not just court TV. It's about the extremely and unusually high degree of media attention that is focused on this particular case and this particular trial. And my client is offering evidence on a very tangential aspect of this case. I mean, he doesn't know any. He's not going to give the state any evidence tending to establish even one single essential element of the offense.
Well, then he's going to testify about some other things that he's embarrassed about.
Well, right. He's going to testify. About things that he is embarrassed to have his likeness go all the way across the nation, have relatives and people like that see it in the news media. That's what it amounts to.
You know, I think your argument makes a lot more sense if he's a minor, if he's a victim. I don't think he falls into any of those categories.
But he doesn't have to, Judge.
I know he doesn't have to, but on the other side of that is he's not entitled to that kind of protection from the court either. He's not entitled to it.
He doesn't have a right to it. It's the court's discretion. I concede that, but under the rule of evidence I've cited, the court can engage him in certain controls to protect the witness. He's
taking care of something that should be, and I know is very important to him. That's why we've been talking about it first, and that's a possibility of being prosecuted in the state courts, and that's not going to happen. That's a big concession to this young man.
It's not a concession, Judge. That is his right. In other words, it's either or.
No, it's a concession. The state doesn't have to offer him immunity,
and then he wouldn't testify.
It's not his. He has no right to immunity. The state doesn't have to offer him.
But he does have a
immunity.
Right not to testify if they don't offer him immunity.
Yeah, and he can still try that.
He has a right not to if they don't offer him sufficient immunity.
The state can offer him immunity at that time. Well, my point is, he doesn't have a right to immunity.
He doesn't have a right to immunity, but he has a right to invoke the privilege against self-incrimination.
And he can do that.
And he's done that through me.
Well, he hasn't done it yet. He says he could have done it.
He will do it, but he'll have to in order for Your Honor's immunity order to be valid. He'll have to, and then you communicate the order to him. That procedure is set out in the statute.
And let's talk about that procedure, because I got a little bit of trouble with that procedure. Okay, he has a right to invoke the Fifth Amendment.
Yes.
And in effect, make the state, if they want him to be a witness in this case, offer him immunity.
Exactly. That's what I was trying to say.
Well, and I understand that's what you're trying to say, but what I'm trying to say is, if I order him to testify, and what if he chooses not to,
But I've told the court, if your honor orders him to testify with a grant of statewide immunity, which your honor's indicated that's what you're going to do, then he will testify.
Yeah, no, I understand.
I've discussed that with him. He's made the choice, and that is his choice.
Yes, but what I'm saying is, I don't have to make a deal with him in order for him to get up on the witness stand. See, he would have to get up on the witness stand, put his hand on that Bible, and tell me he's invoking his Fifth Amendment right to. Okay, unless I give him protection to violate the court's order, he couldn't get that. In order for him to get on this witness stand and testify and tell me he wants to evoke his First Amendment right without, as you say, 77 million people seeing him, he wants the court to shield his face. And for him to use, see, I don't have to make those kind of deals.
I'm not asking you to make a deal.
He can have his Fifth Amendment right to do whatever he wants to do, but I don't have to give him that protection. There's nothing that requires me to give him that protection. I'm trying to figure out why it is I should.
Now, why to give him a protective order, or why to give him a protection when if he tests?
Protective order. I'm not worried about him exercising his Fifth Amendment right. I'm not worried about that.
Well, it's not. This has never been put in the context of a deal, Judge. I don't think it's a deal. It's put in the context.
Well, I guess I'm trying to make sure he understands that he agrees to testify. That's between him and the state.
That's right. I mean,
it's not me. I don't care whether he testifies or not. And so I'm thinking that he needs to explain to me why I need to balance the First Amendment with his Fifth Amendment. And the First Amendment right I'm not talking about is his, it's the press's and the public's. Because he's embarrassed, it's just not good enough to me. It's not sounding good enough.
Well, the press,
because he might be subject to harassment, to me right now is not good enough. This is something that if he did it, unless he says something different when he testifies, unless you tell me, this is something that he agreed to do. This is a consensual act. He wasn't forced to do anything, like a minor might have been in that position, or some other protected category. What's the protected category he is other than a person who's embarrassed? To me, that's not a protected category.
And subject to being harassed.
And subject to being harassed. That's not a protected category. Not subject to be.
But it
likely to be harassed. That might be different.
Well, he is likely to be harassed.
I'm asking you why.
He's already received numerous calls from the press asking if he's the witness and how he spells his name and this type of stuff. So the press is already.
Those are things a reasonable person could argue he brought upon himself. I'm not saying that he did. I'm saying a reasonable person could look at that and say, why does that category protect it? Had he not done those things, obviously he wouldn't even be a witness in this case. But he chose to do those things. I don't.
He may have chosen to do certain things, Judge, but he didn't choose to have the entire world know about it through the compulsory process of the court.
Right.
He's in this situation.
And what I say to that is, why is it the court's responsibility to make that right for him, to protect him? Why is that the court's responsibility?
The court has the discretion to protect any witness, Judge, who is subject to being harassed.
I understand I can do it.
So the rule doesn't talk in terms of protected categories.
I know I can do it.
And the court should do it because of his young. He's not a minor, but he is extremely young. Number one. Number two, he's a college student who has a grade point average of nearly 4 and wants to pursue attending professional graduate school. And if his identity in connection with this gets out, then that harms him. And finally, if Your Honor pleases, and it's a matter I don't think I've addressed in open court, but as I've suggested in a conference among counsel for both sides in your honor, there's also a problem he has with the student code of conduct at the school he attends.
Okay,
And the immunity order is not going to protect him.
Right. What can I do about that?
You can grant the protective order as opposed to the immunity order. Now that won't necessarily per se protect him from a student prosecution, but it will make it difficult, if not impossible, for them to proceed because they won't be able to put a name and a face on it when he incriminates himself.
He had a lawyer from the university that represented him before you did.
Understand, Judge?
How is the university not going to know?
Well, because I mean, people laugh. The university doesn't know because the university affords that attorney free of charge that students with legal problems can consult. But in consulting that attorney has to keep the consultation inviolate, has the same ethical obligations that I do, or Mr. Hardin does, or any lawyer does. If a person comes to them in confidence and says, look, lawyer, I have a problem. Here is my problem.
I understand that.
So the university can't find out from her.
I understand that, but there's 16, 17,000 people over there at North Carolina State, if not more. Nobody at North Carolina State watches court TV so that you can block out his face. And you wanted to change his voice, although you didn't mention that today.
Well, I
recognize his voice. That. Out of all those people, they're not going to be able to look at him and figure it out.
They're not.
That's what I'm talking about. I'm not talking about his lawyer is going to tell the university.
Judge, that's obviously somewhat of a risk. I'm trying to minimize the risk. I don't believe he has a distinctive voice. There are 16 or 17,000 people.
Well, they're more than that, but
maybe more than that.
Yeah.
There's lots. There's a huge number. And that would be like, prosecuting a needle in a haystack, unless if his likeness is divulged to the world, his name is divulged to the world, then there it is. It's handed to the student prosecutor.
What about other people who abuse his services?
First, it was his relatives will see, and now it's the college will see.
I mean, can't they find out who he is, turn him in, give the press information about his website and all those things? Can't they figure that out? I'm just trying to figure out what kind of protection am I giving him?
Judge, anybody that uses his services, sure, they could turn him in, but they're not going to be likely to if they've used his services.
I mean, it's like the woman out there in Eagle, Colorado. Now, everybody in Eagle, Colorado is a friend of hers and giving people information about her. I mean, how you stop that?
Well, the courts tried to stop that out there.
Yeah, it ain't working either.
Well, if it doesn't work, it doesn't work, Judge. But my point
is, that's what I'm concerned with. If I give him protection and it doesn't work, I mean, think about all the other cases that we try here in Durham that I got to give protection from the press with people on other than in that specialized category. That's what I'm worried about, setting that kind of precedent.
But Judge, you see, first of all, this trial is unique in Durham County history. This trial has unprecedented worldwide.
If he gives someone immunity because they're going to be embarrassed, that's going to set a precedent that you're going to be able, not immunity, protection. If he gives him protection because he's going to be embarrassed, that's going to set a precedent. And then anybody can say, I will be embarrassed if I testify. And then that's going to be a protected category. And then anybody can get their face blurred because they'll be embarrassed to testify. You can't do that. Because pretty much everybody's embarrassed when they go up there to testify, especially if it's televised.
Media attention And we haven't had cases like that before and are not likely to have cases like that again.
Right. So what I'm granting your client is something that'll probably never happen again in Durham, North Carolina. He will have that. He will have that. He will have that special status of being a special person that we'll never see again. Is that what you're saying?
I'm saying that we are unlikely to have another witness.
Yeah, we'll see. We'll see as soon as this case opens. In the next case I try, we'll see the defense counsel say the same thing, Mr. Laughlin. Mr. Bussing, did you want to be heard about some issue here?
At your convenience, Your Honor.
I'm ready if Mr. Laughlin is finished. Are you finished?
If you finish with the question, Judge.
Yes, sir. Yes, sir.
Your Honor, briefly, I think a lot's been has already been said that provides the answer to this question, that this protective order ought not to be entered. Principally because Mr. Laughlin's client is no differently positioned than any other witness in any other case. I mean, if you wanted to make the argument just about attending an institution of higher learning, there are countless criminal charges placed against students, and other students are called as witnesses to those things, and taken to its logical conclusion, they'd all be.
He does make a valid point about the press attention and I don't know what's going on worldwide, but it certainly reaches a lot of people.
And I guess our industry response to that would be this case has unparalleled public importance, and that ought not to determine whether somebody gets an unprecedented protective order like this one that's been proposed versus all the other cases that come in front of Your Honor and in front of this courthouse every day. But the bottom line is there's no right to testify privately, let alone a right to have exhibits that are offered to the court that go into evidence sealed. And if there's a constitutional right to see anything, it is what is offered in this open courtroom for a jury to see, for the litigants to see, for their counsel to see. And we've got two requests going here. One is, as I understand it, a request to seal the subpoena to Mr. Laughlin's client, the supporting affidavit, and now to seal a proposed trial exhibit. The burden for making the constitutionally required showing to seal any of those things is on Mr. Laughlin, and there's been no showing of any kind other than testimony from a lawyer, Mr. Laughlin himself. And the second is that there's been an application made for sealing, as I understand it, by the state of North Carolina for Mr. Hardin to seal the application for a grant of immunity. And the burden's on the state in that instance to make the constitutionally required showing to seal that material. Absent that, as we've already gone through in this case weeks ago, there's no basis for Your Honor to seal any of this material.
Actually, it was months ago.
That's correct. And as for the proposed restrictions on photographing or broadcasting, Your Honor, the same burden rests upon the party that seeks the restrictions, that they have to offer a compelling reason, certainly beyond embarrassment or some vague notion of privacy that one might have for appearing as a witness in this courtroom. That kind of reason has never supported restrictions of this kind. There might be if there was some testimony that physical or emotional harm was going to befall somebody, or as Your Honor suggests, perhaps in the case of a minor. But even in the cases of minors, in a fabled case involving the Boston newspaper, where a minor had been a victim of a sexual assault crime, that was found not to be sufficiently important to override the public's right to know and to be present in the courtroom and to observe what was going on and who was making the allegations. And I'm not here to debate all the possible ways that issue might play itself out. But just to say that nobody's met a burden here that would warrant the entry of this order, Your Honor, and we would ask that the applications for sealing and the request for restrictions on photographing and broadcasting sealing of the trial exhibit be denied.
Judge, if I
Yes,
can
sir.
respond, I'll try to be brief. There is no First Amendment right for them to broadcast any witness at all, whether their face is digitalized or not. The cameras are in here by the grace of this court. They have no constitutional right whatsoever to have cameras in the courtroom recording the faces and the speech of the witnesses as they testify. So that's not protected by the Constitution, Your Honor.
No,
right
but
now, all the
they
cameras.
may have a First Amendment right to find out information about the case. I mean, you may be right about that.
We're not asking that the public or the press be excluded from the courtroom when the witness testifies.
No, I'm not talking about that. I'm talking about the sealed documents.
All right, the sealed documents simply state his name.
Yeah,
Court has
that's
to-
what they want to know.
The court has the discretion to allow the witness not to give his full name or his identity,
I understand
as
that.
long as the parties know it and they can get from him the evidence they desire the jury to hear.
What about
That's and what we're doing allows them, the jurors, to get the information, and indeed the press and everybody else can record the testimony by voice. The newspaper reporter can take notes and write down in the columns of the newspaper what the witness says. The only thing that would be protected would be his identity. That's really what we're seeking to do, Judge, to protect his true identity, to save him from embarrassment and harm. Now, Mr. Bussell would actually put us in a catch-22 situation. I can have my client testify about the harassment he's already suffered and the emotional harm that will befall him if his identity is revealed. But if I bring him in here to do that, now he's going to be photographed and all of that before I get the protective order. So it's not right that we be put in a catch-22 situation like that.
But the defendant in this case, Mr. Peterson, made much the same argument in the early stages of this trial about potential prejudice from the jury pool. And those arguments made much more sense because people who were going to sit on this jury would have been exposed to things that he may have found embarrassing or that he thought were prejudicial. And the court, with Mr. Bussian and some other lawyers, rejected a lot of those arguments. I don't understand why this person, who's not even a defendant, we've already said that he wasn't a victim. He's not a defendant who stands to lose a lot more than your client.
But the defendant has ways he can protect himself, Judge, that my client doesn't. One of them is the jury voir dire. So if jurors have received certain evidence through the media,
I understand that, but your client is not charged with anything and won't be charged with anything. He doesn't need that protection. He's not going to be charged with anything.
except perhaps at North Carolina State.
Well, I mean, that's not a charge.
Well, it's not a charge, but it turns out he could be penalized, subjected to a penalty because he's compelled by a subpoena to come and testify, and he testifies. And my argument is he shouldn't be exposed to that penalty, as it were, out of his own mouth. The university can prove it otherwise, fine, but they shouldn't be able to prove it by what News and Observer prints or the WRAL broadcasts coming out of
I'm
his own mouth
inclined-
with him identified.
I'm inclined to give him some protection. I mean, people who don't know him, then they don't know him.
Right.
I'm inclined to protect his name. I'm not really inclined to block his face, so that the press has the obligation that if they're in his shooting, which they have been the entire time, I'm really hesitant to force them to block out his face. I'm hesitant to do that.
So, Judge, they don't have a First Amendment right to broadcast his face, at least in the open courtroom. They could be totally excluded from photographing and taking televised shots of anyone, lawyers, the judge, witnesses, if that were the order of the court. And they couldn't say, Judge, you can't do that, First Amendment.
No, I didn't say.
And
I didn't say that. I said I'm hesitant to do it. I didn't say I couldn't do it.
All right. So the press doesn't have a constitutional right to that. And a person generally is going to be identified in one of two ways. His name reveal, that's one way you identify someone.
I know.
The
I
other
know
way
all the ways. I know
his
all the
facial,
ways to
his
protect
facial
it.
features.
I know all the ways to protect it.
And
I'm just weighing it, and I'm not saying that he is falling on the side of, when you come to balances of needing the protection that you are suggesting that you want him to have. I'm not seeing it.
well, if people sitting over at NC State or somewhere see a televised picture of him or see a photograph in the Raleigh News and Observer or the Herald Sun, and they're almost inevitably going to do that because the TV people already have said, wow, this is the most exciting day of the trial because, wow, now we're getting into sex, and wow, here's a person identified as a male escort that may be required to testify. Boy, his testimony, if he is compelled to testify, is going to be, probably the most interesting part of the trial to date. That's the pickup the press is putting on this. So one can only assume, that being, at least that's what the TV commentators are saying. And one can only assume that that both the printed media and the television media will certainly take as many pictures of my client as they can, unless the court prohibits that, at least here in the courtroom. And hopefully in the courthouse.
That just may be the consequences of his voluntary act. That may be one of the consequences of his act.
But it's also a consequence, Judge, of his being compelled by court order to appear in the courtroom in this case.
And that may be a consequence of voluntary acts on his part.
Well, that may be, but even so, Judge, again, I come back to the harm and what have you that's apt to befall him if his identity becomes known, particularly if it becomes known in the university community.
Well, it's lawfully as to the protective order, you can prepare a protective order protecting his name when he testifies. He can use Brad, whatever name. The documents as to the state's application are going to be sealed by the court. The affidavit, if you want to read the affidavit into the court as opposed to making it a sealed affidavit, that's fine. You can read that into the record. The court in its discretion is not going to order the media to shield his face. I'm not going to order them not to take pictures of him. I'm not going to order them to digitalize his face.
All right, Judge, with respect to the papers Your Honor is ordering sealed, I take it those are any court papers that actually use his name?
Yes, sir.
All right. And with respect to the photographic exhibit, it's my understanding that
I don't have a problem with that.
so that exhibit can be sealed.
Yes.
That's one of many numerous ones. All right, Judge. Now, may I read again? I'm not trying to keep the press from doing its job under the First Amendment, and I'm not trying to keep the public in the dark. I'm just trying to protect my clients.
Yes, sir. I understand.
So if I can read,
Unfortunately for the court, you protecting your client means that you're keeping the press from doing their job.
well, I respectfully
I know. I
disagree,
understand.
Judge.
I understand reasonable people can disagree.
I'm also trying to give the press as much information as they need to keep the public informed.
I understand. These are tough issues. These First Amendment issues are tough issues. They have been throughout the course of this trial, by the way.
So, Judge, may I read this into the record so the press knows exactly what Mr. Hardin applied for?
Well, I thought you were reading. It wasn't that document. I thought you were reading the witnesses.
Now, I already read my client's sealed affidavit this morning
Right.
into the record in open court. So, I don't know if any TV broadcast my reading.
Yeah.
If they did,
Okay.
the viewers know. And
You just lost me for a second. Why do you want to read what Mr. Hardin found?
I want to read what Mr. Hardin has to say, minus my client's name into the record.
No, I understand that. I said
So that the press and the public will know, except for my client's name, exactly what's in this sealed document. I'm not trying to hide from the public knowledge of what's going on in the case. I'm simply trying to protect my client's ID. And reading this into the record will give any broadcast medium that may have their audio on, they can broadcast that to their listeners, and will give any newspaper reporter who's here taking notes, they can take notes as I read it into the record and publish it in the paper in the morning if they so choose, and that will be fine. I have no problem with that.
Mr. Lawford,
But they won't have my client's name.
they're going to find out Monday morning why Mr. Hardin wants him to
Well,
testify, because Mr. Hardin's going to be the one answering them questions.
Sure. So if the court, doesn't want me to read it, I won't, but I'm offering to, so that the media will be fully cognizant of what he said when he made the motion.
You're offering the press a peace offering. You're not going to tell them about your client, but you're going to tell them everything about why Mr. Hardin wants to.
Well, I've already read why my client will take the fifth,
I think you ought to leave
unless he has immunity.
I think you ought to leave it to Mr. Hardin to tell the press
All right.
why he wants your client to testify.
All right, that's fine. As long as he doesn't use my client's name, I don't have any problem with that either, Judge.
I don't think he wants to use your client's name.
No, he's filed this under seal, and I appreciate it.
No, he wants your client to testify.
No, he wants my client to testify, but he doesn't. It doesn't bother him that the press doesn't learn my client's name, as I understand it.
He hadn't expressed that. He agrees with you that he can use any name he wants to use.
Yes, that's what I'm saying.
Yeah.
He's agreed that he wants my client's testimony, but he's agreed insofar as the court will permit it to protect my client's identity, and I appreciate.
Now I will read the sealed document in front of the open court, and the media can take notes and publish it to their viewers.
Appreciate that.
All right. So you're going to prepare some kind of...
I will prepare another order, Judge. What I will do, because it's now very late on Friday, later I know than Your Honor usually runs in this case, we'll...
In this case, I'm glad you said in this case.
Yeah.
Yeah, I am here
In
late on
this case.
Fridays.
And I'll bring that by, I will tell you this, if...
I don't need to see it until Monday. I don't...
Yeah, I'll bring it by prior to my client's appearance at 10 o'clock on Monday, so Your Honor can review it. If there's a problem with it again, we can change it, or otherwise Your Honor can sign it.
Your Honor, I already have a proposed order with regard to granting the immunity, and I'll
All right.
have it.
Have you seen it, Ms. Hall?
No, I have not, Judge. I wonder if we can do this since it is late on Friday. Let me review it and I'll let Your Honor know, and Mr. Harden, first thing Monday if I have a problem with it.
I'll just print you another copy if I can.
Okay.
All right.
Because in fact, Judge, I was going to take a shot at that myself over the weekend, but if Mr. Harden has done a nice job, then that will save me a little bit of
Okay,
work.
you have your copy?
No, I don't. No, I don't, because I didn't know I didn't know what, I don't, because I didn't know
All right,
the
are you-
scope of the immunity, Your Honor.
Are you asking me to hold this until Monday?
Yes.
Ms. Hall?
That's fine, Judge.
All right. All right. We have anything else? Nothing?
Because if he's going to have immunity, I want the order to be right. That's all.
I do what I can. I mean, I don't see the real problem with the prosecution. He's not going to be prosecuted in this county, or I will bet you. I'm willing to bet you. I'm not a betting man. He's not going to be prosecuted in any county in state court.
Well, he's not. He won't be once Your Honor grants statewide immunity. He won't be.
I understand that. Okay.
And that's what I want. I don't want him prosecuted.
Do we have other matters? Yes, sir.
One clarifying point, Your Honor. Do you understand that the subpoena and the affidavit that was read in open court are sealed? They wouldn't be open absent the name being redacted?
His name.
So take the name out and the rest is open? Is that how that works?
Oh, we can do that.
I suppose we can, Judge. I mean, I read my client's affidavit into the record in open court this morning. If his clients didn't take notes on it or record it or whatever, then that's not my fault.
You're not willing to repeat it? Is that what you think?
I'm willing to repeat it. As a matter of fact,
We're good journalists, Your Honor, but if you don't mind, we can redact the names. Serve our purposes.
Yes, sir. That's all.
here's what I will do, Judge. The actual document is in an envelope, seal closed with, sealed by the court. I will simply, with a word processor, run an affidavit again, omitting his name.
All right.
And then Monday I'll bring down enough copies to pass out to the press.
All right.
And I suppose that that's what, if Mr. Harden is amenable to do that, I suppose that's what he can do with his application. The one I offered to read into the record.
I understand. Mr. Hard.
Your Honor, if you ask me to do that, I certainly will do it.
All right. Why don't you do that? Yes, sir. Anything else, Mr. Long?
Not from me, Judge.
All right. Anything else from anybody?
No, sir.
10 o'clock.
I'll stand. Monday, 10 o'clock.
I doubt that he has an OnlyFans. Yeah, I know that you guys can't hear me good when I don't pause it. Hear me well, hear me good, which is correct. I don't know. I know that you can't hear me well when I don't pause it. Sometimes I'm just like making comments, not really to you, just, oh my God, or whatever. Get them, Judge, or shut up and sit down, or whatever. If I'm saying something that matters, I will pause it. It probably doesn't matter. If I'm saying something that I want you to hear, we'll pause it. If I say something and you don't hear me, it's probably just like, for crying out loud, or sit down, or, something like that.
Do that. I believe Mr. Laughlin has some further information for the court and motion to make.
I do, if Your Honor pleases. Good morning. First of all, Judge, about 10 minutes before court opened, we filed with the clerk.
I know. I was thinking the same thing. I was like, I don't want my client to be prosecuted. I'm like, do you really need to say that? I'm sure the judge realizes that. Like, what lawyer needs to say, I don't want my client to be prosecuted? Seriously.
Our notice of withdrawal, our motion for protective order, and we also move that any previous papers, including our affidavit, that have been filed under seal in reference to my client, who until now has been known as Brad, but his actual name is Brent Wolgamott, that be unsealed. And I will hand this up to the court in just a second. Your Honor, I would also like to hand up to the court our proposed.
What just happened? What just happened? He just said his client's name in open court. So on Friday, an hour, he argued that he didn't want his name. It got leaked. So he just said his. Ugh.
Order granting immunity to Mr. Brent Wolgamott. The prosecuting attorney has no problem with the language. Not sure of Mr. Rudolph's position. I've given him a copy of the proposed order as well, and he indicates to me he does not have any problem with the language either. So if Your Honor, if we may hand those, I have my paralegal hand those up. He can walk a little better than I can today.
All right. I don't see any particular problem with the document.
Keep that stuff quiet.
The immunity statute, the statute governing the granting of immunity to witnesses, 15A 1051, subsection B, as in Bravo, indicates that an order to testify may be issued prior to the witness's assertion of his privilege against self-incrimination. But the order is not effective until the witness asserts his privilege against self-incrimination and the person presiding over the inquiry, which in this case would be Your Honor, communicates the order to him. So I believe the way we need to proceed this morning in order to make the order Your Honor just signed binding is for the state to call my client to the stand. They can ask him his name. He will, now that he's withdrawn his request for protective order, he'll be glad to give his full name. And then they can ask him a question or however many questions they want to, but at the point I, as counsel, feel he should not answer and invoke his privilege, I will advise him to do that. And once I've done that, he invokes the privilege. The court can then communicate the order to him. He will have immunity. The jury can be brought in, and he can be questioned the same as any other witness at that point.
Well, yes, we need to talk about how this is going to occur. Are you suggesting it be done outside the presence of the jury?
Yes, I am, Judge. I think probably.
You mean he be asked the questions?
Not all the questions. Just he be asked his name, and then let them ask him a question that we would not, that we would want to assert the privilege toward. It can be, have you ever had any contact with a man named Michael Peterson? They asked that question. I would advise him to assert his rights against self-incrimination under the state and federal constitutions. I'm confident from my...
How is that incriminating? How is that an incriminating question? Have you ever had relations with, or I forgot what word he used. How is that incriminating? Have you ever had an association, whatever word he used, with a man named Michael Peterson? He could be friends with Michael Peterson. He could, I don't know, work for him mowing his lawn. There's other ways to know a person. How is that an incriminating question? And is this the way immunity works? That's not how immunity works. Wendy Adelson got immunity. She wasn't asked a question first that she had to say, I assert my Fifth Amendment right. And then she was told by the judge she had immunity. This is crazy. I've never seen such a thing before. That's crazy. Well, in this case, yeah. Yeah. And biblically, 2 whole towns were destroyed because of men knowing each other biblically. Just saying. This is nuts. Is this a North Carolina thing or is it a 2003 thing? Because I've not seen immunity granted like this in any court. Or is this just this crazy lawyers thing? Like, what is happening? At least it's not boring anymore, y'all.
Prior conversations with him that he will do so. At that point, Your Honor can communicate to him the immunity order you just signed. Thereafter, he would be obligated to answer all questions. He would no longer be in a position to assert the privilege. And at that point, the jury can come in. Of course, Ms. Black can repeat getting his name and that sort of stuff out on the record once the jury is in. And then she can ask questions in any order she has prepared to ask them, whether the second question would otherwise invoke the privilege or not, whatever she wants to do. But I don't think it's proper for the jury to actually see the witness immunized. Now, it is true, Your Honor, under the statute, that if the defendant requests it, and I don't know whether he will or not, he would be entitled to have the jury instructed that my client is testifying under a grant of immunity.
You mean the defendant will have the right?
If the defendant requests it, they're entitled to that. The statute clearly says so. And I say, I don't know whether Mr. Rudolph will request that or not. He certainly may.
We won't be requesting that, Your Honor.
Actually, I don't think the statute says he must request it. The statute says the court must instruct.
I just need to clarify one thing. I was going to ask him about the immunity issue, if the defense planned to inquire about it during cross-examination. If they don't intend to even go there, then there's no need for me to address immunity with the witness in front of the jury.
No, I have no intention of asking any questions about immunity, and we would affirmatively ask the court not to instruct the jury with regard to the immunity issue.
My recollection of the statute was that it said when the witness gets immunity, the court must instruct the jury before he testifies. Now, of course, if the defendant doesn't want it or he doesn't object to it, that's an issue he probably waives on appeal.
To be explicit about it, we're happy to waive that issue on appeal now and forevermore. We're specifically requesting that the jury not be instructed on that. It would be, in our view, prejudicial to my client while protecting Mr. Walgamon, I understand, but it's prejudicial to my client to have the jury so instructed.
Yeah, 15A 1052, as Mr. Laughlin points out, C, in a jury trial, the judge must inform the jury of the grant of immunity and the order to testify prior to the testimony of the witness on the grant of immunity. Of course, then it also says you have to do it in the final charge. I have no interest one way or the other. If the defendant waives that, that's fine.
I'm waiving it. State care, so we would, for the record, waive that.
All right. I'm ready to proceed. How are we proceeding, Ms. Black?
Your Honor, I don't mind following the procedure that Mr. Laughlin had suggested to the court. So the state would next call Brent Walgamon to proceed.
All right, and this is going to be outside the presence of the jury for this portion.
Yes, sir. We,
All right.
That's perfect.
All right. Okay. Does he want to come down or? Oh, he can wait. Just have him wait. She's saying one of the jurors is not here, but he's in the jury clerk's office right now. Yeah, you need to swear.
Sir, if you please stand and place your left hand on the Bible and raise your right. You solemnly swear the testimony you're about to give the court to be the truth and nothing but the truth, so help you God.
Yes, ma'am.
Please be seated.
State your name, please.
Brent Walgamot,
What city do you live in, sir?
Raleigh, North Carolina.
Back in 2001, specifically in August and September 2001, where did you live?
In Fayetteville, North Carolina.
And what were you doing back then?
I was active duty in the United States Army.
All right. Did you have another occupation of sorts?
Your Honor, at this time, in response to the question, another occupation, I, as counsel for the witness, am going to advise him to respectfully not answer that question, asserting his right against self-incrimination under the 5th and 14th Amendments to the U.S. Constitution and Article 1, Section 23 of the North Carolina Constitution.
On the advice of counsel, I refuse to answer the question on the grounds it may incriminate me.
All right, Mr. Walgamot, the court at this time will inform you of a grant of immunity and an order to testify. The court informs you at this time that you have been offered immunity by the district attorney in Durham County, Cumberland County, and Wake County, North Carolina. For all testimony you shall give in this criminal action that would constitute a criminal offense under North Carolina general statutes relating to homosexual prostitution. And with regard to the following, alphabet A, any relations and communications you have had with third parties regarding sexual relations and cohabitation. B, any of the above activities you have engaged in or offered to the defendant, Michael Peterson. And C, all other matters relevant and material to the allegations in this case, or any of the same actions the defendant, Michael Peterson, has engaged in with you. The court further informs you of its order granting you immunity and ordering you to testify. The court, having found your testimony to be necessary to the public interest so that justice may be done between these parties to this action, orders that, number one, the material witness, Mr. Walgamot, is granted immunity pursuant to North Carolina General Statute Section 15A, 1051, and 1052 for all testimony he shall give in this criminal action that would constitute a criminal offense under North Carolina General Statutes regarding homosexual prostitution. And with respect to the matters set forth below, that would be number two, the material witness, Mr. Walgamot, shall answer fully all questions posed to him in further proceedings in this action with respect to the following. Alphabet A, any relations and communications that he has had with third parties regarding sexual relations and cohabitation. B, any of the above activities that Mr. Walgamot has engaged in or offered to the defendant, Mr. Peterson. And C, all other matters relevant and material to the allegations in this action, or any of the same actions that the defendant, Michael Peterson, has engaged in with this witness. 3, this order shall extend to all proceedings in this matter without limitation. It is the court's belief that this order of immunity is valid against all state prosecutions in all 100 of North Carolina's counties. Mr. Walgamot, I ask you at this time, sir, do you intend to comply with the court's order and testify?
Your Honor, the concern I have with what you just communicated to my client is that the immunity is limited to certain topics that he may testify about. And under the state statute, he's got to, none of the information that he gives.
He's got to what?
He's got a right not to testify unless none of the information he gives can be used against him either directly or derivatively in any criminal prosecution, no matter what the subject matter. If he says he's
state
killed,
prosecution.
If he were to say,
I'm trying to figure out what the real problem is. Do you think he's going to be prosecuted at the state level for something else that could come out of this?
Judge, I don't know what questions are going to be put to him totally, and I don't know, and I do know the answers depending on certain questions, and it's going to be more than just. I mean, he may incriminate himself.
Okay, well,
his answers more than just pertains to the subject matter of this case.
The final
relationships with Mr.
The final thing I read to your client was, this order shall extend to all proceedings in this manner without limitation. Now, what possibly could that not mean other than everything that he could testify about would be covered?
Oh, Judge, I don't know, but I'm more comfortable if Your Honor, as the signed order indicates, if you communicate to him.
What the heck is happening? Sit down and let your client testify, dude. Oh my God. Look at his face. Look. He's just like, dude, I have an exam to take. Would you please just shut up and sit down and let me get through this so I can go take my exam? What is wrong with this attorney? You've lost. Sit down and shut up.
Which is in the language of the statute, that none of his testimony or the information that he gives in this case.
Well, this doesn't supersede the order. What I read from was not the order. The order is one that I signed that you did, and that's filed with the clerk. The statute only requires me to inform him of of the grant of immunity and the order to testify. It doesn't require me to read it to him, nor does it require me to determine if he understands it, although I think that's implicit. What is it he doesn't understand? The signed order, the same way you prepared, is what's on file. That's his order, which I'm sure you've gone over with him. I've given him a summary. I haven't read him the entire order.
I know that, Judge, but
Well, the order, the one that will be defended if he's ever prosecuted, the one that he will use to protect him, is the one that's signed in with the clerk.
that would be my first step. But
Yes, sir.
the problem is what you said to the witness is capable of the construction that you are limiting the immunity
Well, I'm not.
only to what he's testified to
Well, I'm
concerning Mr. Peterson and the subject matter of Statement
Well, I'm
Peterson.
not. And if he's ever prosecuted at the state level and I'm involved in it, it'll be clear that I don't intend a prosecution at the state level of this witness. I can't make it any clearer than I made it. What is it you want me to say?
I would like you to communicate to him no testimony or information he gives, subject to your honors directing him to testify.
And you're reading from the order that I've already signed.
I'm not reading from the statute.
Well, you told me you prepared the order. Is it in your order?
It's in my order, Judge, because
That's what I'm saying. It's in your
the
order.
statute.
It's in your order. I'm not required to quote to him the statute. The order that I have signed is what grants him immunity, and it's right there by the clerk. And I'm ready to proceed. I've been very clear. I'm not unclear about anything. I don't see how Mr. Walkerman can be unclear about anything. And you are certainly not unclear about anything. And the three of us agree.
1051B, Judge, says the order is not effective until the witness asserts his privilege and the person presiding over the inquiry communicates the order.
Yeah, it didn't say read the order to him. I communicated that he has an order. The order that you prepared. The order that I have signed. The statute doesn't say I have to read it to him. It says communicate to him that there's an order. That's how I read it.
It says communicate the order, Judge, and I interpret that as
but you're not the judge. And I'm ready to go. I've got my interpretation, and I'm ready to go. I'm satisfied that I've been very clear, and I'm satisfied the order is in the record that I have signed.
May I ask a question, Your Honor?
No, sir.
I think
you can ask your lawyer.
For the court or my attorney, I think what we're quibbling about is that
I'm not quibbling. Hold on.
What with my attorney?
Hold on. I'm not quibbling about anything. So if you want to talk to your lawyer, you can go down there and y'all can talk. But I'm not quibbling about anything. I've signed the order your lawyer has proposed to the court. I've communicated that order to you. Now, I'm ready to go. If you need to talk to your lawyer, you can go down there and talk to your lawyer.
Hey, step down a minute.
Yes, sir. Yeah.
Come down a minute.
Okay, well, Mr. Walkerman is in front of Mr. Laughlin. Just for the record, I would like to object to this testimony as the fruit of what we contend was an illegal search of the computer, and I just didn't want to waive that, and I'd like to continue
Yes, sir.
the objection.
I don't think you have waived that. You've raised it. The court's discretion is denied.
Yes, sir.
That was another thing in the documentary. The search warrant was illegal. So many things wrong with this trial. Yeah.
Your Honor, please, as my client, from what he communicated to me, is of the understanding that the order you signed trumps anything else that may have been said, again, concerning immunity. That's correct. He's prepared to testify.
Yes, sir. That's my understanding. All right. All right, Ms. Black, how are we going to proceed at this point?
Your Honor, I'd like to be able to call him and have him sworn before the jury. Then my question.
Yeah, I think we're still missing one juror who's there. He needs to come down. Yes, sir. Can you send for
State your name, please.
Brent Wagamat.
How old are you, sir?
I'm 28 years old, ma'am.
Tell us, please, are you presently enrolled in school somewhere?
Yes, I'm enrolled at North Carolina State University. I'm a sophomore.
All right, and you're pursuing what career?
I'm pursuing a chemistry degree. I haven't exactly decided on my career path yet.
All right, tell us, back in 2001, where were you living?
I was living in Fayetteville, North Carolina.
Doing what?
I was an active duty soldier in the United States Army. I did live off post, though.
All right, and you held what rank?
At the time of my inactivation, I was a PFC E3.
All right, and you left the military when?
I left military on March 8th, 2002.
All right, now, during this time period back in 2001, did you have a website?
My image and information about me was on a website. Yes,
A
ma'am.
website. And in regards to that website, did you have a different name?
Yes, ma'am.
What name?
Brad.
Okay, tell us, please, when did you begin having an image of yourself and information about yourself being, when did you place that on the website? Or when did you have it placed there?
Actually, it's not placed by me, but when it did appear on the website, it was probably in about March of 2001.
All right, and what was the purpose of that, sir?
The purpose is it was a mail-for-mail escort review site. It's run by a third party, but not by myself. I had no direct impact on the site, although I did benefit from it.
Okay, tell us, please, when you say a mail-for-mail escort site, what types of things were posted on the website with your name attached to it?
What happens is various clients who have hired me over any given time write in reviews of their experience with me.
All right.
So that's basically what it is.
Okay, and you began conducting this type of activity, would that be in March of 2001?
Around that time, yes, ma'am.
And when you engaged in that same type of activity on throughout the year of 2001?
Yes, ma'am.
Okay. Now, how did that work as far as when people would get information about you from the website? How did you then go communicating specifically with those individuals and then actually being hired by those individuals?
As I said, since I benefit directly from the website, even though I don't run it, people could see my email address on the website. More than likely, they would either call me or email me some email requesting some more information about my services.
Okay, and what types of services did you perform?
Oh, wow. That's pretty broad. Basically, it's a companionship for other males of legal age.
All right. And did that involve sexual activities?
Sometimes it does.
Okay, what types of sexual activities, sir?
Oh, just about anything under the sun. I mean, I don't know exactly how much the court wants me to go into detail, but...
Okay, well, it would be
The court just wants you to answer the question.
That's my answer.
just about anything under the sun.
Yes, ma'am.
Okay.
Safely, I might add.
Sir, safely.
Safely.
I understand.
Yes,
May I approach the witness?
Yes. Yes.
I want to show you. Sorry, an envelope marked States Exhibit 28A. Now, you might not be familiar with this envelope, but I'll show you some papers that have come from it.
Was it strategy to let her do the questioning? I think it's awkward. I think Hardin should have questioned him.
First of all, take a look, please. It states Exhibit 28A1. Do you recognize that?
yes, ma'am. That's me.
Okay, look through these materials that have been paper clipped together to see if you recognize the information and the pictures on these papers.
Yes, ma'am. I recognize them.
What are they?
There are various reviews and pictures of me from the Mail4Mail website.
And does that accurately depict the representations on the website as you remember them to have been back in September of 2001?
Yes, ma'am.
Your Honor, at this point in time, I move to introduce State's Exhibit 28A1 into evidence.
Objection is overruled. So
All right, now you mentioned as far as the website, first of all, that you went by the name Brad.
Yes, ma'am.
Is that depicted on the face of this?
Yes,
Your
My-
website name?
Yes, ma'am.
And it says Raleigh.
Yes.
Okay, now why would it have said Raleigh?
Mainly because Fayetteville wasn't a very active area, and I mainly worked in the Raleigh-Durham, Chapel Hill area.
All right. And there's some photographs here. Are these photographs of you?
Yes, ma'am.
Okay, now I notice here that your face in the photograph is not showing. How did you all accomplish that?
I believe that the picture I sent to various clients who then sent in my picture, I had digitized my face on there so my identity would not be revealed.
All right. Not the case anymore, right?
Right, exactly.
Now, look here, there's some reviews here, I believe 7 of those,
Yes.
sent on different dates about you. Those reviews you were speaking of were people that had been with you would actually write in to say what they thought about their experience.
Yes.
Now, also, sir, I want you to look at some other documents that have come from this envelope marked 28A. Tell me if you recognize 28A1, 28A2, 28A3, 28A4, 28A5. I think that one.
Yeah, his identity's revealed now. Oops.
Look at those papers, please, and see if you recognize those.
Yes, ma'am.
Okay, what are they?
I believe they are email correspondences with someone identified as MP writer.
Okay, now, do you remember when you became familiar with or when you were contacted by a person with the name MP Writer?
Yes, ma'am.
Approximately when would that have been?
I believe it was in August of 2001, somewhere around then. It has been about 2 years. So
Do you remember how you were initially contacted by that individual?
I believe it was by email.
All right, now, with that in mind then, could you tell us, please, sir, what was the purpose of that email? The first one, if you can remember.
Well, object to what the purpose was. The email will speak for itself.
Just so I'm clear, you're talking about this
Yes,
on
it
top
does
here?
right now, and then I'm going to show you some more. In just a
Okay.
minute.
I believe it was just conversations back and forth on an email correspondence, trying to get to know me a little bit better, and a little bit of friendly jabbing at me.
Okay, now is that the type of thing that was that pretty much the normal course for the type of services that you provide, that you would get to know somebody first and then perhaps come up with some type of a deal?
Yes, ma'am.
I'd like to show you another packet of emails. It says it's 169. Now, some of these emails will be duplicative, and there may be some others there. See if you can recognize each of the materials that are put together there. States Exhibit 169. And Your Honor, while he's looking at those, I moved to introduce States Exhibit 28A2, 28A3, 28A4, and 28A5 into evidence.
Yes, I recognize them.
Hold on.
Oh, sorry.
Objections overruled. It's allowed.
You do recognize this set of emails.
Yes, ma'am.
How do you recognize these?
There are other email correspondences with the same person.
Okay, do all of these represent?
Well, they videotape depositions too. So he might have done a deposition already, but this was in 2003. I don't know if they deposed him or not, but he was subpoenaed to testify at trial. I don't know if it would have mattered. And he still would have had to testify at trial either way. But his attorney's been arguing. Yeah, but that's what his attorney's been where have you been, Wiggles? His attorney's been arguing that for over an hour, wanting to blur his face. And the judge said no. That's what his attorney asked for. And the judge said no. Because he's not a protected person. He's not a victim. He's not a minor. There's no reason to blur his face. And it would set a precedent to blur out anybody that wanted their face blurred out. It would negate like the protected person status, and anybody that just didn't want their face on court TV Oh. Oh, okay. You're forgiven. Yeah, that's what the lawyer asked for, to have his face blurred, and the judge said no. Because then anybody could say, "Oh, I'm embarrassed to testify," and then they could get their face blurred, and then it wouldn't be much fun watching trials on court TV. He is entitled. He's very entitled. I don't like entitled people. I'll tell you that right now. Nobody is more special than anybody else. And you're an adult. You chose to do this. Now it's time to suffer the consequences of your actions. If you're going to do something and you know that it's going to have a consequence if someone finds out about it, don't do it. Why? Exactly. But why? Witnesses haven't done anything wrong. Why should they be blurred? Exactly. You did it willingly. You wanted to do it. Why are you ashamed of it? You wanted to do it. You did it willingly. You made money from doing it. If you're an idiot, you should get your face blurred. Then the lawyer's face should be blurred too. Right. They haven't done anything wrong. But so why should they be blurred? They're just saying what happened. So they're just saying what happened. Unless, I was going to say, well, they have witness protection for that. For the ones that could be harmed because of their testimony, those you don't see.
Correspondence with the same person.
With the same,
you can tell.
yes, ma'am. With the same email address, yes.
Now, do you actually remember these emails? Was there anything about that particular MP writer that caused you to remember this series of emails?
Yes, ma'am.
What about it?
Well, as I said, I was active duty at the time, and the beginning of the email is from MP writer. Mm-hmm. So when you're active duty, the first thing I didn't know the person in the courtroom today. I just saw MP, and I thought it meant military police. And so it definitely stuck in my head that this was someone who I wanted to take notice of.
Did it worry you?
A little bit at first, yes.
Okay. All right, Your Honor, at this point in time, I move to introduce State's Exhibit 169 of the evidence.
It's allowed.
Now, Mr. Waldman, you say you think you first had contact from a person who you now know was Michael Peterson back in August of 2001?
I can't say
as best you can remember.
As best I can remember, yes, ma'am.
Now, you all contacted each other back and forth approximately how many times by way of the computer?
I'm guessing about 20 different email correspondences by either myself or this person back and forth.
Okay, now you've mentioned that at least one of the initial purpose was getting to know each other a little bit better. Did the emails turn out to be something a little bit different than that? Or did you all discuss anything other than just trying to get to know each other?
I mean, as far as I can, without directly looking at them, as far as I can recall, it was basically the same as many other clients who would contact me. They'd want to get to know me about my life, about, just They want to be safe, so they want to get to know me to make sure that I'm a straight guy.
Okay, well, what does that mean?
Well, it just as in I'm not a gangster, someone who's going to rob them. I'm a clean cut professional who's going to have they're going to have a good time with.
All right, now, a lot of the emails, did they deal with that type of thing? Just casually getting to know each other?
Yes, ma'am.
All right, now, was there one email in particular where the name Dirk Yates was communicated to you?
I believe there was, yes, ma'am.
Do you remember the content of that email from Mr. Peterson?
Yes, vaguely. I remember that the email had something to do with asking me whether or not I had ever heard of Dirk Yates.
And had you?
I had, yes.
All right, and what did you know, or who did you know Dirk Yates to be?
I believe he is a man who produces videos of guys who are either active duty military or have since left active duty.
Doing what?
Porn.
All right. Were there some suggestions made to you by Mr. Peterson that you should contact Dirk Yates?
Overruled.
Yes, there was.
All right. Now, other than the emails, sir, did you all talk in any other mode of communication?
I believe, since we've talked earlier, that I had one phone call conversation with him of significant nature, and there were 2 other phone calls that looked like voicemail, from what I can tell from the records.
Do you remember whether Mr. Peterson called you or whether you called him?
I don't remember, but usually it's them calling me.
Them meaning your clients?
Yes, ma'am.
May I approach the witness?
Yes.
I'll show you in Exhibit States Exhibit 174. Now, you may not recognize this account, but at any rate, let me turn on further.
We'll stipulate the admissibility of 174.
Thank you. I move to introduce State Exhibit 174 into evidence.
It's allowed.
Sir, would you agree with me that this is a phone bill in the name of Kathleen Hunt Peterson?
Yes,
Is that
ma'am.
the face of the phone bill?
Yes, ma'am.
All right. And in looking here at the content of the bill, do you see call number 14 here, Wednesday, August 29th,
Yes.
in Fayetteville, North Carolina?
Yes.
Do you recognize well, I guess that's your old phone number?
Yes, ma'am.
910-308-0190.
Yes, that's my old phone number, yes.
Okay, and that call was how many minutes?
2 minutes.
All right, do you see another entry here, line 15, Wednesday, August 29th at 5:03 p.m., the first one being at 5:01, then 5:03 p.m. Once again, do you recognize your phone number?
Yes.
And that call was of what duration?
7 minutes.
All right, then finally, entry 22, Wednesday, September 5th. Of course, all these are going to be 2001. Do we agree with that?
Yes.
At 3:17 p.m., you recognize your phone number again.
Yes.
And that call shows what length?
1 minute.
Now, Mr. Waldman, in conjunction with your dealings with Mr. Peterson, did you actually send him a picture of yourself?
Yes, ma'am, I did.
What purpose?
Usually anybody who's contacting me likes to know what they're getting.
Okay. May I approach him again?
Yes.
Let's look at, this is a packet of materials marked States Exhibit.
That is not the reason. The reason why, and I know this because I watch Chris Hansen. Chris Hansen is a guy. Chris Hansen is a guy that does the stings to catch a predator, Hansen versus Predator. Now he has a new one called Takedown, where they use decoys to find men that want to sleep with underage girls. And they send a picture of themselves naked, and they ask for a picture from whoever they're soliciting. They ask them for a picture too. And they do that to prove they're not law enforcement, because that in of itself is a crime, sending nude photographs electronically. So that's why they send the pictures, not because of what he just said. They will say that's the reason, but that's not the reason. And that is how these predators get caught on those shows. Even because as soon as, well, number one, there's not really an underage girl because it's a cop. And as soon as they walk in the Sting house, they got caught. But they've already committed a crime by sending naked pictures through email. But that's not why they do it. They do it because they want to make sure the person on the other end isn't a cop. He is. He's very smug. He's very smug. But he's also lying.
170, and you may not specifically recognize this entire packet, but look at 170A. Do you recognize that?
Yes, I'm the man in the middle.
Okay. And now, do you know how this photograph might have come into Mr. Peterson's possession then?
I would have had to send it to him.
Okay. Do you remember doing that?
I don't specifically remember it, but I'm not disputing it. Yes, ma'am.
Okay. Now, during your conversations with Mr. Peterson, did you all actually even discuss a price for your services?
I believe we did.
And what was the price that you quoted him?
I believe it was $150 per hour.
Okay. Was that your normal price that you would have for most any client?
In the beginning of my short career, yes.
Okay. You talk about this career that we're speaking of in that
Yes, ma'am.
prostitution career. All right. Sir,
I do prefer to call it escort.
escort, excuse
Okay,
me.
thank you.
Okay. I'm sorry, I was using legal terminology.
It's okay.
During the course of your conversations with Mr. Peterson, whether it be by phone or by computer, did he ever mention his wife?
I believe he did, yes, ma'am.
Do you remember what he said about his wife, if anything?
Yes, in one of the email correspondences, I believe he said something to the effect that he had a great marriage, and I'm paraphrasing here, a great marriage, and he had a lot of warmth and affection for his wife.
All right. Now, did you all have any type of communication, whether it be by computer or by phone, about how it was you all were going to hook up together without his wife knowing it?
Object.
Or whether his wife would know?
Overruled.
I don't remember any discussions about whether his wife would or would not know. I mean, it may be in emails, but I do not recall that. We were to hook up, I believe, on September.
Oh, I forgot something else. In the documentary, towards the, like in the last episode, towards the very end of the documentary, after the Alfred plea and everything, he finally admitted that Kathleen did not know about his bisexuality and the escorts. Finally, at the very, very end, after it was all over and done with, he admitted that. He didn't admit that he killed her, but he admitted that she didn't know.
September 5th, 2001.
All right. Now, were you going to meet him somewhere here in Durham, or was he coming to where you were?
I was going to come up to Durham.
And do you know where you were supposed to go?
I believe that I was supposed to either go to his house or to another house that he had. Whatever it was his house.
All right. Was that the normal course of business for you to go to another person's house, or how did you normally go about doing it?
I wouldn't call it normal. I would say it's about a 50-50 split between men who would like to see me at their residence and men who would like to see me at another venue, such as a hotel.
Tell us, please, did you all actually discuss what you were going to do when you were to get together on September 5th of 2001?
Yes, ma'am.
And what were you all planning on doing?
Having sex.
What type of sex, sir? You know?
Well, can I say it? I guess anal sex.
Okay. Did you get together with him on September 5th, 2001?
No, ma'am.
Well, what happened?
I made this appointment on September 5th at around 9 o'clock that night. That's when it was supposed to happen. The only reason I was coming up to Durham was because I was leaving on a flight the next morning to Palm Springs on September 6th.
From Raleigh-Durham Airport?
Yes, ma'am. That's why I would be close to his residence. When I had a very long day, and when I got up there that night, I just said, you know what, I'll talk to him when I come back. I'm just tired and I want to go to Palm Springs, so I didn't go.
So you just simply didn't contact him back at all?
I do not think I contacted him that night. I have found out that I contacted him about 25 days later to apologize for not showing up.
Well, after you contacted him to apologize to him for not showing up, did you have further communication with him?
No, ma'am.
Why not?
I believe he did not email me back.
Okay, is there anything extraordinary about that, about just simply losing contact with somebody after that period of time?
I wouldn't say it was extraordinary.
I mean, as far as your escort business or the type of contact you would have with different.
Right. If someone was actually serious about hooking up with me, I would have expected to gotten a barrage of emails from them saying, "Where the hell were you? I was there," But this didn't happen in this case, so I can only assume that it might not have ever happened.
All right. Did you intend for it to happen?
I intended for it to happen, yes.
I would like to move into evidence cases.
That's no way to run a business. You couldn't have emailed him and said, "I need to cancel tonight"? What kind of businessman are you, dude?
170A.
It's allowed.
And at the conclusion of all questioning, I'm going to ask that these exhibits be published to the jury, but we wouldn't necessarily need to do that at this point in time. And I have no further questions.
All right. Cross-exam?
Yes. Mr. Walgamont, good morning. We've met before.
Yes, sir.
At the time that you were doing this, I think you said you did it for a while you were in the Army.
Yes.
And your purpose in doing this was what?
I needed to save money for my education.
And Miss Black asked you about these reviews that you got, and I've read them. I noticed that a number of them were from married men. Is that right?
Yes, sir.
Was that an unusual occurrence for you to have or plan to have sexual relations with married men?
To the contrary, I mean, married men are in the majority of most of the clients that I saw when I was an escort.
With regard to the kinds of men that you tended to have escort relationships with, can you give us some indication of their professions, for example?
Sure. Usually they are professionals because my fees were quite high. I saw doctors, attorneys, one judge.
It was not this judge.
I think we can stipulate to that. Is it fair to say that the men who you would see were bisexual as opposed to being homosexual?
In my opinion, I would go so far as to even say that they were predominantly straight with minor homosexual tendencies.
And just so the jury's clear, when we're talking about bisexuality versus homosexuality, can you define what we're talking about there?
Sure. Homosexuality, in my opinion, and I'm not a scientist, is someone who can only emotionally become attached to someone of the same sex. Someone who is bisexual is someone who, in my experience, can only be attached emotionally to someone of either sex, but might have sexual relations with both sexes.
And did a number of the married men who you had sexual relations with, have wives who knew they were bisexual?
I believe most of them did, from my experience.
In your experience, was it unusual for a wife married to a bisexual man to know that he was bisexual?
Not at all.
You mentioned this email that Mr. Peterson sent you in which he expressed his very strong feelings for his wife. Was it unusual for a bisexual man using your services to be in a happy marriage?
Not at all. Most of the men who would see me would have their time with me and then go back to their happy, healthy lives.
Obviously, what we're discussing here are your escort services in exchange for money.
Yes, sir.
Was there any romantic relationship involved between you and Mr. Peterson?
There's never any romantic relationships involved with anyone who I saw.
Was there any kind of personal relationship involved between you and Mr. Peterson?
No, sir.
Was that even on the radar screen?
No, sir. I believe in one of the emails, it was very explicit that there would be no emotions involved, no personal relationships involved. It was strictly physical.
And just so we're all clear, you have never had any kind of sexual relations with Mr. Peterson, have you?
That's correct. I've never even met him.
And you were shown some phone records. Do you have any recollection of the phone conversation?
I'm not disputing him, but the phone conversations were about 2 years ago, and I do not recall them. They were that insignificant.
Now, I have Exhibit 170. Is Exhibit 170 up there? Okay, thank you. You were asked a question about the photo that you sent him. I think that was Exhibit 170. Hey. You have it. Thank you very much. Thank you. Do you mind if I take it out? Is that the photo you sent him?
Yes, sir.
Your Honor, at this time, I'd ask that this photo be shown to the jury so that they could see what was sent to my client.
Hello.
Thank you. Thank you very much. I noticed in looking at State's Exhibit 169 that all but one of these emails occurred in about a 4 or 5 day period between August 30th of 2001 and September the 5th of 2001. Is that correct?
Yes, sir.
And the last email on September 5th was one where Mr. Peterson was indicating he was confused about when you were going to be coming up to the triangle.
Yes, sir.
And then you just never showed up.
That's correct.
And you never heard from him after that.
That's correct.
And then on September 30th, you sent him an email.
Yes, I did.
And you explained in that email why you hadn't come up to meet him.
Yes.
And he didn't respond to that.
No, he didn't.
And are there some percentage of the people who you have email correspondence with that you just never hook up with for one reason or another?
That happens quite a bit.
Sometimes they're more interested in the communication than meeting.
Certainly, I mean, a lot of guys are certainly interested in hooking up, but others just want to get to know a military man and find out about him and get information about me, and it never goes beyond cyberspace.
All right. After that email on September the 30th of 2001 that you sent to him, did you ever have any further contact with Michael Peterson?
No, sir.
Or anyone using the name MP Writer?
No, sir.
Via email or in any other way?
No phone calls, no email.
Nothing in person?
No, sir.
Yes. Let me show you what I've now marked as Defendant's Exhibit 177 and ask if you recognize it.
Yes, it's my affidavit.
Now, with regard to that affidavit, just so we're clear about how it got prepared, did you at some point a couple of weeks ago call me and ask to meet with me?
Yes, sir.
And was that after a conversation you had with the district attorney's office?
Yes, sir.
And as a result of that, did you provide me with certain information with regard to what we've been talking about here today?
Yes, after realizing that I was going to be called as a witness, I went to you to say I know nothing about your client. I've never met him. I've never had sex with him. I've never talked with him in person. I don't even recall a phone call conversation with him, but I'm still going to be called as a witness.
And were you concerned? Was the reason you called me because you were concerned about what that might do to your student status and your career and that sort of thing?
Sure. I mean, I'm hoping to become a professional, have a great grade point average. I want to do big things with my life, and for this to be blasted across America on national TV certainly does a great deal of harm to myself.
And was part of your goal in contacting me to see if I could talk to the DA's office about whether they really needed to call you?
Yes.
And did I tell you that I would draft an affidavit incorporating what you and I had discussed?
Yes, sir.
And did I then email you a draft of that affidavit?
Yes, I made a few corrections and then I sent it back to you.
And is Defendant's Exhibit 177 a copy of the email as you corrected it and sent it back to me?
It is, sir.
And is there anything in there that is not 100% the truth?
Everything is 100% true.
Offer Defendant's Exhibit 177 into evidence.
It's allowed.
Now, the last paragraph of this can you read paragraph 18 and then paragraph 19 into the record for the jury?
Yes, sir. Although I realize that I have a duty to testify under appropriate circumstances, I have never had any sexual relations with Michael Peterson, nor did I ever meet him. I have no recollection of ever talking to him on the telephone or in person. I had a roommate who had access to my computer and my password in August and September of 2001, and I cannot even testify under oath that I recall all of the emails I have been shown or was responsible for sending or receiving all of them. I certainly do not know if Michael Peterson was the person sending or receiving them. Under these circumstances, I fear that all my hard work in turning my life around and preparing for school will be negated, despite the fact that I literally have no knowledge relating to the Peterson case. I would therefore most respectfully request that I can be excused from testifying in this matter.
And to your knowledge, did you have an attorney from NC State Student Legal Services come to Durham and deliver that affidavit to the District Attorney's Office?
Objection, relevancy.
Overruled.
Yes, sir, I did.
And did you receive any response?
I received no response from the District Attorney's Office.
Sir, do you know anything about the death of Kathleen Peterson?
I know diddly.
Did Michael Peterson...
I take it that means nothing.
I know nothing. Zip.
Did Michael Peterson ever do or say anything, either on a phone or in an email, that indicated that he was not in love with Kathleen Peterson?
To the contrary, in his emails, unlike most of my clients, he indicated that he had a great relationship. Most clients don't want to say anything about their relationship. He indicated he had a warm relationship with his wife, and nothing would ever destroy that.
Did he ever indicate in any way that he was hiding his bisexuality?
He gave no indication.
As a matter of fact, the phone calls were made on a phone that was listed in her name. Isn't that right?
That's correct.
On a bill that would go to Kathleen Hunt Peterson, right?
Yes, sir.
And the phone calls to Fayetteville are right there, right?
Yep.
Did he ever say or indicate anything that there was any issue between him and Kathleen Peterson as a result of his bisexuality?
Not at all.
That's all I have. Thank you, sir.
Redirect.
No, I don't have any further questions. I would like to ask that he be allowed to be released from his subpoena, and then I'm just going to move to publish a number of these exhibits to the jury.
All right. Both are allowed.
Why was that so hard? Oh my God.
In Durham? How are you employed?
As a special agent assigned to the trace evidence section of the SBI laboratory in Raleigh.
With respect to your assignment in the trace evidence section, exactly what is your job?
My job in the trace evidence section at this time specialize in the area of fibers. This would include polymers, ropes, cordage, fabric, anything of textile type nature or polymeric nature. I also deal with explosives and arson.
And with respect to your responsibilities in the trace evidence section, would you please describe what your educational background has been and your training that allows you to perform the duties that you just described to the jury, please?
I have a Bachelor of Science in Textile Chemistry from North Carolina State University in Raleigh. After receiving my degree, I came on with the State Bureau of Investigation. I went through the SBI.
Nancy, if you listen, he's telling you who he is right now. He just asked him who he was, and now he's telling you what his education is. He's from the crime lab. He tests fibers. His name is John Bender. Pay attention, woman.
Academy. I've attended the FBI's Hair and Fiber School out of Quantico, Virginia. I've attended numerous workshops or courses that involve textile-related items. I went to a course at Auburn University, which was textiles for forensic scientists. I've attended carpet technology courses through Clemson University, numerous workshops at NC State. I've attended forensic meetings with the American Academy, the Southern Association of Forensic Scientists, and I'm tested extensively over the last 22 and a half years of my proficiency in those areas.
With respect to your responsibilities at the State Bureau of Investigation in the trace evidence section, exactly what is your job title?
I'm a Special Agent Forensic Chemist 3.
All right. And exactly what is a forensic chemist, as that would be described and as your responsibilities would dictate at the State Bureau of Investigation?
Forensic chemist in the trace evidence section, we deal with various types of trace material that come into the laboratory. We employ a number of different microscopes. The forensic chemist uses not only chemistry to analyze and perform analysis on different materials that we encounter. Either we're showing contact or associations between a suspect and a victim, or a victim and a suspect in a place or an object. So we not employ just the chemistry, we also employ a number of microscopes. And in the trace evidence section, we use microscopes such as the scanning electron microscope, polarizing light microscope, fluorescence microscopy, and the most basic and the most common one we use the majority of the time is the stereo microscope or macroscope, which now allows us to see things up to around 64x. So a lot of our analysis is done on a small basis, and in this case, that's the reason I was employed into the evidence in this case.
And with respect to your field of forensic chemistry, are you involved with or a member of any professional associations or societies?
I'm a member of the Southern Association of Forensic Scientists.
All right, any others?
I've been a member of the American Academy and a number of other small associations, but nothing major. Most of the meetings that I attend are with the Southern Association of Forensic Scientists.
And with respect to your responsibilities at the State Bureau of Investigation as a forensic chemist, have you had the opportunity to testify in various courts in the state of North Carolina in the area of forensic chemistry?
Yes, I've testified in state, federal, and military court.
Approximately how many times?
In excess of about 160 times, additional 10 times in arson or explosives.
Now, at this point, the state would tender Agent Bendur as an expert in the field of forensic chemistry.
It's allowed.
Now, you had alluded to the fact that you became involved in this particular case. If you would, please, will you describe how that came about and what you did generally as it relates to analysis that was conducted by you and with articles submitted to the State Bureau of Investigation?
Okay. In this case, I was asked to look at one particular item. This was a pair of khaki shorts identified to me as coming from the defendant. Special Agent Deaver, Special Agent Barker, and criminal specialist at the time, who's now a district supervisor, Dennis Honeycutt. The three of these individuals were examining the shorts in the work area of Susie Barker at the DNA or molecular biology unit. After calling me down, they pointed out a number of spots, blood spots or stains.
Nope. What we chat stays here forever. So if you don't want it repeated, don't say it.
What appeared to be like a spatter on the inside surface of the shorts, and wanted to know if the spots that they were looking at originated from the inside surface, had been applied to the inside surface of the fabric, or it had come from the outside and bled through.
Now, just from a general perspective, how are you able to determine whether something like a blood spot would be applied or contacted onto a particular surface as opposed to the backside of the surface with respect to fabric?
In this case, it was fairly simple. The spots that we had in question, the only microscope I had to use was a 64X stereo microscope. After observing the stains or spots, found that it appeared to me that the blood had hit the inside surface of the fabric and had wicked through to the outside. There were 8 and 8 in number, 8 different spots.
In general speaking, how do you go about making that determination exactly?
Just a close examination, observation under the stereo microscope, making some observations about the spot, whether it's a dispersed spot where you would have a blood spot hit a piece of fabric, and let's say water would disperse it through the fabric. In this case, the ones that we were looking at in question were 8 defined spots. The diameter of these spots was greater on the inside surface versus on the outside, and on 1 or 2 of them there was no bleed or wicking through to the other side. So 2 of the 6 barely went through to the other side.
John, may I approach the witness, please?
Yes.
Agent Bendura, let me show you what is marked as State's Exhibit 1A and ask you to look at that and the contents and ask whether you can identify those principles.
The outside bag bears my lab number 14. The case number was assigned to it, the date on the 24th of January of 2002 that I received it, and it bears my initials. And the inside contents are a pair of shorts, as I described.
Hold up. Did you type that before or after I sang it? Are we sharing a brain today? Thank you, sweetie, for supporting me. Did you type that before or after I sung it? Same time. I love the love, but I would prefer money. I'm just kidding. I love the love.
Earlier, it's coming from the defendant, and it bears my tag, my case number, my item number, the date I received it.
And just for the record, what you're describing is what's marked as State's Exhibit 1, is that correct?
That's correct.
All right, if you would please go ahead and describe how you went about conducting your examination and analysis of what is marked here as State's Exhibit 1.
Okay. First observations, I know there were several stains on the outside of the shorts. And after speaking with Agent Deaver, Agent Barker, and Agent Honeycutt, my area of concentration were some spots on the inside. So the shorts were turned basically on the inside out. The area that was on the what I refer to as the right rear area of the right leg.
Okay, Deaver and Barker were the two from the lab that kind of screwed everything up. They were the ones that they did confirmation bias. They're the ones that did the tests, the blood spatter tests. They did that. They did. What am I trying to say? Good Lord. Why do I get so tongue tied when I talk to you guys? I'm not nervous. I was when I first started streaming, but I'm not nervous now. I just can't get it out right. They messed up the evidence collection. They said not to do. Susie Barker was in charge of distributing what went where for what tests. And Deaver told her not to test the clothing for DNA because he wanted to use it to test for blood spatter analysis. Now, I don't know why they couldn't have tested for blood spatter analysis if they tested for DNA. I guess he was afraid that they would cut an area that had a blood stain on it that he needed to test. I still don't understand what one has to do with the other. But anyway, they were first designated to be sent for DNA testing, and then they were not. They were sent to blood spatter analysis. But why then couldn't they have been sent back to DNA to be DNA tested? I don't know. I asked this question earlier in the trial, and I think it was Judy that reminded me that method of evidence collection had not been done yet. So, because this was in 2003. So, this might be Michael Peterson's shorts that they're looking at now. So, the clothing wasn't tested for DNA. And I didn't think that mattered. But apparently it would have strengthened the state's case because it would have only had Michael Peterson's and Kathleen Peterson's DNA on it. But so Barker is one of the problems and Deaver's one of the problems because they did test that's confirmation bias when you try to take the test and manufacture it to fit your theory. That's confirmation bias. And what you're supposed to do is do the test and see what happens. And if the test matches your evidence, then you know that's what happened. And if it doesn't match the evidence, then that's not what happened. No, less competent or just as incompetent as Massachusetts state troopers. They basically did the same thing just in different ways. Like they lied on the stand. They manufactured testing to fit their theory of the crime. So just as bad as Massachusetts state troopers. They just didn't use red Solo cups. Red Solo cups, David, are from the Karen Reed trial. There was blood in the snow, and they said, now this is Massachusetts where it snows on the reg, right? They said they didn't know how to collect blood in the snow, and they used red Solo cups to collect the blood.
Be in this area right here. Just the back of the right leg, so toward the lower end.
Your Honor, could I have the witness step down before the jury and show the jury exactly what he did with respect to these items?
So allowed.
Now, as you're doing that, Agent Endor, did you prepare some photographs with respect to the analysis that you conducted?
Yes, I did.
You just lay the pants right there real quick. Let me have you look at these. And I'll show you for the record what is marked as State's Exhibit 100-1, 100-2, 100-3, 100-4, 100A-2, 100A-1, 100B-1 and B-2, 100C-1 and C-2, 100D-1, D-2, 100E-1 and E-2, 100F-1 and F-2, 100G-1, 100G-2, 100H-1 and 100H-2. You just look through those real quick and tell me whether you can identify them.
Yes, sir, I can.
What are they?
These are pictures that we have prepared on the 14th of February 2002, and the photo lab. I had the assistance of Mr. Jim Trevelyan of our photo lab make these for us.
And exactly how do they relate to what is marked as State's Exhibit 1?
There are shots of the outside of the shorts, closer shot of the outside of the shorts turned inside out, photograph of those. Particular interest to the right rear leg, then a closer shot of that area, then an individual shot of each spot. We're talking about all 8 spots. One of the outside area, surface of the area, and the inside surface of the area.
You know, at this point, we move into evidence what's marked as State's Exhibit 100-1, 100-2, 100-3, 100-4. We would also move into evidence what's marked as State's Exhibit 100A-1, 100A-2, 100B-1, 100B-2, 100C-1, 100C-2, 100D-1, 100D-2, 100E-1, 100E-2, 100F-1, 100F-2, 100G.
My question is, why are those photographs so thick? Do they think the jurors are kindergartners? It's going to tear up the picture? So they have to mount them on like super thick cardstock or something so they don't get messed up? Like, what is that about?
-1, 100G-2, 100H-1, and 100H-2.
So allowed.
Agent Mendor, as you were describing what's depicted on these photographs, will you please point that out on what is marked as State's Exhibit 1 and show that to the jury so that they have an understanding exactly what they're looking at with respect to these photographs. Okay. And I'll show you what's marked as State's Exhibit 100-1 to begin with, please.
State Exhibit 100-1 is a photograph of the back side of the shorts. See here that we have the spots in question are down in this area, the right rear leg.
Just so everybody can see it, let's do this half of the jury and then do this half of the jury.
All right.
So we can get a good view.
100-1, again, it's a photograph of the back side of the shorts. With particular interest to the area here that I have marked with a marker, and shows the 8 spots, and it's basically an overall shot of the shorts. Okay. So exhibit 100-1 again is a shot of the backside of the shorts. And if you take interest to the area, here we'll have small letters for each of the spots. And those are depicted also in the photograph here.
Let me show you what's marked as State's Exhibit 100-4 and ask if you'll do the same thing, please.
Okay. Nice again, this is a State Exhibit 100-4 is a photograph when it zoomed in on that right rear leg, this area right here. And you start to see the letters a lot clearer now, the different spots that I had in question. There we go. Zoomed in shot, 100-4 again. Zoomed in shot of the right rear leg. You can see the heat marks that I made that designate the different spots where it's present on the back right rear leg.
Let me show you what's marked as State's Exhibit 100-2 and ask if you do the same thing.
Okay. 100-2, the shorts were turned inside out. And as the outside was done with an overall shot, 100-2 is an overall shot of the shorts turned inside out. This being the right rear leg area of the shorts. And that was just an overall shot.
Yeah, there are some small little paper circles here. What do they represent?
Take it, someone placed those around in the individual spots. The lettering is on the outside and it bleeds through to the inside. Okay, again, this is an overall shot of the inside of the shorts. This being the right rear leg, you can see it right here. And you can see the ink coming through, bleeding through to the inside surface.
I'll show you what's marked as State's Exhibit 100-3 and ask you to describe that to the jury as well with respect to what's marked as State's Exhibit 1.
State's Exhibit 100-3, again, is a close-up or zoomed-in shot of that right rear leg area. The spots in question here are beside, you can start to see the lettering starting to bleed through from the outside. When I mark these spots, they're marked on the outside surface, and the ink's just starting to bleed through the surface. They're adjacent right to the spots in question. Again, 100-3 is a zoomed in shot of the right rear leg on the inside surface. And as I said before, these are marks indicating where the ink is marked that's actually on the outside. I'm going to bleed through the fabric, and they're adjacent to the blood spots in question.
Now, let me show you what are marked as State's Exhibit 100A-1 and 100A-2 and describe these to the jury with respect to what's marked as State's Exhibit 1.
All right. 100A-1, you'll see two different colors on the fabric. And when you photograph fabric that has different surface texture, you'll have a different color. And in this case, the inside surface where the spots, as I said, were originating from, will be the darker photograph we're looking at here in 100A-1. It's a fairly round spot, the first spot A that I had marked with the first spot of interest. It's fairly round. If you look at the 100A-2 from the outside surface, You can see where the blood is just starting to wick up from the inside. Close examination of this course or this twill across the surface, there is no blood present in these fibers that are on the upper side of the yarn. If you look close enough, you can see that the yarns are fairly clear of any blood.
And what does that mean to you?
That's a clear indication to me, sir, that it came from the inside, not the outside.
Okay.
That's the reason it didn't require a great deal of different microscopes to use in this case.
And with respect to what's marked here, States Exhibit 1, then, as it relates to that particular stain, describe where this would have impacted and how it would have impacted. Well, where it would have impacted.
A would be approximately right here, about midway. Let's see. The range of the spots that I looked at here were basically as far as off the hem. I had one that was on the doubled fabric on the hem. That would be spot G, which we'll get to later. That was about 2.3 centimeters off the hem, off the edge of the hem. And the farthest point, I think, may have been D, if I'm not mistaken, but it was 17.3 centimeters up into the shorts.
Okay, if you show the jewelry down on this side.
As I said before, the 100A-1 represents the inside surface, the darker fabric is going to be the inside surface of the fabric. Where 100A-2 is the outside surface of the fabric. And here on the inside surface, you see a fairly round spot on the inside of the yarn on the fabric. That's on the inside surface.
When you say inside, you mean inside of that?
Yes, sir. If you have it turned right now, it would appear that's the way it would appear on this side.
Okay.
100A-2 is the corresponding outside area of that spot. You can see, matter of fact, the spots where the marker is on the outside. The marker is applied to the outside. It's very defined A present there. We're on the inside surface of the fabric. It just starts to bleed through. It doesn't cover all the yarns as this one does. It's a good example of the wicking effect that occurs here. In this area here, the spot A.
Excuse me, when you point out what you just described to the hearings.
Okay. This is going to come inside out. Okay. This will be your right rear area. This will be spot A right here. And this photograph here, 108-2, represents that spot. And as I said before, you can see the lack of blood in the upper part of the yarns. Going in with a stereo microscope with a higher magazine, what's represented in the photograph. There's no blood present in those upper yarns, which is an indication to me the blood came from the other side.
Let me show you what's marked as States Exhibit 100B-1 and 100B-2 and ask if you'll describe what is depicted in that photograph as well.
Okay. Again, as we said before, the darker surface is the inside surface of spot B. And we got a fairly round spot here again, very uniform in the way it's represented on the surface. 100B-2 is the outside. And the blood in this case was even better than A. Barely even got into the top of the yarn there on the twill. There's no blood present in that. So it's basically a bleed through from the other side. Okay. 100B-1, again, is the darker surface, represented by the inside surface of the fabric. And the blood spots were uniform in color. It's fairly round. Depiction from the inside. From the outside, 100B-2, you can see where there's a lack of blood in the upper part of the yarn. Where blood had been applied from the outside, there had been some blood or serum present in the fibers.
Let me show you what's marked as States Exhibit 100C-1 and 100C-2.
Okay. 100C-1 again is the dark side of the fabric, which is is the inside surface. It's had sort of an elongated spot there. And fairly uniform in color across the spot. On the inside, on the outside, you can see it just starts to bleed through. And in one area here, there's no blood present. It's down lower in the yarns in between those portions. There's a lack of blood in the upper yarns. Upper 100C-1 is the dark side of the fabric, which is the inside surface. So sort of an elongated, it's like I call more of an elongated round spot, but it's an elongated spot compared to the other two that we looked at prior. This would be the inside, with a very uniform color across the stain. On the other side, the corresponding outside surface, it starts bleeding into the yarns here. It goes up toward the end here. There's a lack of blood, and there's amplified, of course.
Let me show you what is marked as State's Exhibit 100D-1 and 100D-2 and ask you to describe what's depicted in that photograph, or those two photographs.
100D-1 again is the darker surface to the inside. Again, we have a fairly round, elongated spot there, fairly uniform through the area of the stain. And on the outside surface, it's barely showing through. On the top of the twill, there is no blood pushing the ball.
And what does that mean?
That the blood deposited on the inside surface bled through to the outside. Okay, again, 100D-1 is the inside surface of the fabric. The elongated round spot here, fairly uniform in color. The outside surface, 100D-2. The blood is barely even getting up to the part of the twill. Lack of blood present in this fire.
Let me show you what is marked as State's Exhibit 100E-1 and 100E-2, please, and describe, if you would, to the jury what are depicted in those photographs.
Okay. 100E-1, 100E-2. Our photographs again. 100E-1 is the inside surface, fairly round spot on the surface, and again, as I said before, you can see the corresponding ink mark is bleeding in through from the outside. A lack of ink there, where in 100E-2, very defined, much as the spot is on the inside surface, going to the outside. And in this photograph, the spot E is probably the best of the 8. Spot E, you can barely see it in between the yarns there.
And so what does that mean exactly?
It's bleeding through from the inside. Okay. 100E-1 again, the inside surface of the fabric. Fairly round, fairly uniform in color. As I said down there, the ink mark that I made on the outside is fairly uniform and defined. When it gets to the inside surface, it's fairly bleeding through and not defined. And on the outside surface, on 100E-2, the exhibit 100E-2, you can barely see the blood coming up between the yarns there, the lower part of the fabric. There's no blood in the upper yarns.
I'll show you what's marked as State's Exhibit 100F-1 and 100F-2 and ask you to describe what's depicted there.
Okay. 100F-1, again, is the inside surface of the fabric. Fairly uniform spot again. The ball marker barely showing through. 100F-2, again, is a very defined marker from the outside, but the blood spot is not as uniform and
Are those close-ups of the fabric of the shorts? Why? What is that supposed to tell the jury? That there's a blood spot there and there and there and there and there. You can't tell what part of the shorts that is from those pictures. It's an extreme close-up.
Blood in some of the upper copper yarns here.
So what does that mean?
Again, bleeding, the blood is wicking up from the inside surface. Okay, 100F-1.
You guys know, people kept asking about that. And I was like, why you guys keep asking that question? What are you talking about? I didn't even notice him. For days, I didn't even notice the guy in the cardboard box. I was so intently focused on this trial. Oh my God. I guess to make him not as noticeable so he doesn't interfere with the proceedings. I have no idea what that stupid box is for. But yeah, Judy calls it the puppet camera theater. That is what they're going to try to say. And when I was talking about confirmation bias, this is the test that was confirmation bias, because apparently Deaver did a test over and over and over to try to get, he put blood on a sponge and then hit it with either a blow poke or a crowbar or something long and cylindrical. He hit it to try to make that blood spatter go onto a pair of shorts. I don't know if he was wearing shorts or if they had him on a rig or something, but he did it numerous times. I don't know how many. And he finally got it to make that cast off pattern on a pair of shorts that matched Michael Peterson's. So that's not how testing works. You do it. Scientific testing has to be repeatable. You have to be able to do it and then repeat it and repeat it and repeat it. This was not a repeatable thing. Although you got chaos theory too, which says that things don't always happen the same thing every time. But in this case, I think it's more confirmation bias that he kept trying to get it to cast off in the same pattern. And he did it over and over and over again. So their test tried to recreate what happened that night rather than, I don't know, I didn't watch Dexter because it was on a premium channel that I didn't pay for. So I never watched it. My brother watched it. He loved it. He told me all about it, but I never watched it. So that was the problem with Deaver, and I forgot the name of the other chick. I think I said her name earlier, but I don't remember her name now. She was the one that designated the DNA testing be not done and it be sent to Deaver under Deaver's orders. So they're both problems, and then whichever cops told the medical examiner, not Dr. Snell, he was a forensic pathologist, but the actual autopsy chick, the cops told her to change blood loss to blunt force trauma. So this whole trial is screwed up. And this is one of the screw ups. And it cannot be retested because everybody's had their bare hands all over the evidence.
The inside surface again, fairly round spots, very uniform color. See the marker from the outside barely bleeding through. And the blood spot on the outside is corresponding pretty much the same way. It's barely showing through, not as defined, and lack of blood never fires.
See what's marked as State Exhibit 100G-1 and 100G-2.
Okay. 100G-1, the inside surface, and this shot is taken right at the hem. You see this stitch was put in there for the hem. Blood is on the inside surface of the fabric. The fabric is doubled in thickness, and in this case, this would be the corresponding outside area. The blood does not even penetrate the second layer of fabric. So it's very clear that the blood spot hit the inside surface and not the outside. Okay, 100G-1 is the inside surface. In the area right near the hem, you see the stitching here in the hem. The blood spot is fairly round, uniform. Corresponding area shows a lack of any blood because the fabric here is, again, low in thickness, and there's no bleed through or working through to the second layer.
Let me show you what's marked here as State Exhibit 100H-1, 100H-2, and ask you to describe this particular notice photograph.
H-1, again, is the inside surface of the fabric. Fairly round, uniform spot, uniform color throughout the stain. 100H-2 is a shot of the outside of the fabric. The stain is not as uniform, and there's a lack of blood in the upper yarns of this twill here. H-1 again, the inside surface of the fabric, a fairly uniform spot, very round, and uniform color. 100H-2 is the shot from the outside that corresponds to that spot, and blood is coming through, but it's not totally reached the upper fibers on that quilt.
Now, with respect to the analysis that you conducted of what's marked here as State's Exhibit 1, were you really concerned about any of the other areas other than those that you just described?
No, sir. I was asked to specifically look at those stains in question because of the location, which appeared to be unusual, and I focused my area of analysis on those 8 spots.
So you didn't conduct microscopic analysis of anywhere on the front?
No, the only person I believe that did any further testing on this was Agent Deaver.
Okay, and on the back, you didn't look at any of the other spotting?
No, just made a notation there was other spots there. And most of the staining from the outside, but these spots were from the inside.
And other than the spotting that you were able to locate coming inside the pants here, did you look at any other spotting with respect to?
I looked at the other spots here within this area that we were looking, the 8 spots, and noted there was some of the spots were so heavy, I couldn't determine if it was on the inside or the outside. So dense, the spot was so big, they corresponded pretty much in size and shape from one side to the other. For example, this large one right here, there was not much difference as far as the size of that spot. I focused on the ones that appeared to be larger in diameter or equal in diameter on the inside surface, but were more uniform in color across the stain and seemed to just bleed through to the outside.
So with respect to these larger spots, do you have an opinion as to whether They occurred on this article by striking the outside or by striking the inside. Do you have an opinion?
I couldn't give you one. I think there's lack of detail, and I got to have some evidence there to show or indicate that it is coming from one side or the other. In this case, there's a lack of that. Like if it was on the inside or the outside on those. Only on those 8 that I looked at.
And with respect to all of those, it is your opinion that they struck the surface of what's marked here as State's Exhibit 1 from where?
From the blood spots that you see here, the stains that we have pointed out, had to have been applied from the inside surface of the shorts. They could have not originated from the outside. The blood would have to have hit the surface from the inside.
With respect to your analysis of what you just described relating to what's marked as State's Exhibit 1, did you prepare a written report for that?
Yes, I did.
You take a seat. Let me show you what is marked as State's Exhibit 100 and ask whether you can identify that, please.
Yes, I can.
What is it?
It's a photocopy of the report that I issued in this case, dated February 18th, 2002. It bears my findings, the items submitted, the type of analysis requested, results of analysis, and disposition of evidence.
Your Honor, with respect to what's marked as State's Exhibit 100, we would move that into evidence at this time.
Hello.
And with respect to the result of your analysis, will you just read that into the record, please?
Okay. Analysis of item number 14, suspect shorts, revealed the presence of a pair of blood-stained khaki shorts constructed of 100% cotton twill fabric. Through close observation and macroscopic analysis of the stains present on the fabric, the majority of the stains were initially made from or applied to the outside surface of the shorts. Closer observation and macroscopic examination of the right rear leg surface of the shorts revealed the presence of 8 minute droplet-shaped stains that were initially made from or applied to the inside surface of the shorts. These stains have a range of distance from the bottom hem of the right leg from approximately 2.3 centimeters to approximately 17.3 centimeters. 2 of the 8 minute droplet-shaped stains were removed by Special Agent Susie Barker of the Molecular Genetics Section on February 15th, 2002 for further analysis.
And once you concluded the analysis of these shorts, did you have further involvement in this case as it related to additional analysis?
I just looked at a pair of test shorts that Agent Deaver had prepared, or I had seen.
Okay. Are you aware of the circumstances under which those test shorts were prepared?
Being relayed to me from Agent Deaver, the shorts.
Objections to the substance of what Agent Deaver said.
Sorry. Your Honor, I think that would be helpful for the jury to understand that the agent did receive test shorts and generally the conditions under which he received those so that he can describe his further analysis of that article.
Objection overruled.
I've received a pair of test shorts identified to me by Agent Deaver as a pair of shorts for one of the many tests he conducted as a pair of test shorts where I believe he was straddled over a source of blood and was inflicting trauma to that source. And these stains appeared on the surface and just wanted to have me look at it and see if it was consistent with what we were looking at.
Your Honor, may I approach the witness, please?
Yes.
Now let me show you what is marked as State's Exhibit T6A, T6B, T6C, and T6D, and ask whether you can identify these, please.
Yes, sir, I can.
What do they represent?
These represent the spots that I looked at. There's 3 spots of interest that I looked at. They're marked A, B, and C. T6A is just an overall shot of those spots. T6B is a shot of spot A. T6C is a shot of spot B and C. but particular interest of B. And then T6D is a shot of spot C.
At this point, we'd move into evidence of what is marked as State's Exhibit T6A, T6B, T6C, and T6D.
Did you want to be heard? Objections overruled. It's allowed.
Your Honor, with your permission, can the witness come down and show the jury what he
Yes.
did with respect to these all? Let me show you what is marked as State's Exhibit T6A, and if you would please describe to the jury exactly what that is.
Okay, T6A is a shot of the right rear area of a pair of test shorts that Agent Deaver delivered to me. It bears 3 marks, 3 points that I found of interest. Labeled A, B, and C. These were observed under stereo microscope as the other ones were. In this case, the spots we're looking at here, the ones I've seen are light, and there was no bleed through to the outside fabric at all.
If you'll come down and show that to this side of the jury as well.
T6A, again, is the right rear area of the short, right rear leg area, inside surface. Spot A, B, and C, 3 different spots that I picked out. That appear to be applied to the inside surface. As I said before, there was no analysis done to the outside because there's no bleed through to the outside section of the fabric.
All right, and I'll show you what's marked as State's Exhibit T6B and ask if you'll describe to the jury what is depicted in that photograph.
T6B is a photograph, a blown up shot of the area of interest described as A. And it's seen here on the inside surface of the hem with the two factors, two layers thick. T6B, again, is a shot of that inside right leg area. Spot A, blown up at this point here. And as I said before, there's no bleed through to the outside. So we have only another layer of fabric on the edge of the
I'll show you what's marked as State's Exhibit T6C and ask you to describe to the jury what is depicted in that photograph for us.
T6C, State Exhibit T6C is a blown up shot again of spot B, close up against the ruler here. And this is, with the interest on the inside, again, it's on the inside surface of the fabric of the right rear leg. Again, T6C, T6C is the inside surface of the fabric of the right rear leg. And spot B is seen in the photograph right about here. Again, there's no bleed through to the outside of the fabric.
I'll show you what is marked as State's Exhibit T6D, and if you would please describe that.
T6D is a blown up shot of spot C. We looked at. This is centered in the photograph, and this again is on the inside surface of the right rear leg. T6D again is a shot of spot C. It is on the inside surface of the right leg, and as I said before, there's no bleed through to the outside.
Now, with respect to your examination of the test shorts, as you just described it, were you able to draw conclusions then about the area of application, whether front or back, with respect to all of those?
Oh, as far as this test shorts, yeah, it's easier than the first pair of shorts I looked at, because I said before, all 3 spots here, there is no bleed through to the other side. The spots made invisible on the outside.
Okay,
But it was applied to the inside surface.
okay. As the 8 were, at least.
The 8 that I looked at, yes, in the defendant shorts.
Please take your seat. Now, with respect to any further analysis of the test shorts, The defendant shorts that are marked there, States Exhibit 1, were you involved in any other activity as it relates to the analysis?
No, sir, I wasn't.
Your Honor, I have no other questions of the witness at this time.
Cross this.
Yeah, could you approach briefly, Your Honor?
All right. Mr. Deputy, we'll take a 10-minute break, sir.
Of course, we stand in recess for 10 minutes, ladies and gentlemen, in the audience, if you please.
All right, this morning.
Thank you, Your Honor. Good afternoon, Agent Bendor. Let me follow up on something you were talking about when you were describing your training. You mentioned that you've been subjected to proficiency testing.
Yes, we're an accredited laboratory nationally, and one of the requirements for that is to be tested nationally.
Okay, and is proficiency testing where you're given a controlled sample, in essence, and tested on your ability to make the right analysis or the right identification?
We're given a control and probably in most cases, two unknowns. And we're asked to determine which unknown matches up with the control.
And whoever creates this proficiency testing already knows the answer, and they're testing your ability to reach the right result?
Yes, sir.
Okay, and that's a way of kind of checking up on your skills and the laboratory skills to make sure that the analysis you do in real life is properly done.
That's correct.
And this is done on a periodic basis, even with your level of expertise?
Yes. To stay proficient, you have to take a test at least every year. In some cases, we've taken 2 tests in a year.
Okay, and this relates to things like identifying fibers and the types of things you do on a day-to-day basis?
Yeah, I do fibers, explosives, arson, all the tests related to the areas of expertise that I work in. I also am one of the scan electron microscope operators, and we take proficiency tests not only in the 3 I mentioned, but also in that area. We test metals, look at their elemental concentration, and you have to test it, and it also tests your skills with a microscope.
Now, in this case, what you were asked to do is actually relatively simple, which is look at 8 identified little blood droplets on the shorts that were taken at the scene and see whether you could determine whether they were deposited on the outside of the surface or the inside of the surface.
That's correct, yeah.
And in this case, because of the wicking properties, it was relatively simple to determine that the given stains that you talked about were deposited on the inside and not the outside.
That's correct.
In fact, for I think it was G, where it's on the hem, it hadn't even wicked through, so it had to have been applied to the surface where you see the stain.
Yes, sir.
And so what we know from that is that whenever those droplets were deposited, that part of the shorts was open or exposed.
Open or exposed to some source of blood.
Right. And any position in which somebody wearing those shorts would have the back of the legs open, because they're baggy shorts, could account for the legs being open at the time the blood was deposited.
Yeah, it'd have to be open. It could be against the skin.
Right. So,
for example, if you're sitting down, the fabric would be up against the leg, where if you were standing with the legs positioned properly, it would blouse out the back.
Now, of course, if you were sitting and had your legs propped up, for example, if you sat on the floor and had your knee up, then the bottom of the shorts would be open.
I don't know. I'll admit it. I'd have to see the individual.
Okay. When you talk about sitting, for example, like the way I'm sitting right now, my legs are flat against the chair. I don't know if you can see that, but maybe the same way you're sitting. Obviously, the back of the leg is closed. But if I were to sit on the floor, for example, and prop my legs up, depending upon the shorts, the bottom might sag down and be open, or the back, rather.
I'd have to see the shorts on an individual. Agent Deaver did more of that. It's more extensive testing as far as putting on shorts and put them in different positions.
Okay. In fact, I take it you never put on any of these shorts or tested how the legs.
No, sir. All the spatter analysis in this case, I basically did a technical assistance for Agent Deaver in his blood spatter analysis.
Now, the test shorts you were given that you talked about, the stains that you found in there did not go as far along the leg as the shorts that you first tested.
From what I recall, they didn't go up as far as point D does.
Right, and point D was 17 some odd centimeters, 17.3 or something?
Something like, 17.3.
Is that about 8 inches for those of us who don't use it?
2.5, 3 centimeters per inch. I mean, if you do the math, it'd be basically that.
Right, Right, and on the test shorts, if I could approach. Here. You know what you measured on the test shorts where the highest stain was found?
No, I didn't know. I just made some observations about those spots, marked them.
Okay,
If I had to guess, you're looking at something. The
B
ballpark.
is the highest.
B is the highest
Okay.
of the ones that I see there, and there are possibly 5 to 6 spots on the inside surface.
Okay, and B is significantly less than 8 inches up the leg.
Right, it's not as far as point D.
Right.
No.
And by the way, these stains that you saw on the test shorts had not wicked or bled all the way through to the other side.
Right.
And would that indicate there was less blood deposited in terms of how much wicking would take place?
It could be a number of factors, and really you need somebody with some blood spatter experience to give you that opinion. But that could be one of the reasons. There's less blood there. Yes, okay. Smaller droplet of blood.
Okay, because it takes at least some volume of blood to have enough to wick through that twill and show up on the other side.
Yeah, for example, the spots we looked at earlier, spot E, I think, was the one that barely got through to the.
Well, they can't because they didn't do DNA testing on it. They're just assuming that it is Kathleen's blood.
Outside, that was probably a smaller spot and less blood to wick into the fabric.
Okay. Now, other than determining that the inside surface of the back leg was exposed at the time the blood was deposited, you did no further analysis of those shorts?
No, I did not. Agent Deaver took the shorts. Those were returned to him, and he did some further measurements and testing.
Okay. Anything else? Thank you. No further questions.
You read the rag.
No, sir. All right, so you can come down.
May he be released, please?
Yes.
Thank you.
May we approach the bench, please?
Yes.
Deaver. Lying liar that lies. Deaver.
Yes, sir. On the 11th, we had prepared and agreed on a stipulation of fact as it related to the collection of items out of what is marked as State's Exhibit 28A. All of those had previously been identified.
Who's Michelle? Who's Michelle? Just some random person you made up?
The bench conference, we addressed items that would be allowed to remain in what's marked as State's Exhibit 28A. There was some discussion about whether the state would ask that certain estate documents remain in this envelope. We have amended our stipulation to indicate that although there were estate documents with this collection of hard copy documents in what's marked as State's Exhibit 28A, that they are no longer there, just as other items were that we discussed at the bench. Mr. Sachs is making one final modification that the defense wanted, and you'll have that in a second. I think the language is not agreeable.
Yes, there was a date being inserted in light of Your Honor's ruling. We've agreed that the generic description that will be in it.
And once that's executed, we'd ask that these items as constituting State's Exhibit 28A, as it now exists, to be allowed and presented to the jury, published to the jury, and also the photographs that are referenced in the stipulation, those being what's marked as State's Exhibit P150, P151, P152, and P153.
All right. Other than the previous objection, we've argued that.
All right.
With respect to the items that were pulled from what is marked as State's Exhibit 28A, I've put those in a separate envelope with a notation that they've been identified as part of State's Exhibit 28A, although they're not being considered as part of it at this point based on the court's ruling and the stipulation that's been entered. Mr. Maher has looked at this and is satisfied that the items in this separate envelope are what we've been discussing. I'll hand those to the clerk with your permission so they can't get mixed in.
Yes, sir. It's allowed. All right, so how are we proceeding, Mr. Howard?
Your Honor, if you could inform the jury of the stipulation and then allow me to publish what now constitutes State's Exhibit 28A to them along with the photographs.
All right, what do you mean inform them of the stipulation?
Your Honor, if you could just read the stipulation to them.
All right. All right, would it be your intent, I will read it to the jury, would it be your intent that they receive a copy of it or not?
No, sir, we can make copies if you think that's appropriate. I was not going to do that.
I don't have an opinion one way or the other.
All right. If you'll just read it, I think that'll be sufficient.
Do we have other matters to deal with?
No, sir. No.
All right. I take it your next witness is going to be the SBI agent?
Yes, sir.
I just want to make sure because at certain points you and Mr. Rudolph have not had a meeting of the minds as to when he has an opportunity, if he's going to object. You have some kind of understanding as to when your witness will make some, or have some opinions that Mr. Rudolph wishes to be heard on?
Yes, sir. I'm aware of two motions. One relates to the Daubert question. The other relates to certain experiments that were conducted by Agent Deaver. It's my intention to call him to qualify him as an expert in the field of bloodstain analysis. I don't think there, at least according to the motions, there doesn't seem to be an objection or an issue as to that. I would then have him describe chronologically what he did. I will then have him specifically go back to the location of the scene and describe what he located and where he located it without interpretation. I would have him do the same thing with respect to the clothing that he examined. And at that point, I would ask him whether he conducted a series of experiments. I assume that based on the motion that's pending, that would be the time that we would have to deal with at least one of those issues raised in the motions. And I would like to, at the same time, deal with the question as it relates to Daubert, because once I finish with his description of the experiments that he conducted, I would then move into what his final conclusions are as it relates to all that he saw.
All right, Mr. Rudolph, is that procedure acceptable to the defendant?
Yes, sir.
All right, unless we got other matters, Mr. Deputy, you can bring the jury in. Good morning, members of the jury.
Good morning.
The defendant in this case and the state of North Carolina have entered into a stipulation that I will read to you at this time. As I've told you, I believe, on at least one occasion before, a stipulation is an agreement between the state and the defendant that a certain group of facts do exist and that the proof of those facts need not be further established by either one of the parties. And the stipulation reads in part as follows: now comes the state of North Carolina and the defendant to hereby stipulate and agree to the following testimony, which would have been elicited from Ann Socosio as a called witness in this trial of this matter. Number one, Ann Socosio is employed as a supervisor in the Forensic Services Unit at the Durham Police Department. Number two, on December 10th, 2001, Ms. Socosio was one of the technicians assisting in the collection of evidence during a search of the defendant's home at 1810 Cedar Street, Durham, North Carolina. Number three, during that day, Ms. Socosio assisted then homicide investigator Mike Harris and collecting evidence from the study within the defendant's home. Number 4, Investigator Harris located and retrieved numerous paper writings, folders, and envelopes from a drawer located on the right side of the desk in the study. Number 5, Investigator Harris handed the
That's the way my dad said envelope, and I have never in my life heard anybody else say it like that. Envelope. My dad called an envelope an envelope, and I would correct him every time, and he'd say, I call it an envelope. I've never heard anybody else call it that before. Uh-oh. What'd I do? Dang it, Debbie.
All right, unless we got other matters, Mr. Deputy. Called witness in this trial of this matter. Number 1, Ann Socosio is employed as a supervisor in the Forensic Services Unit at the Durham Police Department. Number 2, on December 10th, 2001, Ms. Socosio was one of the technicians assisting in the collection of evidence during a search of the defendant's home at 1810 Cedar Street, Durham, North Carolina. Number 3, during that day, Ms. Socosio assisted then homicide investigator Mike Harris in collecting evidence from the study within the defendant's home. Number 4, Investigator Harris located and retrieved numerous paper writings, folders, and envelopes from a drawer located on the right side of the desk in the study. Number 5, Investigator Harris handed these items directly to Ms. Socosio, and she packaged them in the envelope, which is now marked as State's Exhibit number 28A. Number 6, State's Exhibit 28A included at the time of collection estate planning documents prepared in 1998 for the Petersons by an attorney, but not executed. It also contained a note from Fred Atwater to Kathleen Peterson and a check from Fred Atwater to Kathleen Peterson for child support expenses. These documents are no longer included in this exhibit by agreement. Number 7, Investigator Mike Harris is now deceased. Number 8, Ms. Socosio also located a bottle of window cleaner among plastic containers in a kitchen island lower cabinet. Number 9, State's Exhibit number P150 through P153 are fair and accurate.
Apparently, they're stipulating to things found that pertain to Kathleen's first marriage and child support stuff for Caitlin. I guess because it was collected as evidence. So it was paperwork and envelopes and stuff about child support that doesn't pertain to Michael.
Photographs of the study of the defendant's home and the lower kitchen cabinets in the island and under the main sink. Number 10, during the same day, December 10, 2001, Ann Socosio observed what appeared to be blood on the handle of a cabinet housing wine glasses in the kitchen of the defendant's home. Number 11, Ms. Socosio took a swabbing of the stain, which swabbing was ultimately forwarded to the State Bureau of Investigation Laboratory for further analysis. And that is the agreement entered into by the attorney for the defendant, Mr. Rudolph, and Mr. Harden, the district attorney. If counsel will approach the bench to see if you have any corrections or additions to add to me. All right, there being no corrections.
Sure, there are no questions on part of the state. And just so the record is clear with this.
Well, to be fair, it is written. I mean, if you read it like it's written, it's enveloped. And it envelops the paper you put inside of it. So, envelope. Well, does envelope have an E on the end? I don't know. But yeah, my dad always, and another thing he did that drove me crazy, like, I guess it's just with names, so. Are there words with TH where you don't pronounce the diphthong? Like the name Teresa, Beethoven, because I play the piano very poorly, but growing up I took piano lessons, and when I played Beethoven, Daddy always called it Beethoven. And I said, Daddy, it's not Beethoven, it's Beethoven. Well, but there's an H there. And the name Teresa, he always pronounced Theresa. It's not Theresa, Dad, it's Teresa. But why are they stipulating to the blood smudge or whatever under the cabinet with the glasses? They've been talking about this stupid blood stain the whole entire time on the glasses and on underneath the cabinet where the glasses was, and now they're stipulating. Why are they stipulating to it now when they keep talking about it? They've talked about it for days, and now they're stipulating to the fact that there was a blood stain there. Good Lord. Yeah. And there's an episode of I Love Lucy. I can't remember. I think it was, she was still pregnant. She hadn't had little Ricky yet. And they were talking about reading him a bedtime story, and that Ricky couldn't do it because he didn't know the English language well enough. And they were reading like a baby book, and it was like through and bow, and there was another O-U-G-H word, because all three of them are pronounced differently, but they all end in O-U-G-H. And yeah, the English language is hard. It is. It's really hard.
Stipulation, we at this time would move into evidence what is marked as State's Exhibit P150, P151, P152, and P153.
It's allowed.
And we'd ask that these all be passed to the jury this time.
It's allowed.
Nor also, so the record is clear with what is now constituting what's marked as State Exhibit 28A, we'd move those contents and that envelope into evidence this time.
It's allowed.
For the record, sir, please state your name.
My name is Peter Duane, D-U-A-N-E, Deaver, D-E-A-V-E-R.
How are you employed, sir?
I'm employed as a special agent with the North Carolina State Bureau of Investigation.
Exactly what is your position there?
I'm presently assigned to the Diversion and Environmental Crimes Unit of the SBI, and as that, I function as the Eastern Coordinator for
I'm a lying liar that lies. That's my position.
clandestine laboratory investigations. I also have responsibility for training SBI agents in the area of bloodstain pattern analysis. I'm also the lead instructor in that area.
Now, if you would, please describe to the jury what your formal educational background is.
I have a Bachelor of Science degree from North Carolina State University in the area of zoology, which was the pre-medical curriculum at the time I was at the university.
Now, with respect to relevant previous employment at the State Bureau of Investigation, if you would please describe what that has been generally.
I was hired in 1985 to the crime laboratory in Raleigh as a forensic serologist. I entered the 17th SBI Academy in the spring of 1986. Upon completion of that, I reported for duty at the crime laboratory and was assigned to begin training as a forensic serologist. Shortly after reporting for duty, I was assigned by my supervisor to also begin training in the area of bloodstain pattern analysis. I was assigned to a person to supervise me in that area to begin that training, and then I was given certain classes to attend around the country for that.
If you would, please just generally describe what those classes have been like and what was involved, and generally what the time frame was that you took those classes.
The first class was sponsored by the Midwestern Association of Forensic Scientists in October of 1987, and that class dealt with bloodstains, looking at them, experiments that are involved in producing bloodstains, and how to interpret those, and how to analyze scenes for blood. I then was assigned to go to a class sponsored by Valencia College in Orlando, Florida, which was an advanced school in bloodstain pattern analysis. And it was much the same, but more in depth, working more with crime scenes specifically instead of the basics. The North Carolina State Bureau of Investigation sponsored a school in October of 1988 that I attended, and it was again along the lines of experiments and working in crime scenes that had been set up to look at crime, to look at bloodstains.
And with respect to the educational background and the classwork that you did relating to blood stain pattern analysis, was there also a training program?
Yes, there was. As I said before, I was assigned to a person who was already an expert in this field in the crime laboratory. Even in 1986, I began to sit with him and to look at cases that were assigned to him or that he received, and to basically watch him as he began his work. After I started going to the classes, then I continued to work with him on cases, go to scenes, look at clothing in the laboratory, and I also began to do research on my own under laboratory conditions. And that is to take blood and to produce blood stains and to study those. That continued until about 1988. Sometime late in the year 1988, I began to do cases on my own, and that were reviewed by this same person who was an expert.
All right. Now, with respect to the field of blood stain pattern analysis, what types of crime scenes would you be called on with it relating directly to that field?
Well, I would be called to provide assistance where blood had been shed in a crime scene, and what was said about, or what could be said about those patterns in the scene would be in doubt. In other words, there's a lot of times when individuals can look at a crime scene and they can pretty well tell from the blood spatter or from the blood that's there what has occurred. I would be called in to provide assistance for when they can't say what it is, or when the explanation of how those bloodstains came to be is in doubt in some way.
Right. Now, you've indicated that you went through a training program and went to numerous classes and had training along the line of blood stain pattern analysis. I think you said for about a 2-year period. Is that right?
Well, it would have been, I was in the academy for some time of that, so it would have been maybe a year and a half or so, yes.
All right. Now, with respect to the classes that you have taken In that time frame, would your training and research have ended there, or would you have continued that through some period of time to further develop your expertise in the area of bloodstain pattern analysis?
Well, that would certainly continue. And when I started taking cases in 1988, they were very simple cases that were assigned that the individuals at the SBI, my supervisor, and the other blood spatter experts there would, say that I had the experience to be able to accomplish. But I continue to do research and continue to do that today as far as doing testing and things to look at blood stains. And of course, the more scenes that you go to, the more experience that you receive also.
Now, have you taught courses yourself in the field of blood stain pattern analysis?
Yes, I have.
If you would please generally describe to the jury the types of courses or lectures that you have given in this specific field.
Well, I am the lead instructor in this with the SBI, and as such, I have taught 2 basic classes. And what I mean by that is that basic principles of bloodstain pattern analysis have been taught, and then 1 advanced class. The individuals taught there were about 40 individuals. I presently am responsible for the training of about 20 individuals who are in various stages of training in this area at this time. I also lecture frequently on this subject. I've taught homicide schools for the SBI and for other agencies around the state in the area of bloodstain pattern analysis. I have taught medical groups, basics in this area also, and have lectured to district attorneys' conferences in this area.
Now, with respect to your work in the field of bloodstain pattern analysis, I think you indicated you started actually working cases in 1988. Is that right?
That's correct.
And from that period to the present, approximately how many cases of bloodstain pattern analysis or evaluations have you actually worked?
I don't know for sure, but it would be somewhere around 200 that I have written reports on myself. Now, that doesn't include the number of cases that I have looked at as part of my training, and I continue to provide help to others who are in training. In other words, I'll help them with their cases, and I wouldn't necessarily write a report on that. I also provide help to departments around the state and individuals who may be bloodstain pattern experts, or just detectives who want to know some information about the scene and as far as the blood spatter is concerned.
How many cases have you been involved in from the perspective that you just described then, could you say?
Well, that would be several hundred more, so maybe 500.
Okay. Now, with respect to your job at the State Bureau of Investigation in this particular field, I think you said you were the lead instructor.
That's correct.
How many other persons at the State Bureau of Investigation have the expertise at the level that you do?
At my level would be one other.
Okay, and who would that be?
That would be Dennis Honeycutt.
All right. Now, with respect to continuing to further the field and develop your expertise, when you work a case, do you all collaborate, or is there peer review with respect to that?
Yes. Well, first we have we have a specific training program in the SBI where those who are on our consider a training committee will review work and provide assistance to those who are in training. Also, when we are doing our cases, then we have a process that we have review, and Dennis Honeycutt and I provide review for each other.
All right. And is that standard? Do you do that in every case that's actually worked and a report prepared?
No. That would be done on cases that are a little bit more involved. If it's just simply telling what kind of patterns are in a scene, a real simple case, then we wouldn't necessarily do that.
All right. Have you had the occasion to testify in the courts of North Carolina as an expert in the field of bloodstain pattern analysis?
I have.
On how many occasions?
It would be approximately 60 times.
All right. Your Honor, at this point, we would tender Agent Deaver as an expert in the field of bloodstain pattern analysis.
I have questions about disqualification, Your Honor.
All right.
In front of the jury is fine.
All right. Let me have you all push me. Yes, sir. Let me make sure first, Mr. Rudolph, you are finished with your qualifying questions, Mr. B. All right. Yes, sir.
Thank you, sir. Good morning, Agent Deaver.
Good morning.
You and I have met before, correct?
Yes, sir.
I'm just going to ask you some questions about the subjects that Mr. Harden has asked you about already. But let me start with a general question, which is bloodstain analysis involves the application of various scientific disciplines. Fair?
Well, there are some scientific disciplines involved, yes.
For example, physics.
Yes.
Chemistry.
That's correct.
Biochemistry.
No.
Excuse me?
No, not that I'm aware of.
Biomechanics.
No.
And I think you said that you majored in zoology.
Zoology, yes.
Yes. Of course, none of your courses related to zoology had anything to do with bloodstain analysis.
Well, no, that's not entirely true. As I said before, zoology it's not how to take care of zoo animals. It's actually the study of life, which would include blood, anatomy. I had a very tough class on comparative anatomy, which is the study of the body and the systems. And yes, a lot of that coursework did apply to what I do now, especially in the area of math, chemistry, those kinds of things.
Well, my question was, you didn't have a course in bloodstain analysis, right?
No, that was provided as specific training as part of my SBI employment.
And did you take physics courses?
Yes, I did.
Did you take advanced physics courses?
Well, I took physics courses. I don't know what advanced physics courses there are. I took what was required for my curriculum.
Well, do you know how many physics courses you took?
I don't remember.
Did you take any courses in biochemistry?
Yes, I did. And as a matter of fact, I have completed several advanced courses in biochemistry after my degree.
And where did you complete those?
North Carolina State University.
All right. And did you get a graduate degree in any particular science?
No, I did not.
No PhD in physics?
No.
Or chemistry?
No.
Or biochemistry?
No.
No master's in physics?
No.
Or chemistry?
No.
Or biochemistry?
No.
How about courses in scientific method?
Scientific method would be included in many of the courses that you take because they're science courses, and that's a part of doing it.
Well, but you know that in some colleges they actually teach courses on the scientific method, right?
I don't know that. I know that I've had scientific method in many classes. I don't know about any specific courses taught in that.
Statistics?
Area. I'm sorry?
Statistics?
Did I take statistics?
Yes, sir.
I had statistics in one of my math classes. I don't know if it was a statistics course or not.
Now, the courses you took in, I think, advanced biochemistry, when were those taken at NC State?
I don't remember for sure. They would probably have been in the early 1990s.
And how many did you take, do you know?
I do not remember.
Now, you talked a little bit about your training in particular in blood spatter, right?
Yes.
And I think you said that you had 2 training courses?
3.
Three, I'm sorry. The first one was back in 1987.
That's correct.
And that was a 40-hour course, correct?
That's correct.
1 week.
That's correct.
And there were no lectures on physics.
Well, indeed, there were lectures on the physics of bloodstain pattern analysis and how physics applies to it. There absolutely were.
And most of that course was throwing blood against various objects and seeing what kind of spatters would be created, correct?
Well, throwing blood would not be quite the correct usage of terminology, but we would create patterns in various methods, and blood would come in contact with things, and then we would study the patterns.
Right. And that was a basic course.
That's correct.
Mr. Rudolph?
Yes, sir.
I want you to stop briefly right here. Several members of the jury have informed me that they need to take a break, and I want them to listen to
Yes, sir.
the evidence. So, Mr. Deputy, let's take a 5-minute break.
Of course, we stand in recess for 5 minutes.
All right, Mr. Rudolph.
Thank you. Agent Deaver, I think when we broke, you had indicated that the course for the Midwest Association was that the course was a course in basic blood spatter interpretation, right?
Yes.
And then you took a course in advanced blood spatter interpretation, correct?
That's correct.
That was taught by Judith Bunker, right?
It was, yes, Judith Bunker and Associates, I believe, were involved in that teaching.
And do you know that Judith Bunker didn't have the qualifications that she claimed to have?
I did not know that. That's a class that I didn't choose for myself. My supervisor sent me to that school.
Well, yeah, you know it now, though, right?
No, I really don't know that myself.
Well, you certainly heard that in the profession, haven't you?
Objection to whatever is heard. Overruled.
Someone had told me that Miss Bunker, who was the instructor of the advanced school, had some problems. I don't know what the nature of those problems is.
So you never heard that she had falsified her background and didn't have the expertise that she claimed to have?
No, I haven't. No, sir.
Do you know whether she's still doing blood spatter interpretation anywhere in the United States?
I do not.
Now, then I think, now that's all the formal training you've had. Of course, the second course that you took, the advanced course up in Raleigh, you actually had invited Miss Bunker to come up and teach, right?
I didn't. That was, again, sponsored by the SBI.
Right. Was that on your recommendation?
I don't know how that came about.
In any event, apparently someone with a problem was the person who then came up and taught the SBI blood spatter interpretation, right?
I don't know if she had a problem teaching blood stain pattern analysis or not. I don't know what the nature of her problem.
Someone with a problem? Didn't you say she didn't have the correct education? Don't be so vague, Rudolph. A problem. Isn't the courtroom where you try to get at the truth? Why are you going to be vague like that?
Was or is. Looking back on the two classes, I found those classes to be...
Sir, I didn't ask you how you found the classes.
Objection is entitled to
I'd ask the witness to be instructed to answer my question, Your Honor.
Okay, the objection is sustained. Ask your question over.
Thank you. What happened was that Miss Bunker came up with whatever problem she had, and she was the person who instructed the SBI, including you, in 1988, correct?
I don't understand the question because I don't know that Ms. Bunker had a problem.
Okay. So
if the question is that Ms. Bunker taught the class in 1988, she did.
now, other than those classes, two taught by Miss Bunker and one in the Midwest, the last one of which was 1988, correct?
That's correct.
You haven't taken any other courses?
Well, actually, every class that I teach, I participate in also, and indeed the SBI has given me credit for those classes. Even though I'm teaching them, I'm actually involved in doing the work in those classes also. And so I have received credit for doing those. I don't list those as classes that I attended because I'm teaching them all.
What? Are you kidding me? He gets credit, like class credit, for the classes that he teaches? How is that ethical? Seriously, how is that ethical? No. When you're in a class taking a subject. You're supposed to be learning something that you don't know. No, that's not how that works. If you're teaching a class, you already know the material because you're teaching it. Continuing education is supposed to be you learning something that you either don't know, or it's to refresh something that you do. No, you don't get credit for continuing education when you're the teacher. Oh, good Lord. What is wrong with North Carolina? That's ridiculous.
So, and that just seems a little odd, but those classes are such that you continue to do research, you continue to make patterns and to study those. And every class that I have taught, I have also participated in that work. So it's like taking a class again.
My question was whether you've attended courses taught by others in the field, sir.
Well, I have other instructors who are teaching when I'm in those classes, so I'm actually learning from them also.
I see. Is that Mr. Honeycutt?
He's one of them, yes.
Who else?
Mike Garrett is one of my instructors in that area, and trying to think of who else I have as instructors.
Now, did you train Mr. Honeycutt?
Did I train Mr. Honeycutt? No.
How about Mr. Garrett?
Yes, I was involved in his training.
Now, who trained Mr. Honeycutt?
I couldn't answer that.
Well, I thought you were the lead trainer.
Well, Mr. Honeycutt and I were in training at the...
Yeah, clinicals would be different. That would be different. But that's not the case in this.
Same time, as Mr. Honeycutt was in another area of the state, and we were being trained as bloodstain pattern analysts at the same time, and have worked very closely together at times in the area. But I don't know about his training.
Yeah. Have you attended any courses? There are.
I mean, this would be like me teaching a continuing education course to other nurses and saying, okay, I've done my continuing education on this subject because I taught it to people. That doesn't make sense. No, you don't get continuing education credits for something that you already know. You have to actually take a class yourself. You don't get credit for teaching a class.
Numerous courses offered around the country in bloodstain interpretation, correct?
I would assume so.
You don't know?
I don't know.
Well, you've heard of Herb McDonald?
Yes, I have.
Up in Corning, New York?
Yes.
That's sort of the leading place. He's the sort of the father of modern bloodstain interpretation, isn't he?
I know that he, very early on in the history of bloodstain pattern analysis in the United States, did some work in the area. As far as being the father of it, I don't know that.
You've not gone up there to take any of his courses?
No, that's true.
Have you taken, other than going to Orlando, Florida in 1988 and to Michigan in 1987, have you gone to any other blood spatter course in advanced blood spatter since 1988, other than the ones that you yourself have taught?
No.
Now, I think you said that other than these courses, your training consisted of sort of on-the-job sort of training?
Well, no. I mean, you can't go out there and start doing it if you don't know how to do it. It would be a matter of working on your own to do the experiments and to do the work in the area.
And that would be with Mr. Spittle, Agent Spittle?
That's correct.
And so when you said you were working under someone who was already an expert, it would be Mr. Spittle, Agent Spittle?
That's correct.
And what was his training? Where was he trained?
Objection, this is far afield of this witness's qualification.
Your Honor, you get.
I really don't know. I don't remember what his training was. I know that he had already testified as an expert in the area and was the lead person in this area at the time that I was hired with the SBI.
You have no idea what his training was in blood spatter?
No.
And you certainly weren't in a position at that point to evaluate how competent he was when you were starting yourself?
No, I wasn't there to evaluate or make judgment on his work. No.
Now, we heard last week, or maybe it was Monday, from Agent Bender, about how the SBI lab, by the way, you're no longer assigned to the SBI laboratory, are you?
No, I'm not.
You're not assigned to the serology section?
No, I'm not.
You're not assigned to do blood spatter analysis?
Yes, I am very much continuing to do blood spatter.
I didn't ask you whether you were continuing to do it. That's not within your formal job description, is it?
You know, I don't remember if it's in my job description or not, but I have many assignments in the SBI that I'm expected to accomplish, including instructor in a lot of other areas, and a lot of other things that I have to do.
Now, Agent Bender testified that in order for the SBI laboratory to be accredited, he has to go through something called proficiency testing. Are you familiar with that?
Yes, I am. I completed proficiency testing in serology when I was in the laboratory.
Okay. And what proficiency testing basically is, for example, as he described it, was he's given some samples, a control sample and a test sample, and he's asked to figure out what they are, right?
Basically.
And that's, no matter how experienced he is, he has to do that every year to see whether he really knows what he's talking about, right? In layman's terms.
Well, I don't know exactly how their program works, but the proficiency testing program does something similar to that. I'm not familiar with that anymore.
And what is the proficiency testing program for blood stain analysis?
I'm not aware of one or a requirement for one. As a matter of fact, the ASCLAD, which is the organization that requires those of laboratory, does not require for blood spatter, blood stain pattern analysis that they do one.
Well, do you know why? Do they not consider it a science?
I don't know why.
Well, if it's a science, there ought to be proficiency testing in it, shouldn't there?
I can't say if that's the criteria for having proficiency testing. I don't know. I can't answer that.
Well, it'd be pretty easy to do proficiency testing in bloodstain analysis, wouldn't it?
Oh, I think absolutely not.
Oh, well, for example, if we put up on the screen a bloodstain, sort of like what Agent Bender had to look at, a sample, and asked you as the lead instructor what that was. You couldn't tell us?
Objection.
Overruled.
Are you asking me what that is?
Yes, sir. What kind of spatter that is?
Sir, that would a picture up on a wall would not be something that you could just automatically come to some conclusion about.
Well, can you tell me, for example, if that's impact spatter or satellite spatter or some other kind of spatter?
No, I can't.
Why not?
Because I don't know what context that picture was made in.
You can't tell just from the drops?
No.
Can we go to the next one? Yeah. Can you tell me what kind of spatter that is?
From a picture, no.
Can you tell me whether there's any difference between whatever created that and whatever created the first spatter?
No, because what may have happened is someone may have taken a picture, different pictures of the same pattern, which may have produced the same thing. And that's very, that would be extremely dangerous to be looking at pictures and determining what types of patterns they are. That would be very dangerous.
Well, it would be dangerous to look at pictures to try to determine what the patterns are?
No, it would be dangerous to take pictures that you don't know what the origin of them is to make determinations as to what kind of patterns they are.
Well, you've done research. You said you've done research in blood spatter, right?
Yes, sir.
You've created various kinds of patterns.
Yes, sir.
From things, you know what satellite spatter is, right?
Yes, I do.
That's when something drops down and it creates its own spatter, right? Or alternatively, if it drops into a pool of blood and creates a satellite spatter, right?
Basically, that would be generally true. And if one were to take a picture of a piece of that satellite spatter and stick it up in front of you, you may totally miss it.
Well, let's go to the next picture. That would be 20. Can you tell me whether that, for example, is impact spatter or satellite spatter or some other kind of spatter?
Step, if you take the jury to the deliberation room. Yes, sir, Mr. Harper.
Well, I guess we can stay here all day and look at pictures of whatever that is supposed to be without context. This witness can't answer that. And I think he's indicated that with the last two questions, or last two photographs have been put up there. I don't think that's what this is about. It's not reflective of his qualifications. I thought that's what this voir dire was about, not whether he can identify some out of context photograph that's presented to him.
Mr. Rudolph.
Judge, he's been presented as an expert. He was presented as someone who conducts experiments, looks at various kinds of spatter, can tell various kinds of spatter, and I think this jury is entitled to know what the limits of his knowledge are, and I think this court is going to have to make a decision about whether or not he truly is qualified to do what he's claiming to be able to do. And I've got 3 more photos to show him. These are all different kinds of spatter, and I think the jury is entitled. We're going to be getting into things like impact spatter versus satellite spatter versus other kinds of spatter, and I think the jury is entitled to know whether he can tell it or he can't tell it.
Well, the problem, of course, as you know, Mr. Rudolph, is that you have a right to cross-examine him about his training and about whether you think he's an expert. The state has made a profit at this point, and either their profit is going to be accepted by the court or it's not. Even if it's accepted by the court, that only means that based on his training and his expertise and that he can give something testimony helpful to the jury, then he passes the threshold of giving his testimony. It doesn't mean that he's going to be believed necessarily. It doesn't mean that the court is going to assign any weight to his testimony. I fully expect that if he qualifies, that you're going to give through your cross-examination, which you're giving now, some very good reasons why you believe the jury shouldn't give him much weight. But all of us understand that it's a legal issue.
Yes, sir.
As to whether he testifies
absolutely
as an expert, and it's not a factual issue for the jury.
Absolutely, I understand that completely, and my questions are all going to his qualifications to give the kinds of opinions that he's going to be giving. He's going to be testifying based on his report that certain kinds of spatter on an area no bigger than that are impact spatter, for example, versus some other kind of spatter. And my argument is going to be at the end of this that he's not qualified to do that for various reasons, including the fact that he's never been proficiency tested. So
okay, but I just don't want us to do your cross-examination twice.
Oh, no, absolutely not, Your Honor.
Bring back. It's overruled. Yes, sir. Thank you.
You can't tell us whether that's impact spatter, satellite spatter, or some other kind of spatter, correct?
I can't even tell you if that's blood.
And, well, assuming it's blood, sir, assuming that those pictures come from a textbook, you can't tell us what kind of spatter they are, can you?
The pictures that would be given to me in a textbook, I would have to take the author's word on that he had done a proper study of those and had represented them correctly. To show me that picture without his representation, I have no basis for saying whether it's blood or whether it was taken out of context or if it's a piece of a pattern or what exactly it is. That would be really, really bad for a bloodstain pattern analyst to do.
My question, sir, is looking at that picture, can you tell us whether that is from an impact or whether it's from a satellite? Can you tell us?
No.
Yes, next. Same question with that. Can you tell us what kind of spatter created that?
No.
Next one. Can you tell us what created that?
It doesn't look significantly different from the last one that I said no about.
You said it didn't look significantly different. So if it in fact was caused by something very different, then you really aren't recognizing that. Is that right?
Unless I had the author's, whatever his caption was, I wouldn't be able to tell that.
Same with that one?
That would be correct.
So are you saying there's just no way to do proficiency testing for bloodstain analysts?
It would be proficiency testing for bloodstain pattern analysts would be difficult. And for that reason, no one has really agreed on a method for accomplishing that. And I don't know for sure, but I would assume that that's the reason that ASCLD, the laboratory people, have not agreed on a method for accomplishing that either. Certainly, there would be tremendous difficulty with showing someone a picture and trying to do a proficiency test on that when bloodstain pattern analysis is a totality of work, of study, of understanding the principles that are behind it, and of looking at the pattern as a whole. Where it is and how it came to be are all necessary to be able to accomplish this work.
Well, you don't need to know how it came to be to determine what it is. Your job is to figure out how it came to be, isn't it? Isn't it?
Well, certainly it is. What I mean by how it came to be is what's the history behind what you're showing me as a picture. That's what I mean when I say how it came to be. What is the context of this picture?
Well, let's forget about pictures for a second. How about, so you do experiments with blood spatter, right?
Yes, I do.
How about if a trained expert took a scene and did various kinds of blood spatter, some impact, some satellite spatter, some expirated blood, and you were given the scene to look at? Could you do that?
Now we're getting somewhere. That's actually done in the classes that are taught and that we teach. And the way to accomplish that is to videotape the method for producing those stains.
Yeah.
And we actually build rooms and things, and we go in and do that. We videotape the production of that, and then we send our students in to work those scenes. And that is a method for accomplishing somewhat what's being asked here.
Excuse me, sir. My question is...
Objection. He was finishing the explanation of the question that was asked. Steps, if you take the jury to the...
Well, as I indicated, it's not a jury issue. this issue as to whether he can testify as an expert witness is, first of all, a legal issue. I don't mind doing it like this because even if I find that he's qualified, you're going to have a right to cross-examine him in front of the jury. But this is way more information than I need to make the decision that I have to make. And I would prefer you all ask him questions you want to ask him, and make any possible argument. But remember, you're objecting, and this is what the consented defendant that is done in front of the jury. I would have preferred to not do it that way, but that's fine.
I would ask the witness be instructed to answer the question that's asked and not go into a lecture on whatever subject he'd like
Well,
to.
that's the other reason that we're talking now, because as I said, it's not a jury issue. So if this is going to be long and drawn out, I would prefer to do it outside the presence of the jury. But you got a right to ask your question. So you ask your question, and I'll get the witness to answer the question.
Thank you.
All right. Bring him back. Can you not hear? You? Yeah. All right, further questions?
Yes, sir. Just to ask a final question on this topic. The bottom line is that you yourself have never been proficiency tested by an outside, independent bloodstain analyst, correct?
No, I have not.
Now, there are certain professional journals for forensic scientists, are there not?
Yes, there are.
And are you familiar with the names of any?
Not right off the bat.
For example, the Journal of Forensic Science, are you familiar with that one?
Yes, I am.
And you've not written any articles for any professional journal, have you?
No, I have not.
You've not contributed to any textbooks or treatises?
No, I have not.
There are people who do what you do who do that, right?
Yes, there are.
For example, Paulette Sutton in Tennessee is sort of your counterpart, right?
I don't know her.
She's contributed chapters to various textbooks, hasn't she?
I don't know that.
Well, are you familiar with any of the textbooks or treatises that have been written on bloodstain interpretation?
Yes, I am.
Which ones are you familiar with?
If you could ask me specific ones, I could tell you. I've read many of them.
Can you give me the name of any that you're familiar with?
Well, they all kind of have bloodstain pattern analysis in the title. Specifically beyond that, I can't remember.
How about the authors? Any authors you're familiar with in particular?
Not at the moment.
Have you read any of these books?
Yes, I have.
How long ago?
I've read some recently.
Which book have you read recently?
Well, it was Bloodstain Pattern Analysis, something.
By whom?
I can't remember at the moment.
All right. Well, are you familiar, for example, with the book by Stuart James called Scientific and Legal Applications of Bloodstain Pattern Interpretation?
Stuart James is someone that I have read before, but I don't know if that book is in particular the one that I've read.
How about the one he wrote with William G. Eckert?
Yes, I have read that.
You've read this one?
Yes.
And how about Bloodstain Pattern Analysis by Bevel and Gardner?
Yes, I have read that.
And do you know what these books say about the limits of bloodstain pattern interpretation?
In what regard?
The limits of what a bloodstain pattern analyst can say or do in terms of what happened in a scene. Do you know what they say about that?
Yes, I do.
What do they say about it?
That you must be very cautious and conservative in what you say about bloodstain pattern analysis. which goes to the pictures that we're talking about.
And can you tell the jury why they say you have to be very cautious and conservative?
It's just something that you should do. I mean, in all areas of forensic science, you should be cautious and conservative. I don't remember particular or specific things, but I realize in my training that you must be.
Now, if they say specific things that are limits on what someone in your position can give opinions about, you would not be in a position to disagree with that, would you?
I would have to see what the context of those are and talk about specifics for this case, perhaps.
All right. Have you? I think back in 1993, you attended an AAFS meeting.
What is AAFS?
You don't know what AAFS is?
In 1993?
Yes, sir.
I can't remember. I've attended many meetings, so.
Well, are you familiar with an organization known as the American Association of Forensic Scientists?
Oh, okay. That would have been in Boston, yes.
That's AAFS, right?
Okay, thank you.
Are you a member of that organization?
No, I'm not.
Aren't most forensic scientists members of that organization?
I couldn't say.
Do you know what that organization does? Do you know whether they have certain ethics and principles that apply to forensic scientists?
Not being a member, I don't know specifically what they have.
Have you attended any? How about the Southern Association of Forensic Scientists?
I've attended some meetings for that organization.
And when was the last time you attended a meeting for that?
I don't remember.
Years ago?
Yes.
Have you ever made any presentations at a meeting for a professional association?
Well, I'd have to say yes.
What professional association?
Well, there's associations in the state of North Carolina that I've made presentations in the area of bloodstain pattern analysis on many occasions.
And what organization is that?
Homicide Investigators of North Carolina, the Forensic Pathologists of North Carolina, the District Attorneys Conference of North Carolina.
Well, now, those presentations, you weren't training those people how to do bloodstain, were you?
No, I was talking about the field and what one could learn and obtain from knowledge in that field.
How about making a presentation to your peers nationwide or region-wide? Have you done that?
No, I have not done that.
Have you read any articles on bloodstain pattern analysis recently?
I'm going to say yes, I have. I don't remember specifically what they were, but I'm all the time reading about bloodstain pattern analysis.
Can you tell me what the topic was? Or what journal it was in?
I just can't remember specifically.
I've got a little bit more. You want me to break for lunch, or you want me to finish it up, Judge?
Depends on what you mean a little bit.
About 10 minutes.
You got 10 minutes?
Yes, sir.
Go ahead.
Now, the courses, you said you're the lead instructor for the SBI?
Yes, that's correct.
As I read the transcript, you know I subpoenaed your transcript from the SBI, right?
What do you mean by transcript?
Oh, I'm sorry. Can we mark this? Let me show you what's been marked Defense Exhibit 178 and ask you whether that's not a transcript of the training that you've both received and done in connection with the SBI.
No, it's not.
What is it?
It's a transcript of the training that I have received And I actually brought copies of training that I have done to you today.
Well, what I saw was some training you did in 2003.
That's correct. The training unit, when they received a request for that information yesterday, they only keep records for 3 to 4 years. And so that stuff is in archives and can be retrieved, but with some effort.
So at least within the last 3 or 4 years, that's the only one that you have taught?
Yes, that's correct.
And you said that this doesn't list the ones you've taught, but let me just show you this one in 1993. See that? Bloodstain pattern analysis? Raleigh? Who's listed as the instructor?
Yes, I already testified that they gave me credit for attending the class also, even though I was the lead instructor.
I see. And you've not actually taught anywhere outside the state?
No, I have not. That's not permitted by the SBI.
Have you ever analyzed bloodstain evidence from a situation that was known to be a fall?
Well, yes. When I say that, it was thought by everyone involved, including the pathologist, that a fall was involved. And I was called to provide assistance in the area of bloodstain pattern analysis, probably in the area of 6 or 8 times.
And did any of those involve people who had fallen down wooden stairs with a metal chairlifter?
They involved wooden stairs. I don't remember anything that involved a metal lift chair.
Did they involve drinking and Valium use combined?
I don't remember. I know that it seems like I remember 1 or 2 of the individuals were impaired.
You know what I just realized? Nobody tested that chairlift, unless I missed it. Nobody just tested that chairlift to see if she hit her head on that. Do you guys remember? Hey, John. John, I dropped some knowledge at the beginning of the stream about the documentary and things that I learned about his first trial, how there were a bunch of liars, and it is possible that he might not be guilty. Although I don't know what I think anymore. He might still be guilty. He might not. I don't know. First trial was a mess. He definitely deserved a second trial. But he pled to voluntary manslaughter to make it all go away because he'd already served 8 years. But it is possible that she could have hit her head on that metal chairlift. And I don't remember hearing anything about them trying to see if the wounds on the back of her head matched anything on the chairlift. That's another possibility. Although, I still think he did it. I just don't know how.
For some reason, because of medication. Yeah.
Did they involve scalp lacerations?
I mean, he could have taken her head and bashed it into the chairlift. That could have been what all the blood was from on that wall, because the chairlift was right next to that wall where all the blood was. I'm just saying, I think that should have been tested. So many things didn't get tested. The clothing didn't get tested for DNA. I mean, this whole case was handled so incorrectly. But the chairlift could have been what cut the back of her head.
I believe on one or two occasions that there were scalp lacerations involved in the 5 or 6 that I did, yes.
And these were cases where the person had actually fallen, is that right?
Well, these are cases. These are situations where everyone was in agreement that the cause of death was a fall. Yes.
And you concurred in that?
Yes, I did.
Now, you conducted some experiments in connection with this case, right?
I did.
And did you consider those experiments to be scientific?
Well, I considered them to be in keeping with bloodstain pattern analysis. They were experiments that have been conducted in other schools that I have attended and also that we have done in schools on many occasions and produced patterns.
Sir, that was a yes or no question. Was it scientific? That's all you had to say, yes or no. So I suspect the answer is no. And you're trying to put up a smoke screen right now. No, you did not follow the scientific method because you kept doing experiments until you got the result that you wanted. And that is not the scientific method. That's confirmation bias.
Patterns that we see in crime scenes and that we know from experience that have produced those same patterns.
I mean, I have an instruction that the witness answer the questions asked.
Yes, as best you can, just answer the question.
Did you consider the experiments that you did to be scientific?
In what context?
In any context, did you consider them to be scientifically valid?
Again, I'd have to elaborate on that answer.
Your Honor, he can answer yes or no and then elaborate. But
I don't think he's trying to keep you from elaborating. I think if you can answer yes or no and then elaborate.
Yes, in the realm of bloodstain pattern analysis, I did consider them to be scientifically relevant to that field.
And have you taken any courses in how to design a scientifically valid experiment?
Well, a lot of courses in science in the university have experimental design in them, and I have been involved in research in the laboratory, and also I worked in research at the university as a job while I was there also. So design of experiments is something that I'm familiar with.
And can you tell us then how you...
Dang it. You didn't break it, Nancy. It did this yesterday, too. Yeah, pretty much. Hates me. And now I have to figure out where we were. No, you didn't do it, Nancy.
Automatically come to some conclusion.
Someone who was already an expert. It would be Mr. Spittle, Agent Spittle.
That's correct.
Impact spatter versus satellite spatter.
Unless I had the authors, the one that I've read.
How about the one you...
Yeah.
Did they involve scalp lacerations? Scientifically valid.
Again, I'd have to elaborate on that answer.
Your Honor.
Cause of death was a fall, yes.
And you concurred in that?
Yes, I did.
Now, you conducted some experiments in connection with this case, right?
I did.
And did you consider those experiments to be scientific?
Well, I considered them to be in keeping with bloodstain pattern analysis. They were experiments that have been conducted in other schools that I have attended and also that we have done in schools on many occasions, and produce patterns that we see in crime scenes and that we know from experience that have produced those same patterns.
May I have an instruction that the witness answer the question is asked?
Yes, as best you can, just answer the question.
Did you consider the experiments that you did to be scientific?
In what context?
In any context, did you consider them to be scientifically valid?
Again, I'd have to elaborate on that answer.
Your Honor, he can answer yes or no and then elaborate. But
I don't think he's trying to keep you from elaborating. I think if you can answer yes or no and then elaborate.
Yes, in the realm of bloodstain pattern analysis, I did consider them to be scientifically relevant to that field.
And do you know, have you taken any courses in how to design a scientifically valid experiment?
Well, a lot of courses in science in the university have experimental design in them, and I have been involved in research in the laboratory, and also I worked in research at the university as a job while I was there also. So design of experiments is something that I'm familiar with.
And can you tell us then how you go about designing an experiment to remove any possible bias? You're aware that one of the problems in conducting a scientific experiment is bias on the part of the person conducting the experiment, right?
That's correct.
And tell us how you go about removing that element when you create one of these experiments.
Well, for bloodstain pattern analysis, you would remove the element by putting as many of the elements that can produce patterns similar to what you've seen in a crime scene as can be put into the experiments. In other words, take into account everything that you can possibly think of to accomplish that, and that's how you design those tests.
And how does that eliminate bias on the part of the person who is then conducting and interpreting the test? How does that eliminate bias?
Because you've taken into account everything that you can think of that might produce those patterns otherwise. Also, you must include those that have been stated as the way that those patterns were produced by anybody who may be in the scene or have something to do with that.
I see. So, for example, if you were going to test whether somebody had cleaned an area, there's a void area here in this wall, right?
Yes.
So if you were going to design an experiment to test a hypothesis, for example, about whether somebody had cleaned that, what you would do would be to create a blood spatter and then attempt to clean it and see what would happen, right?
Well, a void place is not a blood spatter pattern. It's an observation, and it's an observation. A result of that would be based on your experience on perhaps what could clean blood or does clean blood.
You're aware that one of the hallmarks of good science is experiments that can be replicated by others to see if they can validate your results?
Oh, absolutely.
And to your knowledge, has anyone ever replicated any of the experiments you did in this case?
The experiments that I did in this case are
Your Honor, may I have a yes or no answer before he explains?
Can you give him a yes or no?
Could you re-ask the question, please?
Yes, sir. You did certain experiments in this case, correct?
That's correct.
That you consider to be scientifically valid, correct?
In the realm of bloodstain pattern analysis, that's correct.
Well, isn't blood? I thought you said bloodstain pattern analysis is science.
I haven't had the opportunity to testify to that yet.
Oh, well, do you think it's a science or not?
I think it is a science.
The other question was, did he know whether someone has replicated?
Yes, sir. I was backing up for a second.
I don't want to get three more
questions
in there. I want him to answer that one.
Did anyone, let me ask you the question that the judge would like me to ask you. Has anyone replicated, reproduced, done over the experiments that you did in this case?
Nobody has, that I know of, has reproduced my experiments for this particular case, but myself and many of the others in this field do these same experiments all the time. And so there's nothing unusual about the things that were done in this case.
Sir, I've got two more questions. Let me ask you, would you agree with the following statement? I have seen enough cases where I've been able to reconstruct the circumstances that were given to me and was able to determine that bloodstain did not occur as one might expect from an individual involving those circumstances. You agree with that?
Could you read that again?
Yes, sir. I have seen enough cases where I've been able to reconstruct the circumstances that were given to me and was able to determine that bloodstain did not occur as one might expect from an individual involving those circumstances. Have you had that experience, sir?
Can I read that before I answer? That's such a long sentence. I need to read that.
May I approach?
Yes.
Do you agree with that, sir?
I do agree with that.
You said it, didn't you?
I did say it.
Would you agree, sir, that there are so many variables in determining bloodstain patterns? You agree with that?
I do agree with that.
That it depends on how the object struck the surface, right?
I do agree with that.
On hair. Right?
I do very much agree with that.
On the amount of blood that's available.
That is correct.
And when you did your experiments, sir, you made assumptions about those things, didn't you?
I did not.
That's all I have, Your Honor.
Questions, Mr. Howard?
Yes, sir. Mr. Rudolph, asked you about whether you were familiar with cases where it was reported that there had been a fall. And I think you'd indicated that you had seen that 6 to 8 times. Is that right?
Well, I have been to probably 15 times where it was reported that a fall had occurred. Probably 5 or 6 of those times I was in agreement that a fall was involved. The rest of those I was not in agreement that a fall was involved or created the patterns that were seen there.
Now, you had indicated that although you are the lead instructor for bloodstain pattern analysis with the State Bureau of Investigation, that you had not taught or lectured to some outside group. Is that right?
You mean outside of
the State Bureau of Investigation?
Well, I have lectured and taught groups outside of the SBI, but inside of the state of North Carolina.
Okay. And I guess the point that I want to understand is, as an employee with the State Bureau of Investigation, you can do that. You just can't testify. You can't teach or lecture outside of the state. Is that right?
That is correct, and I have been asked to do that, but I'm not allowed to do that.
And why is that? Exactly.
The rules are to prevent conflicts of interest in our employment and what our stated duties are.
No, I don't have any other questions.
Mr. Rudolph? Mr. Deputy, if you'll take the jury to the deliberation room. All right, Mr. Rudolph, you have objected to the state's proffer of this witness as an expert, or you have not? I wasn't quite sure.
I do object to the proffer of this witness as an expert.
Yes, sir.
I think that the voir dire has shown that, in fact, his knowledge of bloodstains in particular and being able to identify particular bloodstains is limited. He's never been proficiency tested. There is no indication other than his own conclusions that he's a qualified expert that anyone else has ever recognized him as a qualified expert in his field. He's not written. He's not taught anywhere. He's not been peer reviewed by outside agencies. Basically, he's a self-proclaimed expert, and we'd object to him testifying as to any blood spatter interpretation.
Mr. Harden.
Your Honor, within his field at the State Bureau of Investigation, as that lab is accredited by a national association, there's not a requirement for proficiency testing. So that should eliminate that issue. Since there's no requirement, he obviously doesn't have to go through that process. He's not allowed to teach outside the state of North Carolina. He's taught in the state of North Carolina in this field in a variety of venues with a variety of associations. He's taught several classes at the State Bureau of Investigation for students of this discipline. He has also read extensively about it, as he testified to. He's testified in 60 cases as an expert in this field. They can't all be wrong. So I'd ask that you allow him to testify as an expert in the field of blood stain pattern analysis. All he's got to do with respect to this is be in a position to provide the jury with information that's outside their knowledge and expertise and will assist them in determining an issue in fact in this case. He certainly can do that. His qualifications, his background, his experience, his training all suggest that he can do that. And I'd ask that you allow him to be able to testify to the jury in that manner.
Yes, sir, Mr. Rudolph.
Nothing further.
All right, then, Ms. Court Reporter, based on evidence presented, arguments of counsel, the court does find that this witness possesses the appropriate education and training to be designated as an expert in the field proffered by the state. The court further finds that he can give testimony to the jury that would be helpful to their understanding of issues in this case. The state's motion is allowed. We're going to bring the jury back, and you make your offer in front of the jury that we're going to lunch until 1:45.
Your Honor, I would ask the court's going to find that he's qualified to give the opinion, I'd ask the court instruct that doesn't mean that the court's giving any kind of judicial imprimatur to his opinions, and that ultimately it's going to be up to the jury to accept or reject his opinions as with any other witness.
Well, that's the instruction typically that the court gives in the final instructions, which I do intend to give in this case. But all right.
At this point, we would renew our motion to tender Agent Deaver as an expert in the field of bloodstain pattern analysis.
I'd ask that the court instruct the jury as to the limits of that particular ruling, Your Honor.
All right, the state's motion is allowed. Members of the jury, it will be up to the jury to determine the weight to be given to the testimony of this witness as you would any other witness as to his qualifications and believability. That is something for you, the jury, to determine. At this time, we're going to take a break. I suspect that this witness will be testifying in this case for some time. So I'm gonna give you a little bit longer lunch break and we'll come back at 1:45. Remember the instructions I've given you throughout the course of this trial, 1:45. Yes, sir.
For planning purposes, just wanted to at least explore the possibility that next week, beginning on Monday, we begin the hearings with respect to the Ratliff issue. I anticipate that Agent Deaver is going to be on the witness stand probably the remainder of this week and possibly some next week. It would be my thought that we go ahead and take his testimony before the jury, and in the afternoons at 3 o'clock when they're not here, that the court allow us to address the questions raised by the motion in limine relating to Ratliff, so that once Agent Deaver is through with his testimony, we can move right into the Ratliff information if the court concludes that it's going to be admissible. If the court concludes that it's not, it'll give me enough time to make some adjustments with other schedules.
Judge, I have no objection to doing voir dire on the Ratliff matters at 3 o'clock. I think that's part of the reason we set the schedule up, is so that we could do that sort of thing. And I think that's appropriate. I know that Mr. Peterson's daughters have got to be back at school for a couple of days early next week just to tie up loose ends, because they're not going to be going back to school this fall. And I know they very much want to be here for the Ratliff testimony, which after all concerns their natural mother. And so I just say that I think as long as we can get to that at some point, say midweek, so that they can be here for that, that's fine. Not the voir dire, but the actual testimony itself, assuming the court allows it in.
I have no idea how much evidence you're going to try to get in, or who you're going to call. You know that better than I do. So I take it if you believe we can do the 404B evidence in a week there. I don't know when you intend to actually offer that into evidence if it comes in. Yes, sir. And I take it that's what Mr. Rudolph is asking.
I'm not just trying to figure out what the schedule might be with regard to that.
I'm hoping we can address the question and have it ruled on within a couple of days in the assuming we would work from 3 to 5 in the afternoon, or however long it takes. And I don't know that it'll take more than a couple of days. At least we hope it won't.
If I guess his question is, if we can resolve that, do you anticipate going immediately into that in front of the juries?
Yes, sir. It sounds to me like it's probably going to take us till Wednesday to get that resolved anyway, and that'll be fine.
Well, if we start Monday, I probably can't do it Tuesday. So you'll either have to do it along on Wednesday, Thursday, however long it takes. But I'm pretty sure I can't do it on Tuesday. Yes, sir. All right. Well, then with that understanding, that's fine. Anything else?
Yes, sir.
1:45.
All set.
why do they wait till the trial started to decide if they're going to let certain evidence in? Why don't they do that before the trial starts? So they're going to have a voir dire about whether or not they let the Germany stuff in, which they do. We know that they do let it in. And Judge Hudson says, after the fact, that he probably shouldn't have let it in. But why don't they decide those things before the trial starts? Unless, trying to remember from the documentary, if it was because I think the prosecution didn't know about it until after the trial started. I think someone went to the prosecution and said, oh yeah, by the way, he had a friend in Germany that died by falling down the stairs. I think that's what happened. I'm not going to go back and watch the whole documentary, but I think they didn't know. I think that was it.
We ask questions about your specific activities related to this case. I wanted to ask you some questions about blood spatter from a general perspective, and ask you to begin with, what are the most important criteria in blood spatter pattern evaluations based upon your training, your experience, and your research in the literature that relates to the subject?
Well, it requires that you spend an appropriate amount of time in the examination of the blood stains that are in a scene or on objects. Obviously, you have to do an examination of items that contain blood stains on them also. It's necessary to look at autopsy reports and other statements that are made there. It's important that you make diagrams. It's important that you take the blood stain patterns as a total part of the whole picture of the scene. That you are, again, as I said before, very conservative with your with looking at it. It's also very important that you go to the scene. There are times that you're called to look at blood stain patterns after you can't go to the scene anymore. If that happens, then you have to really narrow the things that you say about it. So it would be very good for you to be able to go to the scene. Document, as I said before.
Now, would it be fair for me to say that you have to look at information from a variety of disciplines in order to actually conduct the blood stain pattern analysis?
Yes, that's true.
So you wouldn't necessarily just look at a series of photographs and feel like you're in a position to conduct that analysis if that's all you had?
Well, certainly, if you looked at photographs and had some perspective as to how they were taken and what they look like, there may be some very general things that you could say about them. But trying to do a complete analysis on a crime scene from photographs would not be that wouldn't be something that you could do from a set of photographs.
Right. Now, I've been using the phrase blood stain pattern analysis. Is that field called other things as well?
Yes, the title is blood stain pattern analysis, but it's also commonly referred to as blood spatter analysis, or as it has already been referred to in this court, blood spatter. And that's a general term talking about the analysis of stains at a crime scene.
Before we get much further, I want you to define for the jury exactly what blood stain pattern analysis or blood spatter is.
It is a part of crime scene investigations. And what it is the study, the examination of blood stains in a scene and to make determinations as to how they were caused.
All right. Now, with respect to the science of blood stain pattern analysis or blood spatter analysis, how long has at least the field of endeavor been available for the study of crime scenes?
I object to the characterization of science.
Overall, it's been a part of crime scene investigations for over 100 years. European scientists began writing about it in the late 1800s, the early 1900s. There was some very important work done on it again in the middle 1900s. It began to be a part of crime scene investigations in the United States in the early 1950s, and increased in importance and popularity in crime scene investigations to the present day. It is a very readily acceptable part of crime scene investigation. As a matter of fact, it is now a responsibility of crime scene investigators for the SBI. They must become bloodstain pattern analysts when they do crime scene investigations.
And exactly why is it part of forensic evaluation of a crime scene?
Well, it is considered to be a science. And the reason for that is that the types of stains that are found in a scene are readily reproducible by actions similar to those that were that produced those. What I mean by that is you can go back into the laboratory and produce these types of patterns with similar actions over and over again. As a matter of fact, that's really the basis for the schools that we have been talking about today, either that I have taken, other people teach, or that I have taught myself.
Now, you were talking about the fact that with this science, it's considered science because the patterns are reproducible. Is that right?
That's correct. The general types of patterns are reproducible in a laboratory setting.
Does that mean that you can reproduce everything that is created in a crime scene?
Well, it's not the purpose of a bloodstain pattern analyst to recreate a crime scene. That would be impossible because you were not there. You did not see what happened. What you're doing is reproducing the types of stains that are found there.
Okay. Now, with respect to blood stain pattern analysis, are there some basic principles that one must grasp as they are learning this forensic technique?
Yes, there are some things that need to be understood about this investigation or this investigatory technique.
If you would, please, just generally describe what some of those basic principles are.
Well, the first thing that one needs to understand when they're dealing with bloodstain pattern analysis is that you're involved with the human body, and the blood is contained within vessels of the body itself, within the circulatory system. The reason that's important to understand is that an injury must rupture that circulatory system and cause blood to come to the surface. When that blood comes to the surface on the body or on clothing or on other parts of the scene, that is when a bloodstain pattern analysis can begin. The reason I say that is, and I use an example, if two individuals were fighting in a corner of the room, and it might be a very serious fight, they may be creating injuries, but it is not until blood comes to the surface and then begins to drop or fall or be spattered on parts of the scene that a person doing blood spatter can come in and start to say something about that scene. Now, if they did that over in that corner and they moved over to this corner, and that's when blood starts to be shed on the floor or on the walls or whatever, a bloodstain pattern analyst would not be able to say anything about what had occurred previous to that blood falling on the floor or coming in contact with the walls. In other words, I wouldn't be able to say anything about that corner of the room. And that seems that seems simple to understand, but it's something that needs to be grasped with blood spatter. There are other actions that could be occurring prior to that. And indeed, I'll explain that more later.
Now, with respect to some specific terminology as it relates to this field, I'm going to be asking you questions about that, and you're going to have to use that terminology. Is that correct?
That's correct.
Would it be helpful for you to step down and describe some of this information on butcher block paper?
Yes,
for the
it
jury? Now, could the witness step down and use the butcher block paper to illustrate some information about blood staining analysis?
It's allowed.
Now, if you would, Agent Deaver, describe to the jury how bloodstains are formed, and use the terminology that you're going to be using in your descriptions of what you did in this case, and define for them those terms, and we'll talk a little bit about that as you go.
Okay. Well, the first thing that I need to explain is that blood comes to be in a scene when it's acted on by force. Okay, and there's several forces that are acting on blood in a scene. The first force that I would like to talk about is gravity, and simply it's if I might use the example, if you cut your finger and allow that blood to come until gravity acts upon it and it drips onto the floor, then it would create a drop. Okay. Gravity can also produce other stains. They would be blood pooling or blood flowing, blood running. So that force is acting upon it. Okay. Another force that would act upon blood in a scene is impacts. Okay. And what I mean by that is that there is a source of blood and something has impacted it. It might be, for instance, if I take a blood drop and place it in my hand and I were to hit it with something, okay, that force would cause the blood to break apart, okay, and it would create impact, okay. Now, another force that could be considered in the crime scene is centrifugal force, okay? And what I mean by centrifugal force is it's a circular motion, and when it reaches a force sufficient to cause that blood to come off of it, then it'll actually cause, like we might say, flinging blood, okay? Let's say that I have blood on my hand, and I cause a circular motion, and then blood would come off of it, okay? And that produces a certain type of staining also, okay?
What makes that different from the second diagram that you showed with respect to impact spatter?
Well, if you take into account, let me answer that question in another way. Another principle that has to be understood.
Oh my God. No freaking way. That lady is a monster. Why? How did it get overturned? Please at least tell me they're going to try her again. Overturned on what grounds? Why? Type, woman, type. I have questions. Why? That's the woman that killed her stepson, who was special needs. This was a miracle baby. This was their miracle child. Because they thought he was going to die. And she killed this kid. Her husband was in the service. While he was in the service, she killed him. Stuffed him in a suitcase. Drove to Florida. Put the suitcase under a bridge. She told, and her husband, she made up all these weird stories, which kept changing about what happened to him. She said she got carjacked. She said that I don't even remember all the stories. They were so crazy. If she gets another trial, we're definitely covering it. Juror issue. Okay, retrial. Good. Oh my God. That woman's a monster. Ugh. And continued and continued and continued to lie. She even talked to the press and kept saying, you know, we're going to get you home, honey. We're going to get you. I mean, oh my God, this woman.
Here is that generally the more force that is applied to blood, the smaller it causes the droplets to be. What I mean by that is blood is a substance that wants to stick together or hold together. It has viscosity, it has surface tension, and it wants to stay together. Force is required to break it apart. The more force you apply to that blood, the smaller the droplets will become. Okay, let's go back so that I can explain this completely. Let's go back to gravity. Okay, and using my finger example, I cut my finger and I allow that drop to come until gravity.
You guys, oh, the antifreeze chick. Well, that's good. You know, we have the best judicial system in the world, but it has flaws. I don't think there's a perfect system anywhere. It's so sad. I'm like this case. He should have been retried. But the reason why, when he first got the conviction overturned and got the retrial, the district attorney said no Alford plea, no plea at all. They were going to take him to trial. And then when all this crap came out about all the lies, all the, getting the medical examiner to change the cause of death, all of that crap that came out, then the way the evidence was contaminated, then the DA said, "Okay, yeah, we'll do a plea now." Because they didn't want all that to come out during the trial. So they did a plea. This man should have been tried again. He would have gotten convicted and gone to prison for the rest of his life. But because everybody did whatever they could to convict the man, they screwed it up. Don't do that. Do it by the book so it sticks. God bless America. Because they didn't remove a juror? That's why? What was she? They thought she'd already made up her mind or she had a bias or something and she wasn't removed? So the Court of Appeals granted her a new trial because of that. Oh my God. And that judge was good too. That was a very good judge. Oh my God. That, oh, I hope they don't bring that woman back. She was going for insanity. And the expert on her side, I swear that woman was in love with, I think it was Bundy. She thinks that anybody that commits murder is mentally ill. And she interviewed Bundy and went on and on and on about how anybody that kills somebody is mentally ill. So they thought that she should have gotten off for being mentally ill. And that lady was as crazy as a bedbug. And when the prosecution was questioning her, she got bitchy. Oh my God, did she get bitchy? I swear that woman had to be in her 90s. She was an old lady. In fact, I think there's a documentary about her on Netflix or HBO, either one. That was a good trial. That was a very good trial. And the jury got it right. Now we got to go through it again. Oh. Well, good. We will watch it. We will watch the next one. I guarantee you we will watch it. Because I am PO'd right now. Oh my God.
Pulls it off and it strikes an object, strikes the floor. And that's happened to all of us. It's something common to our experience. Gravity is a force, speaking of these types of situations, that's fairly small, okay, in relationship to the other forces I've described. So the blood drop is fairly large. Okay, when we think back, you may have a blood drop the size of a nickel or a dime created by gravity. Okay, now let's go back to this example. Impacts. Okay, if I were to take a drop of blood, place it in my hand, and I were to hit it with a bat, okay, it would break the blood up because it's a larger force in comparison to gravity. It would break the blood up into smaller droplets. All right, let's use another example of impact. I've got a drop of blood in my hand and I fire a bullet through it. That is a lot more force than my bat striking my hand. Those blood droplets are going to be much smaller. Okay? Now,
well, let me ask you a question with respect to the shape of these blood droplets. If you've got a blood drop that is caused by gravity, what is the shape of that drop going to be?
Well, that would be depending on that would depend on your perspective to the surface. Let me give you a couple of more definitions very quickly so you understand what we're saying. The first thing is source of blood.
I want to object to the witness not answering the question that's been put to him and answering some other question. I mean, it's non-responsive.
Well, I think he did answer. You may not be satisfied with his answer, but I think he answered.
Very well.
Okay. Indeed, a source of blood is something that is providing blood. Okay, a source of blood, providing blood. My finger is a source of blood if it's cut and blood is falling. If I were to stand perfectly still and allow that drop of blood to fall straight down onto the floor, that would create a perfectly circular drop, which is what I've tried to represent here. Okay. What that means is that the source of blood, if this were the floor, the source of blood was at 90 degrees or perfectly perpendicular to the floor. Okay. Now, if I were to do the same thing, if I were somehow to be able to cast that drop straight up and it were to strike the ceiling perfectly perpendicular again, it would still create a perfectly round drop.
I just gave myself a headache. I think I have an aneurysm. Oh my God. I've never given myself a headache from emotion before. This is a first, y'all. Oh my God. That's scary. I guess my blood pressure went up when I heard that.
Now, if somehow I were to be able to cast that drop of blood off my finger and for it to hit perfectly perpendicular to that wall, that drop would still be round. That's a very, very important principle or thing to understand. Now, if I use my finger again and somehow I cast it off and it doesn't come perpendicular to the surface, in other words, it's traveling at an angle now, that drop is not going to be perfectly round. It's going to have
And why is that? Why is it going to look in an oblong fashion with that action?
As the drop falls against the surface, it continues to move. As part of the drop stays on the surface, it continues to move and create an oblong shape. Right? And anything that doesn't hit perpendicular is going to create an oblong shape. So again, if I were to take my finger and I were walking along, okay, and that drop hits the floor at an angle, then you're going to have an oblong shape.
All right. Now, with respect to that last example that you used, the blood striking a surface at an angle, what information are you able to glean from the shape of that drop?
Well, this provides a lot of information, just as this provides information that the source of blood was perpendicular to that surface. This provides information that the source of blood was not perpendicular to that surface. But you can glean a little bit more about it, okay? In doing so, the drops will frequently produce what we call a little tail on them, okay? And actually what happens is it flips a little tail off. When it does that, it gives you information that the blood was traveling in this direction. Okay? Every time you find these little tails, that tells you that the blood is traveling in that direction. That means that the source of blood was opposite of that, or over here. If we're using my finger again, and I flick that blood out, the source of blood's my finger, the blood is traveling in that direction. Now, if you were to have drops all over my page like that, you could, at least in this plane, determine that the source of blood was somewhere in this. And that's one of the principles that we use in doing blood stain pattern analysis.
All right. And with respect to the other forces that can act on blood that can be shown and then discerned by you to make some decisions about source location, are there other terms that you're going to be using in this examination?
Yes.
Would you please define those for the jury?
Okay. Going back to the forces that we had, we talked about the force of gravity. We talked about the force of impacts. When there's all kinds of impacts, I used a bullet as an example. We use centrifugal force too. Now, centrifugal force is greater than gravity, okay, relatively speaking, in this context. It's also less than an impact. So you would expect the size of drops to be in between these two. Okay? They would be categorized as medium-sized drops, okay, for this. Now, we have a definition for what gravity acts on, drip blood. We have a definition for what impact spatters look like, and that definition would be called an impact spatter, okay? It's very characteristic. The type of pattern produced by this force would be called a cast-off. And that's simply blood that's been cast off some object that is in a circular motion. There is another force that can produce a cast-off, and that is the sudden stop of an object. In other words, I've got blood on my hand, and it comes to a sudden stop. Okay, that sudden stop is going to cause blood to be cast off of it again, and that cast-off can be found on the floor or on the wall or something else. Now, these are characterized a lot by the drop size or the force that produced them, also by the type of patterns that they are. Drip blood obviously is very simple to understand. Impact spatters, when they are produced, we're looking for force that has produced smaller drops. And also often these patterns are produced as I have produced here, in a fan shape. Okay, let's go back and use, this is my point of origin. Okay.
And when you say point of origin, you mean source of blood?
I'm sorry?
Point of origin or source of blood?
Okay, source of blood. Sorry, this is a source, okay, of blood. Okay, there's blood on this object, whatever this black object is here, there's blood on this object. Okay, when it is impacted, I've impacted it with this pin here. When I impact it, a blood spatter is produced, an impact spatter. Okay, now the impact spatter, based on the force that I give, will produce often a fan-shaped pattern. It'll emanate from this source out, striking whatever there is to strike there. If there's a wall there, if there's a floor there, or whatever there is to strike, it will produce this fan-shaped pattern. Okay? Talking about what we saw before and finding our source, we can go back and look at these. They've got the little tails on them or whatever. We can draw lines through there, and we can, at least in one dimension, determine what that point was. Now, I said a while ago, point of origin. Point of origin would be the origin of that impact. Okay? If there's a source of blood and it's been impacted, then when a spatter pattern is produced, an impact spatter is produced, okay, then you've got a point of origin somewhere. All right, let's use another example.
Now, before you go on, what scientific techniques are you using there to make those determinations about the directionality of those blood droplets?
Okay. There's more information that can be obtained by this blood draw. Okay, that's oblong. It was discovered in the 1930s that this, following the principles of physics, okay, or objects in motion, produced, when it struck a target, the ability to determine exactly where the point of origin was for that drop, okay, or to determine the point of origin for that drop. And the way that was done was a measurement was made of the width, okay, and the length of that drop, and a trigonometric relationship was had, okay, that allowed you to do that. In other words, if you wanted to measure the width of this drop and the length of this drop and do a trigonometric function to it, you can determine the number of degrees off of this surface that the point of origin was. What I've drawn over here is in one dimension. Let's say that my hand is out here in space, okay? I have a drop of blood on it, and I impact it with a bat. The blood can still strike this piece of paper, okay, and produce the same type of pattern that I've drawn on this piece of paper. When we draw the lines through here, we're going to come to a point, but that is not actually the point of origin. That's just an idea of where the point should be on one dimension. The point of origin was actually out here in space. I can go back and do these measurements and do these determinations and actually put a protractor on this drop. And with those degrees, okay, I can find where that point is out here in space. Okay, and that's actually how you do these point of origin comparisons. Now, going back and finding these impact spatters is a relationship on the size of the drop. Okay, we're looking for these fan patterns so many times when we're in the crime scene.
Now, a moment ago, you were talking about the fact that the greater the force, the smaller the drop.
Yes, that in general terms, the greater the force, the smaller the drop. Again, if I put a drop of blood in my hand and I hit it lightly, that's not a lot of force. It's going to produce, a certain size drop. If I hit it harder, you can expect generally smaller drops. If I shoot a bullet through it, you can expect smaller drops still because the force is increased into the blood. And again, it takes more force to break that apart to make it smaller and smaller.
And with respect to the small drops, can you describe to the jury whether you can determine distance that a small drop would have traveled as compared with a drop that's much larger?
Well, yes, you can. Again, another law that we have to deal with here is the law of mass, okay? And that applies to blood also. And what we're talking about is that as an object flies through space, it's being dealt with by friction in the air or whatever, and also gravity. An object that has more mass will carry farther. Okay, so when you're dealing with for this instant, an impact spatter, okay, and you've got an impact that's occurred, the smallest drops are going to come down first, okay, and larger drops are going to carry farther in that pattern because it has more mass. It can travel farther through the air. And so, again, generally speaking, you're going to find the smallest drops closest to the source or point of origin, and you're going to find the larger drops in the pattern farther out.
Now, you've used the term source and point of origin. Are they always going to be the same?
Well, a source of blood is not necessarily a point of origin. I could be standing here bleeding and I could be producing, drips or whatever. I'd be a source of blood. It's not until I'm impacted that there's a point of origin for a blood stain pattern. So basically, generally, we use this, the definition of source of blood is whatever it is that has blood on it or whatever it is that's bleeding, and a point of origin to describe how this pattern or how a pattern originated or where it came from.
So they're related, but they're not necessarily synonymous.
No, they're not necessarily the same.
Okay. Now, with respect to depositing blood on a surface, whether it's on a wall or on a floor or something else, when it contacts the surface, what is that called?
What the surface?
Yes.
Okay, well, and when we're doing our work, we call the surface a target. And a target is anything that blood comes in contact with. If it's the floor, if it's this piece of paper, if it's the wall, then when we're working, then we call that the target. The source is not the target, but what the blood strikes is the target. Even if it's my clothing or my body or whatever, then I'm the target of what that blood comes in contact with. So when we're talking about these things, we talk about what the blood is hit as the target.
All right. Now, a moment ago, we were talking about points of origin, and you described that. Now, exactly what can you determine from points of origin as it relates to action or activity within a crime scene?
Well, when you've done the determination of when you've done the examination of a crime scene and analysis of it, and you have determined these types of patterns that we're talking about, you can then go in and do an analysis, doing the measurements that we've talked about on those stains to determine a point of origin, okay? When those point of origins are found, what that means is that there is a source of blood that has been impacted, okay? That's what that means. And in that point, when we do that, then we'll give some kind of, we've got an impact spatter here drawn very roughly
okay? And we go in and we do this examination, then we will actually pull strings is what it's called. We will tape strings to these droplets, use a protractor, pull that string out along the number of degrees that it struck, and you'll have a point of origin out here in space again. When you've done that, what that means is that there was a source of blood that was impacted at the measurement that we give. Okay? And an example here would be 28 inches off the floor, 6 inches off of this pad, and a certain number of inches from another place or whatever. Okay? And that would be, what that means is that this pattern was formed when a source of blood was impacted in that place. And that's what we do, and that's what we consider a reconstruction of these patterns.
And exactly how do you do that?
Again, going back and measuring these drops. You wouldn't measure necessarily all the drops in a pattern, but you take representative drops out of the pattern, okay? Do your measurements, pull those strings. When those strings come to a convergence or a point, okay, you'd have strings pulled out here. When they come to a convergence or a point, that's your point of origin. And again, it's very simply done by measuring the width and length, doing that trigonometric function that I was talking about, and then pulling that string. You'll actually lay a protractor on that surface and pull that string out there and tape it on that drop. And when those strings come to a point, then you've got your point of origin.
All right. Now, exactly what kinds of things can you determine from blood stain pattern analysis?
Well, we've been talking a lot about impact spatters, but there's others. There's cast-off stains and drip stains. There's transfer stains, which is another force that is pressure, okay, which means that you've transferred blood from one object to another. When you take into consideration all of these things, many times you're able to determine the movement of the victim, okay? In this case, the victim may be the source of blood. It doesn't necessarily mean that that's the only source of blood, but the victim, if they're bleeding, you may be able to, after this analysis, determine what their movement is in the scene, where they were at certain times when certain actions were taken. You may also be able to determine the movements of other individuals in the scene based on looking at these blood stains again. Okay? Also, when you do a study of the clothing, blood stains that come in contact with clothing will also tell you how those blood stains came to be on that clothing. And the actions that the individual wearer was taking in that scene, okay, can often be said. Weapons can sometimes be determined by an analysis of the blood stains also. It's often used to corroborate or refute statements made about the crime scene. In other words, an individual says that they were created in a certain manner. When you look at that, then you can say, yes.
I didn't know we were going to be taking a course in blood spatter analysis, but apparently we are. And we got another hour and 18 minutes of it on this video.
That is consistent with statements made, or sometimes no, these stains are not consistent with those statements. You can determine the order of events sometimes, okay? When did this happen in comparison to that, based on the stains that you see in the scene?
Are you able to determine the number of blows that would have been struck on a source of blood to cause a particular pattern?
Well, yes, if I might explain.
Sure.
Okay, the number of blows. Let's go back to our impact here. Okay, I've got a drop of blood in my hand. Okay, and I strike it. Okay, if I were to have enough blood here and I were to continue to strike it and move my hand around, it would create different impact spatters. If I measure these in here, I'm going to come back to several points of origin, okay?
And I will be able to say that there were impacts in different places, okay? Each one of those is a blow. I am going to have to say, though, that it's a minimum number of blows. In other words, if I were to do a reconstruction from this pad and I were to find 3 points of origin, I would have to say that that's a minimum number, okay? I would maybe even add one, though. And the reason for that is that, remember, you have to create an injury that causes bleeding before I can see it. So the first impact created no blood spatter, okay? Created no impact spatter, okay? So I may count one extra because there's one in there that caused an injury to start the blood flowing, and then I start seeing blood spatter. But that would be a minimum number, okay? There may be others that we didn't see or didn't find. That would be a minimum number of blows. Going back, I strike it 1. 3 times, I found 3 patterns. I might say that there was a minimum of 4 blows applied to that source of blood. 1 being when there was no blood, and then 3 after when I found the patterns.
So if I understand you correctly, then if you have enough information, you can sometimes sequence events, but you're not able to define or describe every single event that would have occurred in a crime scene. Is that right?
No, you're not able to describe every event because, everything can't be described. You go in and you look at the patterns that you have. You study them, you analyze them, and you say what you can about it. Not having seen what went on in that scene, everything can't be described, and nor would it be the intention of a bloodstain pattern analyst to do so.
Now, you talked a few moments ago during questions that I posed and also that Mr. Rudolph posed about the use of experimentation in this form of analysis. Will you please describe to the jury generally how you go about that process and what the value is of experimentation in bloodstain pattern analysis?
Well, yes. Indeed, when you're trained as a bloodstain pattern analyst, you're taught that you should be, again, conservative, very cautious about what you say, and then that you should do confirmatory tests as a part of your analysis. That's a readily acceptable part of your work. It's in the literature and in the books that we've talked about today. And what you do is we discuss some very simple types of patterns. When you have done an analysis on a crime scene, then it behooves you to go back into the laboratory and to reproduce those patterns by actions that you believe caused the patterns in the crime scene. Okay? If you find an impact spatter, okay, and you say that it was a certain distance from a wall or whatever, you go back and reproduce that. You put it a certain distance to the wall. You look and see if that pattern looks similar to the one that you've seen. You may even go back and pull the strings on it again and see, what your distances are and things on that. If you see things on clothing and you think that they were produced by a certain action or whatever, then you could go into the laboratory and produce that action and see what the spatters look like on that clothing. You would also use this method for taking into consideration other actions that may have produced the spatter patterns that you see. Indeed, again, a lot of the schools that we teach and that we attend in other places are simply going into the laboratory and creating impact spatters, transfer stains, which is blood on an object being transferred to another object, cast-offs, dripping stains. Those kinds of things are produced in school, and we go in and study those. And we make comparisons between those and scenes back and forth.
Now, you had indicated that you had worked 200 cases and that you had been involved in roughly 500 cases.
Well, yeah, that was the estimate, sure.
With respect to the 200 cases that you specifically worked, did you always perform experiments in every one?
No.
And why not?
Well, some of the cases that you do, I mean, it's just simply a bit of information that you provided for the investigators in that case, and there's really no reason to go in and reproduce that. Usually it's something that you've produced, I mean, hundreds of times in your classes or whatever, and done. And that information is just a bit of information used for the investigation. What is usually done, however, is that if there is an explanation for the stain seen in the scene that is different from what you have observed, then yes, you need to go in and do some experiments. And you need to contrast the stated actions against what you think caused the stains in that crime scene. And that's really what that experimentation is all about or for.
All right. Now, with respect to this case in particular, if you would please, would you describe how you became involved in your analysis of the crime scene at 1810 Cedar Street? Your Honor, could he take the witness stand, please?
Yes.
If you would please describe how you became involved in processing the scene and working the scene at 1810 Cedar Street.
On the afternoon of December 9th, 2001, I was at my residence. I was called by Supervisor Rick Sims of the Capital District of the State Bureau of Investigation. And what I mean by Capital District, it is that Durham fits within that district. He advised me that the Durham Police Department had requested a bloodstain pattern analysis and gave me the address. He gave me the name of Eric Campen and a telephone number to call so that I might find, get directions to that. And he said that it was stated that the victim had fallen down some stairs. And asked if I would respond, and I agreed to respond to that, and did respond, arriving sometime shortly after 5 p.m. On December the 9th.
If you would please describe to the jury what you saw when you got to the scene and with whom you spoke.
Well, I drove up on the Kent Street side of the residence. There was a command bus in front of the house, or what I consider the front of the house from the Kent Street side. I pulled up in front of the bus and went inside. The person that I spoke with there was Sergeant Pascal of the Durham Police Department. I told him who I was, and then I had responded to provide assistance in the area of bloodstain pattern analysis. He told me that that Detective Art Holland was in the residence, and that Eric Campen was the person that I needed to speak with. I asked him if there were any photographs of the scene, and he said there were, and he provided me a set of photographs. And while I was in the bus, I began to look at photographs. While doing so, I asked Sergeant Pascal if a search warrant had been issued for the scene, and he told me that they were working under a search warrant.
All right. Why were you concerned about whether there was a search warrant?
Well, because the information that had been given to me was that it was an accident, and I didn't know if the police department was working as a death investigation without a search warrant, or if they had obtained one. And I was just simply concerned under what I'd be working under. It's a routine question I ask whenever I arrive at a scene.
All right. Now, did you speak with anyone else in the command post about what was inside the residence?
No. I think there were other people in there, but I really didn't speak to many. And just to answer a little further, I really don't want impressions of what people think about the scene or whatever. I don't want that to be entered into my mind, and so I don't sit around asking what they think about it. And so as soon as Sergeant Pascal told me where Eric Campen was, I really dismissed myself after looking at the photographs and found him.
Do you recall approximately how many photographs you looked at?
No, it was a pretty good sized stack. I mean, it was pretty thick.
With respect to what was depicted in the photographs, do you generally recall what the subject matter would have been?
Well, it was I mean, there were pictures of the inside of the house, was what I remember because that's what I was interested in, and of the stairwell and the walls. That's about all I remember.
Now, you indicate once you saw those photographs, you didn't really talk with anybody else, but you received the information that Eric Campen was the person that you needed to see inside.
That's right.
And what did you do once you received that information?
I actually went from the bus into the yard itself and asked an officer there where Eric Campen was.
As you were going in, did you make any observations of the exterior of the residence?
Well, it was dark by the time I went in, and I remember there being light in the yard. There was an officer and a car in the I guess the driveway there in front, and he actually made me register to go in. And if I remember correctly, there was an officer at the door, and I think it was the officer at the door that actually called for Eric Campen to come outside and to meet me there.
All right. With respect to meeting Mr. Campen, what happened?
Well, I asked Mr. Campen and found out that he was actually the person who had requested that I come. I asked him what had been done at the scene. What I was specifically interested in is what kind of examinations they had done at the scene. I asked him about the EMTs coming to take the body. I wanted to know specifically what they had done. And that's basically it. I wanted to know what he and those who were helping him had done. He also told me where officers had been in the scene, and we did discuss that for a few minutes and what their actions had been in the scene. He also then told me that other people had been in the house, and he described to me what their actions had been in the scene, which were all done for the purpose of determining what I might find as far as bloodstains in the scene itself.
Now, is that information you need to take into account as you do your analysis?
Yes, it is.
Now, with respect to his description of the various people in that scene you just described, EMTs, officers, other persons that appeared to be related in some way, did he talk with you about information about the actions of the defendant in the scene as they were known to be at that time?
Well, yes, and that was part of the description of other people in the scene. I was interested in knowing and at some time asked who had blood on their clothing, because clothing is a very important part of the examination. And he told me that there were two individuals that he knew of that had blood on them, Mr. Peterson and Mr. Peterson's son, Todd. And I asked what their actions were specifically related to what he knew about what they had done at the scene.
Now, did he describe this information to you while you were standing outside, or did you go inside at this point, and did he point things out to you?
Well, we began our conversation outside, and as I remember, we walked into the front door. There was an officer at the front door, and we stood in what I consider the hallway of the house, and we concluded our conversation there. He pointed down the hall to the left, where the victim's body had been found. We discussed in detail what the EMTs had done. He pointed around through the foyer area of the house, telling me where officers had walked and where other people had walked. He described to me that Mr. Peterson had sat down on a couch, but we didn't go and look at that at the time. We went through the whole thing with him pointing out things. And then I told him that I needed to go to my car and retrieve a few things. And so I went back out of the scene, I believe, at that point, and got some tools and things that I needed.
Okay, once you went back to your vehicle to get your tools, what did you do?
I went back in. I met with Eric Campen again. We dressed in booties and a suit at that time, and then he and I went over to the stairwell itself, and I asked him again to describe for me what had been done in and around the stairwell as far as he knew.
Now, wait a second. Let me back up a little bit. If I understand you correctly, before you went to your vehicle, you just stayed in that foyer area, and he pointed out things from that location.
That's correct.
Down the hall.
Yes, that's correct.
And when you go back in with your tools, that's the point where you actually go down into the area of the scene.
I'm sorry, that's right. We actually turned left from the door and walked down the hallway to the stairs. Now, we did not enter the stairwell. Sorry.
Excuse me. Before you, as you were going down the hallway, were you looking around at that point to gather information so that you could conduct your analysis?
Well, sure. When I enter a residence, I begin immediately to start to note in my mind what the things that I see there. And yeah, immediately upon entering the house, I started, noticing things and paying attention to things up and down the hallway. I was looking for any kind of blood stains. Okay. I was specifically interested in blood stains that would indicate to me that individuals in the scene had walked through blood and were tracking it in and out of the house.
All right. From the point of the foyer going down the hallway to the left, did you see anything that indicated either drops of blood or transfers of blood in any way?
I did make a note of a transfer stain on the door, on what I'm calling the front door, which is the opening to Kent Street. It looks like the front of the house to me, but there was a transfer stain on the door. If you're facing looking into the house, it would be on the door frame on the left on the inside. If you were facing out, it'd be on the right side. And I noted that upon entering the house. And then there was nothing else that I saw up to the base of the stairs.
And again, what's a transfer stain?
A transfer stain is when blood is on an object, that object has come in contact with another object and transfers blood. It's also considered a contact stain. Those terms are used somewhat interchangeably.
All right. Is the term secondary transfer something that is in use with your vocabulary in this field?
No. I mean, a transfer is a transfer. It's a blood, as far as our definitions are concerned, a transfer stain is a transfer stain.
Okay. Doesn't matter whether it's transfer from something with blood on it onto an object, or whether it's moved 2 or 3 times or something like that, it's still a transfer stain?
I wouldn't be able to determine that. I would just be able to say that this blood was on an object and came in contact with another object.
Okay.
Where the blood came onto the first object, I wouldn't necessarily be able to tell that.
All right. Now, you'd indicated that you put protective clothing on?
Yes.
And exactly what type of protective clothing did you put on your person?
Well, I want to say that I was using their protective clothing, which I believe was a suit and booties that you put on your feet. It's made of Tyvek material. It's very commonly used by crime scene individuals, and it's used primarily to protect one against bloodborne diseases. I usually have suits with the feet already in them, and I think that if I remember that we were using their suits because they were already out. So they were the booties and the suit were separate. And we were taking the boots off when we left the house, putting them back on when we went into the foyer, is what I remember.
Okay. Now, go ahead and, if you would, please describe what you saw as you went down the hall to the left as you entered that scene.
Okay, well, I walked down the hall. The lights were on. There was the lights were on throughout the house, and there was, like I said, sufficient light to see. Eric and I were together as we got to the base of the stairs. We stopped. I asked Eric again, or Mr. Campen, what actions had been taken in the stairs themselves. I was interested in the blood stains that were in the stairs, okay? And so I was very interested in finding out what kind of actions had taken place in that stairwell, okay? Mr. Campen told me that he and the people who were helping him had been in the stairwell for the purpose of taking photographs. He also described to me that he and another person, I don't know their name, had made an attempt to look at blood stain patterns and try to make some little, I guess, analysis or whatever of them, and that they had done that on the on one of the walls next to the opening to the stairwell. And our conversation then went into what I was going to do there, and he asked me if I needed any assistance to accomplish what I needed to do.
In addition to describing what he did in that scene along with someone else, did he describe to you at that point any information that he had about the actions of other people specifically related to that area? In particular, I'm thinking about the EMTs, other police officers, other persons, to include this defendant who might have been in that area.
He did. I was interested again in finding out exactly what the EMTs did when they picked up the victim. A lot of times they will create blood stains, and I wanted to know what the specific actions were, and if Mr. Campen hadn't seen what they did, then who did, so I could speak with them. He also explained to me that Mr. Peterson and his son Todd had been at the base of the stairs, that Mr. Peterson had been contacting or had been in contact with the victim, and that his son Todd had been in contact with him. And we discussed that. Mr. Campen actually took me around past the stairwell and over to a couch and showed me a transfer stain on a couch that was in a sitting room or dining room area. It was in front of a fireplace or in there, and showed me that and told me that Mr. Peterson had seated himself on that couch. I then asked again, or sometime during the conversation asked again, if officers had been in the stairwell, if they had walked through that stairwell or had done anything in that stairwell, and he told me no.
All right. Now, with respect to the immediate area of the stairwell and the hallway that precedes the stairwell, did you see any? What did you see? Ms. Peterson had been gone for a long time. When you got there, she wasn't there.
Yes, that's correct. The victim's body was not there.
All right. And what did you see with respect to blood in that area?
Well, I actually took a photograph of the victim's body in place at the bottom of that stairwell, and then I began to make comparisons between that photograph and what I saw that existed at the bottom of the stairs at the time that I was present, again for the purpose of determining what stains had been altered, changed, or made since that time. And that's what I was interested in primarily. What was at the bottom of the stairs were transfer stains, smears. I think that's basically it.
Did any of the transfer stains in the hall preceding the stairway look like shoe prints?
No.
Did any of those look like bare footprints?
Yes.
Do you recall generally their location?
There were two what looked like bare feet transfers, which means that blood was on the foot and came in contact with the floor, very close to the door opening to that stairwell, and that's all I remember.
Right. With respect to the actual stairwell, describe what you saw there. And let me back up. I want to make sure I understand. You're looking at a photograph that had been taken earlier in the day and comparing that photograph with what was actually on the floor and at the stairwell when you got there for exactly what purpose?
Well, I was looking at it for the purpose of determining, again, alterations of bloodstains at the base of those stairs, which would have been caused by the actions of individuals after the time of bloodshed. EMTs will sometimes do that. Officers will sometimes do that. I see that regularly. I look for that as a common practice in every scene that I enter. And I get people to tell me where that has happened and how it has happened. And if I can, I was very lucky in this scene. I had a photograph readily available to me to do better, to do it in a better way. Sometimes I have to rely just on the word of those around me. But this time I had a photograph and their words and descriptions of what that was. I was looking for stains that had been altered by the actions of others, whether it was the police, EMTs, or other people who were said to have been in the scene.
With respect to your comparison of what you saw and the photograph that had been taken earlier in the day, did you see any differences of significance?
I did not. In my comparison of those things and what they described to me, I saw no significant alterations of bloodstains in that area. And indeed, the stairwell itself looked to be in the same condition that it was when the photograph was taken. Okay, I didn't see any alteration of those stains, and it is something that I'm very experienced with and look for very carefully.
Even if there had been alterations and you found those, is that something that would have affected your analysis to the point that you couldn't conduct one?
I'll object to that unless we specify what the alterations are.
Overruled.
Those alterations would be taken into account, and the alteration and the blood stains where those alterations occur would be given less significance in the scene. However, as is the general rule, there are other parts of the scene where those alterations have not occurred that would be studied and given more significance in the scene. That is a routine procedure and a routine thing that bloodstain pattern analysts do, is that they will take into account all of the information given and place more emphasis on those things which appear to have not been altered than on the things that have alterations. But the alterations in and of themselves will not necessarily preclude those places from being studied for some important information. It's just that the alterations would be taken into consideration.
All right. Now, with respect in particular to the stairwell, generally describe what you saw when you observed that area.
General.
In the stairwell.
Okay. In the stairwell, I generally saw blood stains on the wall to the left of the entrance to the stairwell, which I consider the north wall. Okay. Looking straight across from the opening to what I call the east wall, there were blood stains on that wall also. There were blood stains on the steps. There were blood stains on the west wall, which would be the wall between the stairwell and the hallway. Okay. There were blood stains on what I call the risers, which is the space directly below the stair or the step tread itself. There were blood spatters on those. There were blood stains, as I've already described, at the base of the stairs. There were some blood stains on the walls on the outside of the stairwell. There were blood stains on the what I consider the trim molding on the opening of the doorway itself. On the outside of the stairwell, I found blood stains on a header panel, which was above, which if you were looking into the opening to the stairwell, was up and to your left was a header panel above the walkway into the dining room and the kitchen area of the house, and also to the wall across from the opening to the stairwell. There were bloodstains on that.
Did you see the chairlift that was in the stairwell?
Yes, I did.
What observations did you make with respect to that article?
Well, I noticed immediately that there was I call it a lift chair in the stairwell. It was in the down position. Of course, it can travel all the way from the bottom to the top. It was in the down position. It had blood stains on it, and it had blood stains behind it.
Now, once you made the observations that you described, I think you said you had your tools with you. What did you do?
Again, I discussed with Eric Campen what I was planning to do in the stairwell, and he asked me if I needed any help, and I said no. I don't know what they were doing at the time, but he and Ms. Powell were there at the crime scene. I believe she was still taking photographs. I told him I didn't need any help, but I needed to speak with Ms. Powell. And so somewhere from another part of the house, she came immediately, and we started to look through the photographs. It was necessary for me to have photographs for my examinations, and I started talking to her about the photographs that she'd taken. We had a set of photographs with us. And as we looked through the photographs, and I looked at the walls there, we were outside of the stairwell. We were not inside the stairwell. I explained to her the things that I needed, and did she have a photograph of that area? And she told me that she did. We would look for it. We would find it. Okay. And I told her that I thought the photographs were very good and that they provided for me the information that I needed. And then she went on her way back to doing what she was doing. I then began to do a general examination of the stairwell. What I mean by that is to go in and to start to draw the things that I see, and start a general diagram of blood stains and blood stains in the stairwell.
As you went through that process, looked at the photograph, began drawing your diagrams, did you continue to look to compare the photographs to what you actually saw on the stairs, the stairwell, the walls, the chairlift, the molding? Did you continue to look to compare what you saw physically at that location with what was depicted in the photographs?
Well, I mean, I think I did a couple of times, but then after the point when I originally did it, and I was satisfied that it was in a condition that I could work in, I then really didn't worry about that much anymore. I looked at the photographs from time to time to see if an area was taken that that was important to me, and that's about all I did with the photographs after that.
All right. With respect to the information that you received from Mr. Campen about actions of individuals in the area of the hall and the stairwell, and your observations of those areas, and in comparing the physical surroundings with the photographs, generally, based on your experience and view, how was that scene maintained?
Well, my impression was that the scene was maintained well. In consideration of, I was told when I got there when this situation had been called in, and considering that I arrived so much later, I actually had an idea that the scene was going to be in bad shape. That people would have been working in the stairwell, would have been conducting analysis and doing certain things in the stairwell. And I was very pleased to find that had not happened, that the stairwell was in good condition, that officers had not been in there, that the only walking in there that had occurred was done by Angie Powell making photographs. And the only other thing that I knew about was when the victim and the victim's son had been with the body, and also the EMTs had taken the body. All the other information I had about officers being in other places in the house was no problem for what I had to do.
With respect to the floor area and the stair area. If there had been information that there had been a lot of people in that location, you'd have taken that into account, I assume. Is that right?
That's correct.
Would that have in any way inhibited your ability to conduct an analysis of that area?
Object unless you determine what he would have found out.
Overruled.
Well, it would depend. It would depend on what I found that had been messed up, and I can answer the question. I may totally disregard an area if it has been altered, okay? Or I may take into account some of the stains that have not been altered by other actions, or I may completely disregard the scene itself. That has happened on occasion when I have arrived at the scene and individuals in that scene have altered the ability to conduct a bloodstain pattern analysis to the point where I'm not willing to do that. And the information that would be given couldn't be relied upon. I did not find that in this case. I didn't find any evidence of it in this case. There were some stains in the house that I regarded with less importance or less significance because of the movement of people in the house, but the stairwell was not part of that.
With respect to the walls, I'd ask you about any information you had about movement of people on the stairs, and you've described that and how you took that into account. I'd ask you the same question about the walls. Did you have any information whatsoever that any action had been made with any individual contacting the walls and altering the area of the walls?
There was no information. There was no indication from my experience in looking at that. And indeed, I placed more significance on the walls than I did on any other portion of the scene, based on the fact that Angie had been or Miss Powell had been in there taking pictures. But still in all, I didn't see anything on the stairs that even indicated that Miss Powell had changed blood stains in any way. But the walls, I had less problem with the walls than anything, and the walls were what I was most concerned with.
You know, with respect to your objective when you got there at the scene and made these observations and had the conversations with Mr. Campen that you had about activity in the area, what was your precise objective when you got there and made these observations?
Well, the information that I had been given was that the victim had fallen, okay, had fallen down the stairs. That was the information that I was given. Therefore, the question to me and what I was in the stairwell to determine was, are the bloodstains consistent with a fall, or are they consistent with other actions? That is the simple question that I was there to answer. That was what was asked of me at the Durham Police Department. Are these stains consistent with a fall, or are they consistent with some other action? And that's what I was there to answer.
And with respect to...
Mr. Harden, let's stop right here.
Yes, sir.
All right, members of the jury, we'll take our afternoon recess. Remember the instructions I've given you throughout the course of this trial. Keep an open mind. Don't discuss the case even among yourselves. Stay clear of the parties, the witnesses in this case. Don't watch it on TV. Don't read about it. Don't do any independent research or investigation. We'll see you tomorrow morning at 9:30. Or is there any other matter before we break?
We previously asked
Okay, that was weird. Why is it blue?
for diagrams. I'm now told that he made diagrams.
It was the back. It was the back staircase. That was the kitchen staircase. That was the back kitchen staircase. The main staircase was inside the front door, and it was like this elaborate ornate staircase. This was like a little narrow staircase. It just went from the upstairs, like around the bedroom area, down to the kitchen. Hey, Jill, welcome back. So they didn't need to go up the staircase to get upstairs. They could have gone upstairs the other way. Okay, you're gonna have to. Spike was barking. What did they say? I heard him say something about there was blood on the chairlift and under the chairlift. But what did he say about the chairlift as far as the injuries? Did she hit it or what did he say? Do you remember? Because I missed it because Spike was barking. All I heard was that there was blood on it and under it. Because of loudmouth.
Diagrams, apparently. I thought that we were supposed to get those ahead of time if they're part of the basis of his opinion, which apparently they are, and we have still not gotten them. So I'm going to ask the court to order the district attorney to provide us with whatever diagrams or other things he relied upon in coming to his opinions.
Mr. Hart?
Your Honor, we've given them a number of diagrams. I've asked Mr. Deaver to go back through his file and make a copy of everything. I'd be glad to provide that. They've been given a lot of diagrams, so we can turn those over to you.
No diagrams with regard to 12-9. We've been given diagrams with regard to the experiments that were done in September of 2002, and I think I'm entitled to the diagrams ahead of time, not in the middle of cross-examination. So I'd ask that they be turned over forthwith.
Actually, I disagree. As far as I'm concerned, he's not entitled to those things until the witness has testified. We provided him a lot of information prior to the witness testifying. We now have it. I'll give it to him, even though it's state's position. He's not yet entitled to it.
Well, under the discovery statute, I think I am entitled to it, but I'll let the court resolve that.
All right. Well, you understand what his request is, Mr. Harden. You all got overnight. Check with Mr. Deaver. If they exist, inform the court whether they exist or not, and we can hear whatever arguments need to be heard.
Yes, sir. No, there was one other request of the defendant. He had asked whether Mr. Deaver had a resume. They've already subpoenaed numerous documents from the files of Mr. Deaver at the State Bureau of Investigation. We've already had cross-examination about several aspects of that, one being a transcript of Mr. Deaver's training and courses that he's taken. I think there are several documents relating to various job descriptions and job assignments that he has had. And there also descriptions of courses that Mr. Deaver has been involved with as a teacher and some information regarding responses that those courses received from some of the participants. That's been provided through the State Bureau of Investigation based upon the subpoena they issued. Mr. Deaver doesn't have a current resume. It's more than 10 years old, and I don't think he ought to be required to provide one. And so that's where
with all due respect, Mr. Deaver has testified under oath that he has a CV. And I think that I am entitled to see his CV. He's now testified that there are certain things that do not appear on the training records that we got. He claims that he's taught courses that they don't have records for. And if I need to issue a subpoena to him directly, I'll do that. But I think I'm entitled to a copy of whatever CV he has, whether it's 10 years old or more recent. I can tell you that the transcript I saw where he talked about having a CV was not 10 years old.
All right. I'm not sure I understand.
I'll issue a subpoena if that's what
Well, I'm not sure I understand what the issue is.
I'm asking for a copy of a CV.
And Mr. Harden, you were indicating he does not have a?
He's indicated to me he does not have a current resume. What he has is approximately 10 years old.
Whatever he has, Your Honor.
All right. Well, he's requesting whatever he has, Mr. Harden.
Your Honor, the state's position is he's not entitled to it. He's gotten information from the State Bureau of Investigation with respect to training and job descriptions and coursework that this witness has been in, and I don't think he's entitled to his CV or resume, whatever, however he wants to characterize it.
Well, I think I am, but as I said, I'll be happy to issue a subpoena if that's what I have to do. But I'm asking the court to order that the CV be brought to court, so when I issue the subpoena tomorrow, he'll have it, and then he can turn it over in response to a subpoena.
All right. If he has one, Mr. Harden, the state needs to be prepared to produce it tomorrow, sir.
Yes, sir.
All right. Anything else?
Yes, sir. No, sir. I apologize.
Please.
This case is ridiculous. If it's an expert witness, they have a resume or a CV or whatever you want to call it, that is discoverable, and the defense attorney needs to have it along with any other reports, diagrams, whatever he's going to be testifying from. Oh my God.
Stuff together.
Yes, sir. It was just a momentary blank spot.
I understand. That's all it takes. Mr. Rudolph, anything else? 9:30.
All stand. We just Superior Court County and Durham stand in recess until 9:30 tomorrow morning. God save the state and son of court.
Andy.
Issue before we get started.
Just for the record, I have gotten a copy of what appears to be a CV from Mr. Deaver. I have not gotten any notes or diagrams yet, and I am requesting those to the extent that he relied on those in doing his work and forming his opinions. Also, just for the record, we got a statement from a CID investigator.
Hold on for me, sir. Is that the only juror missing? Just let him come on.
Sorry.
Apparently there's a juror.
I'm sorry.
All right, Mr.
In any event, we got a statement that was given to the prosecution by former Army Special Investigation Division agent by the name of Lyons, Stephen Lyons. That statement did not have a phone number, and I don't think it had an address, so we have no way of getting a hold of him. I don't know if Mr. Harden is planning on having him here for the hearing on Ratliff or not, but his testimony is obviously critical because his testimony is completely contradictory to the testimony of several other people with regard to what the scene looked like on that particular morning. If Mr. Harden is not planning on bringing Mr. Lyons here to testify, we'd like to get a copy of his address and phone number so that we can contact him and bring him here ourselves.
Mr. Harden, let's back up for a second to this witness. Diagrams that he used in formulating his opinion, are you aware of any? Or?
Yes, sir, I have those. He's provided those to me, and I'll give those to Mr. Rudolph this time. I've also provided, as he indicated, a copy of the resume. Just for the record, this resume is approximately 10 years old. There is not a CV. Mr. Deaver says that he has not had a CV since he was last in the lab, which was more than 9 years ago, to the extent that it would be different than a resume. He doesn't have that. It's not available to him, but we have provided the copy of the last resume that Mr. Deaver prepared. Again, it's approximately 9 to 10 years old. And with respect to the address of Stephen Lyons, we'll be glad to provide that to Mr. Rudolph.
All right. Anything else then, Mr. Rudolph? Are you
satisfied with that the state has complied with at least your request?
Yes, sir.
All right. All right, Mr. Harden, if we can bring your witness back on the stand, and we have all our jurors now?
Yes, sir.
All right, so you can bring them out. All right, Mr. Harden?
Yes, sir. Now, Agent Deaver, yesterday we were at the point where you were describing what your objective was when you went into the scene at 1810 Cedar Street. I think you described aspects of the scene, but you hadn't quite completed that. So I want to go back to that point from yesterday afternoon. With respect to the objective that you had when you went into that location, if you would please, again, describe that to the jury, if you would.
Well, if I might preface that for just a little bit, bloodstain pattern analysis is a very good crime scene technique when used to determine if statements made about a scene are consistent with what the scene looks like or not. The information that I had been given was that there was an accidental fall in the stairwell of this home. And so when I went in to look at the blood stains, I was looking at and interested in determining if the blood stains that were present were consistent with a fall or were they consistent with some other action, different than a fall. And when I'm talking about actions of a fall, that would be some blood source that had come in contact or impacted a surface, whether it be the stairs, the floor, the wall, or the corner of a wall. And then if there's other stains that indicate, for instance, impacts in other places, then they would not necessarily be consistent with the stated actions.
Now, with respect to that objective, what was your primary focus as it related to the surfaces that could be involved with this scene?
Well, I was interested in all of the blood stains, obviously, that were in the stairwell, but my focus became I primarily became focused on the walls themselves, especially in the corner, and that's related to my initial review of this or initial look at the blood stains themselves, and also if the stains on the wall are impact spatters and they come to a point of origin somewhere other than a surface, then we would have actions inconsistent with a fall.
Now, why do you say that if you have impact spatter that indicate points of origin other than a surface, it would indicate to you something other than a fall?
Well, what I'm saying is, again, the examples that I gave yesterday about an impact or a point of origin. A point of origin would be a source of blood somewhere that it's impacted, and those blood stains strike a target, a wall or whatever. If that impact spatter, when reconstructed, comes back to a point in space, that means that the source of blood was not on a surface. In other words, an impact.
At Epcot, in the Canadian Pavilion, they have maple popcorn. It's like caramel, but it's maple. It is so good. Oh my God. And the past 2 times I've gone, I've forgotten my popcorn bucket because it's only like $2.50 or something like that if you have your own popcorn bucket. So next time I go, it's so good.
Had to come in contact with that source of blood somewhere other than a surface, either the steps, the floor, a wall, or corner, anything. If I have points of origin out in space, that would be inconsistent with a fall.
Right. Now, with respect to blood staining generally, as you approach a scene such as what you had at 1810 Cedar Street, exactly what are you looking for?
Well, I'm looking for I'm looking for the common stains that I described yesterday in the little thing that we did up here on the flip chart. I'm looking for drip blood or blood that's been acted on by gravity. Okay, and then again, that would be fairly large drops, maybe puddles of blood, those kinds of things. I'm looking for that in general terms. I'm looking for impact spatters, blood droplets that have been acted on by force to cause them to break up into small droplets, okay? And also the fan shape on the wall of those impact spatters. Again, if I impacted something and that blood spatters on the wall in a fan shape, okay? And in general terms, I'd go into the crime scene and start looking for those. Do I have small drops? Do I have that fan shape pattern on the wall? Transfer stains. Again, the force of that would be pressure. Do I have stains in the scene that have been created when something with blood on it came in contact with something else? And I would start to look at those and start to kind of separate these patterns as I begin to do my observations. Cast off, we talked about centrifugal force and the sudden stop, which creates a certain type of bloodstain pattern. Those patterns, again, that's a force somewhat in between gravity and impacts. And so the blood drops are going to be medium sized. And so I go in and start looking for medium sized drops, but also cast off stains are frequently an inline pattern. That's how they're described. In other words, if we go back to that, we've got blood on an object and it's being swung and the force is now causing blood to fly off of that object. Those are going to be in lines, okay, in the scene many times. And so I go in and start looking for those kinds of things. In general terms, I start looking at the scene as a whole. What do I see there? Do I see these fan shapes, inline patterns? How big are the drops in comparison to each other and to patterns?
Now, a moment ago and yesterday, I think you were talking about impact spatter in particular, and you indicated that the greater the force, the smaller the blood stain would be.
Yes, and that's a general rule that the greater the force, it breaks up the droplets in smaller and smaller drops. So if I find very small drops in one of these patterns, I'm looking at some significant force many times. Of course, you have to look at the scene as a whole and patterns as a whole. And so I'm taking into consideration all of these things. An impact spatter pattern can have larger drops in it also. As I said before, the smallest drops, they don't fly very far, and so they're going to be close to where the pattern begins. The bigger drops, having more mass, are going to fly to the outside. If we were looking at that fan pattern again, you might generally look at the largest drops being on the outside of that fan and the smallest drops being close to the middle of that pattern or fan.
Now, with respect to the size of drops, say in a fan where there's impact spatter, are you able to determine with precision what the velocity would be of the drop as it leaves the source and strikes the target?
No, you wouldn't be able to determine that. There's a lot of variables that are involved in that. You would just be able to determine in general terms the force that was applied to that drop.
Right. Now, I think you indicated yesterday that when you got there, you at least had an idea that the scene might be in pretty bad shape.
Well, when I say that, no one told me what the condition of the scene was. When it's been many, many hours since the situation has first been seen or the police have been involved with, it's been my experience that the scene over time will be degraded because of people being in the scene, of work that's being carried on in the scene, and the normal process of processing the scene itself. And so when I began my travels here to Durham, my thought was initially that I needed to be, pay attention and see what the condition of the scene is. And the way I did that was to glean as much information as I could from the officers who were there and the people who were working there as to what actions had taken place in that scene.
Now, with respect to your thoughts, I think you indicated yesterday that when you got there and made your initial assessment, that you were pleased that the scene was in the condition that it was in.
Well, that's based on the blood stains in the stairwell themselves. I was concentrating for my information on what I do, and that is that I go in and look at blood stains. And so my questions about the scene related to the stairwell. And as I began to get information and realize that there had been very little movement in the stairwell itself, except for what I thought, down at the base of the stairs, which was natural to the information given, I was very pleased to believe that I could go in and do an examination of that scene and to make the determination or answer the question that was being asked of me by the Durham Police Department.
Now, with respect to your involvement in a case such as this as a bloodstain pattern analysis expert, what discretion, if any, do you have as to whether you actually work the scene?
Well, I have total discretion. It's when I'm called to a scene, and understand that I'm called to provide assistance to other agencies. That's what the mission of the State Bureau of Investigation is. We are called in by local law enforcement to provide expertise in areas that they may not have or that we have greater training for. And so I'm regularly called to scenes all over the state by police departments. And I'm also called to scenes that the SBI is actually responsible for, providing assistance there. I have total discretion, whether it's an SBI case or a local law enforcement case, to refuse to do that blood spatter scene if I deem that the condition of it would not provide reliable results.
Have you chosen in the past not to work scenes because the scene was degraded to the point that you didn't feel you could render an appropriate and relevant analysis?
Yes, I have.
Approximately how many times have you had to do that?
Probably 2 or 3 times.
Okay. Now, with respect to your initial assessment of the scene, you had described that what you were focused on, what your objective was. If you would please, well, let me back up. With respect to the greater scene, you talked about the fact that you're focused on the stairwell.
That's correct.
With respect to the greater scene throughout the house, if we had concentric circles and the smallest circle is right there in the stairwell where you're focused, and then we go out from there, what relevance or consideration did you give aspects of the greater scene as it left the area of the stairwell or was located a greater distance from the stairwell?
Okay, I would give the greatest relevance to the stairwell itself, and especially to the walls, okay, because no one was walking on the walls. There was no indication that anything had occurred to the walls themselves, especially in the corner of the stairwell. Then the floors themselves, because I knew that someone had walked in the stairwell taking photographs, then I need to be very careful there, okay? As we go outside of the stairwell to the place where the body was found, then there have been EMTs there and others have perhaps walked by there, and so you need to be more careful there. As you leave the stairwell altogether out of the hallway, then again, based on the information that I had that officers had been in those areas, that other individuals had been in those areas, then less relevance would be paid to bloodstains found in areas outside there. That is all a mental exercise that I performed as I went to that scene based on the information that I had. For instance, I took a look at the blood at the door and the couch, as I mentioned yesterday. Those were all consistent with actions that were indicated to me had occurred in the scene where Mr. Peterson and his son had blood on them, and they had been in those areas. And so I looked at those and I said, well, that's consistent with those actions. And so less significance was paid to those things. Again, what I was interested in was answering the question, is it consistent with a fall or some other action? And so that led me to specifically the walls. And then, I looked at all the stains on the floors too, but.
Right. Now, once you, again, made your initial assessment, you have your tools there. What did you do from that point forward?
Okay, well, as I said yesterday, Mr. Campen, I told him what I was going to be doing there. He had other things that he needed to do. He asked me if I needed any assistance. I told him no at this time. And I put my tools down outside of the stairwell. And then I began to do an assessment, as I said before, looking at the types of patterns that I see in the stairwell. And I did that for some period of time, just simply looking at the scene, studying it, using my experience and having been in many, many scenes to start to guide me as to what actions may have created those stains in the stairwell. I then took out my notes and started doing the diagrams and drawing of the blood stains for the purpose of my notes and writing notes to the things that I'd seen.
And with respect to the diagrams and the notes, I mean, what are you focused on?
Well, the same kinds of things. I'm basically going over what I've already gone over with my eyes and in my mind, and I'm starting to draw those things out and really focus in and get very close to the stains to look and see what they look like, how big they are. Also, I start looking at the directionality. I start looking at the drops with the little tails and determining from where points of origin are, where these impacts may have occurred creating these stains. And I start drawing those things out.
Is that typically the process you go through in every scene that you work as it relates to blood stain pattern analysis?
Yes, that's correct.
Okay. Now, go ahead and describe what you did as you continued to process the scene and how you went about that.
Well, there were some questions that I had. As I began to make my notes, I realized that the steps needed to be numbered. I called for Mr. Camp and he came back. I asked him how they had already numbered the steps, and he indicated to me that they had numbered them from 1 to 18 from top to bottom. And so that's how I numbered them.
It's been 84 years.
Also suggested to sometime during this process of taking notes and working in the scene itself, I asked for Mr. Campen again. I told Mr. Campen that he might want to do a luminol. Did he have luminol chemicals, and was he available to do that? And he said yes. And I said that perhaps someone had walked in the scene at a time when the blood was wet and perhaps had blood on their feet, and that it might be useful to determine where they went. I was specifically talking about the top of the stairs for him to do that, and he agreed that that was something that he probably ought to do. I did tell him at that time that he shouldn't spray luminol in the stairwell at any time for any purpose, and that's something that we don't do anyway. We don't spray luminol on visible blood. It's not for that purpose, and actually it doesn't help the scene at all. It's not good for the scene, so we don't do that. And I made sure that he understood that, and he said yes. And then he went off to prepare for that. And then I continued my study. Sometime later on, I decided to take a break from what I was doing. I just walked around the corner to get out of the scene for a few minutes and just rest. And I went into the kitchen area of the house and just standing in there, thinking about what I was doing, taking a little bit of a rest. and then went back from there. I did notice some things in the kitchen area at that time while I was taking that break, and then I went back to the stairwell and continued the process of taking notes, doing measurements, and began the process of actually marking spots on the wall or blood stains on the wall for doing a reconstruction. What I mean by that is doing the measurements of the length and the width of the drops, and then pulling the strings to find points of origin. Sometime later on in the night, I started pulling those strings, and I asked for assistance again. And this time, Mr. Campen and Mr. George, I believe it was, came back and asked what kind of assistance I needed. And I was, the stairwell is very tight up and in the corner where I was working. And so I asked them if they would to hold strings for me as I did the stringing process. After a period of time, when they had helped me with that, I told them that I no longer needed their services. And so they went back to doing whatever it was they were doing, and I continued the stringing process. Upon completion of the stringing process, I took notes on what that information gave to me. I then asked for Mr. Campen again and Detective Art Holland, and told them that I would like to know about the clothes that had bloodstains on them that Mr. Campen had told me about earlier. I wanted to know about the condition of those clothes, how they had taken the clothes from the individuals, and what had occurred with those clothes. They indicated to me that the clothes had been put out to dry in one of the rooms of the home, and after they were dry, that they had been packaged and taken to the police department. And so at that time, I asked if I could go and see them. We then proceeded to the Durham Police Department, and those clothes were taken out of evidence and put out for me to look at. I made some preliminary notes on that clothing, and then I left the Durham Police Department.
All right, now let me go back for just a little bit. With respect to the instruction that you gave Mr. Campen about the luminol processing, was there any discussion about that prior to your suggestion of it?
No, there was not.
Did you watch as he performed the luminol processing?
No, I was doing my work in the stairwell. He and I were discussing the process, and he was asking me questions because I do have expertise in that area. He was asking me a few general questions about it, and things that just general things about things that he had seen in scenes, and we were having a discussion about it. But he and Mr. George were actually, I believe Mr. George was there, were actually standing at the top of the stairs while they were preparing the chemicals for that. And I was down in the bottom of the stairs, and we were just talking back and forth. When he began, of course, the lights had to be out. And so that prevented me from working for a little bit. But after they moved on, then I could turn the lights back on in the stairwell. I, however, did not go up to see what he was doing.
Do you know exactly how far from the top landing the luminol was sprayed?
Well, in the beginning, none was sprayed in the stairwell itself. I had told him not to do that. As he progressed up there, he then came back and asked me if he could spray on a few steps at the top of the stairwell. And what the purpose of that was, if there were a trail that began in the top of the stairwell, then he wanted to follow that from that point onto the top floor of the home. I told him that would be okay to do that because I had finished my examinations at the top. There was very limited blood up at the top, and from what he was describing to me, it wouldn't affect someone else's ability to come and take a look at that blood later because of that. I did again caution him not to spray luminol down at the bottom, and he said he understood, and so he proceeded.
Was anybody even down at the base of the stairs where you were working while Mr. Campen was conducting the luminol processing at the top of the landing area?
No. I was by myself down the stairs.
Okay. Now, approximately how long did it take you to go through the process of looking at the staining patterns, making your notes, making your diagrams, using your protractor and drawing the strings as you indicated so that you could, in essence, conduct your analysis? About how long did you take to go through that whole process?
I was in the stairwell probably about 5 hours, all told.
Okay.
And that does not complete the process of doing an examination of that scene. A lot of that time is spent doing documentation and preparing to do further observation from photographs and your documentation and those kinds of things.
All right. Now, you had indicated that you asked to go back. Well, you asked about the clothing, and I think you indicated to the jury in one of your earlier responses that the clothing on persons involved at the scene is very important to you. Is that right?
It's very important because the stains that are found on clothing can very often tell you the actions that those individuals have taken.
All right. Now, with respect to the clothing that Mr. Peterson had on, you were told exactly what with respect to their location and how they were handled?
Yes, it was told. Well, it was told me that they were removed from the individual, and that they were taken to another room of the house, and that they were put out to dry. I asked specifically about that because that is exactly what, as a bloodstain pattern analyst, I want to have happen. The best thing to do would be remove those clothes and as quickly as possible put them somewhere so they can start drying. And so that's what had occurred. And again, I was a little bit surprised that the clothes had been taken that good care of, because that's not something that happens all the time.
With respect to putting the clothes in a place or location where they could dry, what significance is there to whether they're folded, whether they're laid, or whether they're stretched out? Are those things that are going to be of concern to you?
Well, they absolutely will. If the clothes are wet with blood on them, and you take a set of clothes that have blood on either end of them, let's say that we've got a pair of pants and you fold them over, you've now created other stains. And that's certainly something that we don't want. Those are called artifacts. And it's just like if you created artifacts in the crime scene. The EMTs roll a gurney that's got blood on the wheels, and you create an artifact. If you fold clothes over that are wet, it does the same thing. If you put clothes together that are wet, it does the same thing. Those artifacts, through experience, you can find and you can see, and there still may be information that you can glean from that clothing by noting the artifacts and you might say disallowing them as part of your observation, but you'd rather not have them.
Did anyone give you any indication whatsoever that Mr. Peterson's pants in particular had been folded together?
No, they did not.
I think you indicated that you asked to see those clothing.
Yes, I did.
Did you see any evidence that the pants of Mr. Peterson had been folded together?
No, I did not. And that night, again, I want to be very careful about things like artifacts. And so one of the reasons that I was looking at the clothing was to see if they had been handled improperly, had not been dried before they were, bagged or packaged or whatever. And I looked at those for that. Now I was just looking, kind of as an observation then. I would do a detailed study later of the clothing, but I was looking for that.
All right. Now, with respect to the clothing, I think you did that after you had essentially finished all of your work at the scene. Is that right?
That's correct.
And if you would please describe to the jury how you went about examining the clothes. I think you did that at the Durham Police Department.
Yes, I did.
And with whom were you going through that process?
Detective Holland and Mr. Campen were present, I believe. I think that's all I can remember that were there. But and they were the ones who had to get it out of property and to bring it out. And they opened up the bags and took the clothing out for me, and it was spread out on brown paper on top of a table. And then I, with gloves, simply looked at the clothing for the front, turned that clothing over to the back and looked at it again, did some very rough sketching of it and where I saw stains on it and some notations on things that I noted about the clothing. And then it was put back in the bags and taken away. Those observations were not very long.
Okay. With respect to the clothing being packaged in paper bags, is that something that would be of concern to you?
Yes, that is the proper way to package bloodstained clothing, in that the paper breathes, and whatever moisture is naturally in the clothing from humidity in the air or whatever will continue to leave the bag, or in other words, it'll keep the bag's clothing. If that were packaged in plastic bags, moisture that's in there would start to degrade the blood because of bacteria. And so it's a requirement that they be put in paper bags.
Okay. Is that the only occasion that you've looked at Mr. Peterson's clothing?
No.
Okay. And you've done that on several occasions throughout this process?
Yes, that's correct.
All right. Were there other articles of clothing that you looked at that time as well?
I believe there were a pair of socks and a pair of shoes. And I may have looked at the shirt too. I think I did. I think I looked at all the clothing, Mr. Peterson's clothing.
Were there other articles of clothing taken from other individuals that you were aware of at that time?
Yes, I did. I was aware that that Mr. Peterson's son Todd, that clothing had been taken from him also.
Did you look at that clothing at that time?
I don't think so.
Okay. At that point, no clothing from Miss Peterson had been collected, so did you see anything related to her?
No, but I did ask that if anyone whoever from the Durham Police Department was going over to the medical examiner's office to pick up items of evidence, that clothing be handled very carefully also, and in the same manner that that Mr. Peterson's clothing had been handled, because I would very much like to look at it.
Okay. At some point, did you do that?
Yes, I did.
Now, once you had made your initial observations of the clothing at the police department, what did you do?
I returned to my residence.
Okay, now let me go back for a few minutes, if I could, to the scene before you actually go look at the clothing. I think you had indicated that you were in the stairwell and you'd been working for a while and you were going to take a break.
That's correct.
With respect to that, what did you do?
Well, I just simply wanted to get out of that stairwell, which is an enclosed space. I'd been in there for some long period of time, and I wanted to just kind of, refresh myself a little bit. And so I just simply walked out of the stairwell, walked down the steps to a little room that's there, or a little area that's there, I guess adjacent to the dining room. I walked over to the fireplace. I was interested in looking at the fireplace for something, and then I walked around to the kitchen. Basically, I was just standing in the kitchen when I began to notice a few things in there that I reported.
Now, when you were in the kitchen at the fireplace, did you see anything that looked like this?
No, I did not.
And for the record, this is marked as State's Exhibit 72. Were you kind of looking in the area for anything?
Object deleted.
Well, he said he was over.
Looking for anything that like this while you were in that area?
Yes, I was.
Okay. Now, if you would please go ahead and describe what other observations you made while you were in the kitchen.
Well, while I was in the kitchen, just standing there kind of thinking, I happened to notice some blood stains in the kitchen, and they were specifically on a cabinet.
Jill, you weren't here this morning when I was telling you guys about the last few episodes of the documentary. Well, they found out after he was granted a new trial and right before he took the Alford plea that the cops had found the blowpoke, the mysteriously disappearing blowpoke that they never could find throughout the whole trial. That they found, like, well, I guess they found it during the trial. Like a year later after she died. They found it during the trial. And it was in the garage and had cobwebs on it and bugs on it, like old dead bugs that had been in the garage and just abandoned for so long. They found out that the cops that night, the night she died, the cops had found the blowpoke. They found it and they photographed it. And they didn't seize it. They didn't even put the photographs of it in discovery. And they put it in the garage where it was found a year later with the cobwebs and the bugs on it. All that time they were saying they didn't find it, they never saw it, when they actually saw it and photographed it. And they've got a blowpoke in the courtroom that is not the blowpoke, it's one like it. When they actually had found the real blowpoke with no blood or anything on it. This man really did deserve another trial.
In the kitchen, and I noticed where they were, and they were of interest to me. And I started looking around and saw some things that kind of fit together to me. And so I made a note of this.
To that characterization.
Overall,
I'm not saying he didn't do it. I'm just saying he did deserve to get another trial. And because he did go to prison for 8 years and he took the Alford plea to voluntary manslaughter, it ended up time served and now he's a free man, which I'm not happy about because I don't know now. I don't know. He still swears he didn't do it. And because his trial was such a mess, I don't know. But the jury convicted him on lies and innuendo. So who knows?
I made a note of those things that I noted, and that seemed to fit together to me because of some bloodstains that I saw.
And where were those bloodstains exactly?
The bloodstains, well, there was a drip, there was a drop of blood. Again, going back to gravity, this was a fairly large drop of blood that was on a countertop under the kitchen cabinets, all the way at the end of the kitchen, or what I would say would be the south side or south wall of the kitchen. There was also a transfer stain or contact stain on the knob of one of the cabinets. Okay, in other words, something with blood on it had contacted that knob, and upon opening up the cabinet door, there was also a transfer stain on one of the shelves of that cabinet.
Madam, may I approach the witness, please?
Yes.
Now, let me show you what is marked as State's Exhibit P55 and ask what.
Yeah, I break up and then we get back together. Then we break up and we get back together. Then we break up.
You can identify that, please.
Yes, this is the kitchen area where I was taking a break. Just standing in there, really.
Okay, if you would please generally describe to the jury where you were in that photograph, or at least relationally where you were in that photograph.
Well, the tape, there is one difference. That tape was not present when I was doing my work. And I had, the fireplace that I was describing is say over here. And I walked over to that fireplace and I was looking for something over there. And then I walked around the couch and I was just standing here at at the bar, again, just kind of taking a break, walking around. I had been in a crouched position for a fairly good long time in the stairwell, and so I noticed this. I could see the what looked like a blood stain on this cabinet, and this is where it is, way down here on this end, and that's when I noticed the things that I talked about.
Let me show you what's marked as State's Exhibit P234 and ask whether you can identify that.
Yes, that is the cabinet on the far end. And what I'm calling the south wall of the kitchen is this wall right here. This is the countertop. This is the cabinet door with the knob that had blood on it. And then this is what I call the first shelf up. Okay. And that blood stain would be right here in this area next to the divider between the two cabinets.
And I'll show you what's marked as State's Exhibit 180 and ask whether you can identify that.
Yes, this is a close-up of that same cabinet that had glasses.
Before we go any further, what does it represent as it relates to what's marked as State's Exhibit P234?
Represents the glasses in that first shelf.
Now we move into evidence what's marked as State's Exhibit 180. It's allowed. Could the witness step down and show the jury these photographs and what he's describing?
Yes, sir.
Closely. We'll copy this half for the jury and then that half.
This is the kitchen area that I was describing. This is the south wall. There is a door in that goes into another room. I didn't cross through that door. And this is the cabinet on this end. It is the cabinet that is actually mounted to that wall. So it's the very end of those cabinets there. Again, this is the kitchen area that I described. This being what I described in my report as the south wall, that would be the end cabinet where these blood stains were found.
What about with respect to the cabinet? Where was it exactly? Where's it with this?
The blood stains? Oh, yes. Okay. This is, you can see the knob actually on this cabinet, and it was on the knob. There was a stain on the edge of this shelf here, and then the blood drop was on the close to the south wall, was on the top of this countertop.
I can show that.
It's hollow, so you can blow through it to blow air onto the fire and poke, which it seems awkward. It's so you don't have to put your face too close to the fire to blow on it. So it's long, so you can blow and then poke at the fire at the same time. I've had 2 fireplaces in my life. We've never had a blow poke ever. And I've lived in Florida my whole life. We've had 2 fireplaces, believe it or not. I don't understand. Yeah, that's exactly what it is. Long iron pokey straw. I don't understand why you need, you need to poke and, stir it up. Because, if you've got fire in one spot, it goes out another, you have to, stir it. But, and, some fireplaces, some people use a bellows to put air, but I've never, why do you need to add air? We've never had to add air to the fire. I don't understand that. You just move it around with the poker. I don't know why you have to add air to it.
This is the south wall. This is the end cabinet, and the blood was on this knob here. Okay, and on the edge of this cabinet in this place. Okay, and then that drop was close to, was on this surface here, and it was close to this wall, and that was a perfectly round drop. Okay, and so the source was above it, and it had dropped straight down
onto the counter.
Onto the counter.
All right. And with respect to what's marked as State's Exhibit 180, can you kind of show from a relational perspective where this item is as it relates to what's marked as State's Exhibit P234?
This picture is this area right here. It is that shelf.
Now, are you able to see the drops or stains that you've described on the cabinets in what is marked as State's Exhibit P180?
No.
Just so the jury has some idea how large they were, what could you say?
Well, they were the stains were a transfer stain is not always a real heavy stain. I mean, it's a real light stain sometimes, and it was a light stain. On the knob and this, it was a light stain. On the countertop, it was just a drop, like a small drop that, much like the drop if you cut your finger and it dripped down. That's what it. It's just a little drop.
Okay, if you would please take your seat. Now, with respect to the observations of the countertop and the cabinet and the knob on the cabinet, did you also have other observations in the area of the kitchen that were of significance or importance to you?
Well, that blood being in that area, it was fresh blood. It was bright red. And so it was an indication to me that someone with blood on them had been to that cabinet. I looked into the cabinet to see what there was in the cabinet, and I saw that there were certain type of glasses on each shelf there, very unique glasses not just a round drinking glass, but they were unique.
Okay, I know. Dang it, I separated my windows again. Y'all know how I hate when I get my windows separated. Okay, I realize there's very few people in here now, but Judy and Joe, I know, are here. Probably maybe still Marty. Maybe Nancy. I don't know. Anyway, is it just me? Does anybody else think that they're making a big deal over the blood smear or whatever was over by the cabinet of glasses? Because what I think happened is either, okay, so maybe he did it. At this point, I don't know anymore. I have thought for years he did it, but now I don't know anymore. Because now that I have watched the documentary and watched the trial, or started watching the trial, I don't know anymore. But I think whether he did it or whether he just laid on her dead body and got blood on him, either way, and I think Todd did the same, got her blood on him. And then while the cops were there, or maybe before the cops got there, they went over and got a glass out of the cabinet. And they got blood there, her blood there, from getting a glass out of the cabinet. Why is that such a big freaking deal? I don't understand why they keep talking about the blood smudge or smear, whatever they're calling it, at the glass cabinet. Why is that such a big deal? What does that have to do with who killed her? I don't understand why they're making a big deal out of it. Does anybody else feel the same way I do about the Diet Coke can and the smudge of the glasses? What does that have to do with who killed her? All that tells me is they got a glass out and a Diet Coke, and they were thirsty while the cops were there investigating his wife's murder. I don't understand why it's a big deal. I don't get it.
And I looked around the kitchen to see if there were glasses sitting in the kitchen that were like that, because if someone with blood on them had gone in that cabinet, perhaps they had gotten a glass, and that would lead to maybe another place where there was blood or whatever.
Excuse me, go ahead.
And so I did look around the kitchen, and I found...
This video is 3 hours long, and we're 45 minutes in. What time is it? It's 4:30. We're not going to make it through this video, you guys.
Glasses like those on that shelf in another part of the kitchen.
Where were they located?
They were located on a bar beside a sink that actually is kind of a continuation of that entire countertop. From that south wall all the way around, out on the end is a bar that sticks out, and there's a sink in it.
And with respect to the cabinet, in your observations, was the door closed, or was it open, or was it completely open? If you would, please just describe what you saw.
Well, the cabinet door was open. It was open. It wasn't open all the way. It was just open a crack or so. Like it had maybe it had even closed and just didn't close all the way, but that's how I observed it when I saw it.
But you don't know whether it was like that earlier in the day. I mean, at this point, it's late in the evening of the 9th, isn't it?
That's correct. This is late in the evening. I don't know exactly what time, but it would have been some hours after I had begun my work.
Okay, we're going to stop there. I wrote the timestamp down. So we'll continue from there. If I realized that video was that long, we would have quit 45 minutes ago. Yeah, I don't get why they're making a big deal about the little blood stain by the cabinet where the glasses are, and the Diet Coke can, and I mean, yeah, they have to process everything, okay? Process it, mention it, and then move on. It has nothing to do with who killed her or how she died. It's just, yeah, you have to process it because you have to process everything at the scene. And it has blood on it. So, yeah, process it. But why do you keep coming back to it over and over and over again? No wonder this trial was 4 months long. But it is really sad if you stop and think about it. Our justice system is innocent until proven guilty. And then you have people like Deaver that want to make the evidence fit into the theory of the crime so that they can convict someone because they've been arrested. And I was at the beginning of this, and it's not because of the trial that I feel this way. It's from watching the documentary. But, because at the beginning of this, I was like, well, because of Deaver and his stupidity, now this murderer is free to live the rest of his life free. But now I have reasonable doubt. I don't know now if he did it or not. Because of all of the things, if it had been just Deaver, which is what I thought at first. I thought it was just Deaver. It's long, Jill. It's like 13 episodes. It's like 13 episodes, and each episode's like a couple hours. So it's going to take you more than just one sitting to watch it. But when I thought it was just Deaver, I thought one person screwed this up. He was guilty, and one person screwed it up. He got a new trial because of one person. But now, by the time I finished it and found out about all the other lies, not just screw ups, lies, out and out lies. The biggest one about the blowpoke, because they kept saying through the entire trial. Now, I hope to God the district attorney wasn't in on that. I hope to God he didn't know that the cops found it, because the district attorney threw the whole entire thing. I mean, he's got the blowpoke there. It's not the blowpoke, but it's a blowpoke. He's got it there and he's showing it to Deaver. It's in the courtroom. So they're still using that as the theory that that's the murder weapon. And then to find out that the cops found the blowpoke, the one they were talking about, the actual blowpoke that the Petersons owned, they found it that night, but they hid it. I mean, it was hidden in plain sight, but they put it. The fan's blowing my hair in my face, and sorry, but they put it back in a different place. And then they kept coming at, where's the blowpoke? Where's your blowpoke? What happened to your blowpoke? They knew where it was because they were the ones that put it in the garage. When I found that out last night, I was like, oh my God, I've got to tell them about this tomorrow. I cannot believe this happened. And I feel like an idiot. For years, I have been saying Michael Peterson killed his wife and killed the lady in Germany and now I don't know anymore. I absolutely have no idea right now if he did it or not because of what the documentary showed. Like, I don't know. So, like I said, this is on my list of questions for God when I get to heaven. At the end of the documentary, I was just like, and it wasn't just like one or two things. It was like the whole end part of the documentary was just bam, 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 just like constantly. I was just like, and then still the part where, I don't know if you were here this morning when I was talking about the part where Nancy was saying, why aren't they wearing gloves? That exact part where Nancy said, why aren't they wearing gloves, was in the documentary that they contaminated the evidence because they weren't wearing the gloves. That exact part. I was like, wait till I tell Nancy tomorrow. And Nancy was like, called it. But yeah, man, it's so sad because that's what our justice system is supposed to be, innocent until proven guilty. And in this case, so how are we supposed to know if he did it or not when everybody tried to make him guilty? They tried to make everything fit. And now I don't know. I have no idea. I almost feel sorry for the guy because because he went through hell and he might have been innocent or he might have beat her to death. Man, I'm so glad I did this trial. I know that it's not as popular as Johnny Depp was, but it's been extremely interesting to me. It has been boring in spots, but it has been extremely interesting to me. So, and thank you guys for watching it with me. Today has been much better than the past couple of days, especially with the male escort and his weird attorney that was trying to get his name sealed, and then he announces it in open court. So, okay, guys, I will see you again tomorrow, and we will. I don't know how many days we've got of Deaver. This is true, Judy. This is true. Yeah. So the problem with Deaver is now we know that he's not always telling the truth. So But okay, guys, be kind to people, love your family, and Jesus loves you, and so do I. I'll see you in the morning. Have a great evening. Bye. Tomorrow is Good Friday. It was very Good Friday. It's a sad Friday, but a good Friday.